passport, passport getting to issue the minus. The mother has already booked the ticket for on January 15 week.
Rejected it earlier. It you not paid the money we asked you. So deposit the money, then you move it. And you don't move. Should not be doing this kind of thing. We told you clearly. File the IAV, it will come up in regular course. It will come in the regular course. Surface na Kotal 20, Nam Kotal. Ella. KPID, yes.
ಹೌದಾ ನಮ್ಮ ಹತ್ರನೂ ಬರ್ತಾ ಇಲ್ಲ ಈಗ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಜಾಸ್ತಿ.
There is apprehension that respondent two is trying to divert. It's a large amount of money.
Who is respond number 2? Waqf board itself is going to divert. Good. Yes. They can't divert like that. Yes. I told you. Regular course. Tomorrow. Tomorrow. One nimsha.
96 lords
Just a moment.
withdrawal.
Just a moment. Serial number wise karitare ahoge.
Very well.
Adjournments, list number 1, page number 5, serial number 36 and 37. Page number 6, serial number 38 to 44. Page number 7, serial number 45 to 53. Page number 8, serial number 54 to 59. Page number 9, serial number 60 to 65.
60. Yes. You are for the? You inform the petitioner and the other respondents?
Well, I am appearing for respondent number 5. There is an interim order operating against me.
You have an objection?
Well, on 15th also your lordship gave them time.
If you have an objection, we are not going to adjourn.
Well, it may give them 1 week. Well, it may, however,
The adjournment now will happen only in the second week of December if it gets adjourned.
well, it may.
If you have an objection, we won't adjourn.
Well, it may give a fixed date. Well,
All dates are fixed. Dates are fixed. Who is appearing now for respond number 2 and 3? Piyush Kumar Jain or Samath Kashyap? Shri Piyush Kumar Jain has entered appearance for respond 2 and 3. Delete name of Shri Samath Kashyap as that appearing for respond number 2 and 3. Counsel for respond number 2 and 3 seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 11th, relist on 16th December.
well, it may give time to petitioner to file rejoinder also. Otherwise, they would come in
Then
time.
it will go to January. Rejoinder, if any, to be filed on or before 19th December, relist on second week of January.
13th January.
Interim order earlier granted is extended till next date, 13 January.
My lord, serial number 62, my lord, for the petitioner.
Yes.
In 2 weeks' time.
It's not to DB matters. It pertains to
Please, my
DB
lord.
matter.
Please, my lord, the WB was tagged, however, registry inadvertently has tagged as mentioned it as division bench. my lord. I'll follow up with the registry within 2 weeks and maybe.
The request of counsel for the petitioner January.
13th January.
Obliged.
Page number 10, serial number 66 to 72. Page number 11, serial number 73 to 76.
77 Kardilla, 70. 70? Yes. You're for? Yes, madam. 76, any objection? You want adjournment? Pleadings are complete? 76 at the request of counsel for the petitioner, second week of January on date coding. In the meanwhile, pleadings to be completed.
13th January.
Interim order earlier granted is extended till next date.
Page number 13, serial number 77 to 81.
Inform ಮಾಡಿದ್ದೀರಾ? Will ಅಲ್ಲ, have you informed? You're not informed, don't mention.
96, my lords.
96.
Lords, there are two matters, 96 and 96.1. 96, my lords, I request for a withdrawal, my lords.
96.
24094.
Petitioner is before this court seeking for the following leaves. A memo has been filed.
It is already filed in the counter.
96. Memo has been filed for withdrawal. Accepting the memo, which reads as and accepting the memo, petition is dismissed as withdrawn. Pending IA stand disposed. 96.1.
96.1, my lord, kindly have it on Monday, my lord. Because they are going to, my lord, they pass an order, work order.
Any adjournment today will go to January. If you want to address today, you can address
For
today.
withdrawal.
My lord, only for withdrawal. My lord, if
Withdrawal.
Because he is going to
96.1.
pass an order, sir.
List on Monday
Please.
under the caption withdrawal.
There is an interim order, my lord, against me.
ಯಾವ್ದು?
Interim order
ಯಾವ್ದು?
passed by this in 1996, my lord, serial number 96.
He is withdrawing.
Yes, withdrawn, but there is an interim order operating
That
against
expires.
me.
Once withdrawn, petition is not.
Direction to, because my wages, my lord, have been held up from August.
Once it is withdrawn, would the interim order continue?
It's not going to be continued.
Ashte, what else is there?
Otherwise, they may take some objection.
We don't know what to say now or what to do.
ಇಲ್ಲ
You
ಮಾಡ್ತಾರೆ.
tell us.
They will do it.
Serial number? 31 ಕರೀಲಿಲ್ವಾ? 31
Yes.
petitioner is before this court seeking for the following leaves. A memo has been filed, dismissed as withdrawn.
My lord, seal number 124.
124.
24.
Yes.
Short assignment.
Awaiting service. Awaiting service will take some time. Awaiting service on respond number 2, relist in January.
13th January.
113. Counsel for the petition seeks for and is granted 3 weeks time to comply with office objection. January 2nd week.
13th January.
26. Have you informed the others?
My lord, kindly have it on Monday, my lord. Next week.
Right, this
If you are opposing, we won't adjourn it. If it gets adjourned, it will go to January.
impugned order is challenged by both petitioner as well as respondent.
Are you opposing the adjournment? We won't adjourn it.
But I am
26 will reach shortly. You can take it.
List number 1. Order serial number 1. Yes, Rajendra.
My lord, before we proceed, my lord, just one submission. Counsel for respondent number 4, Ms. Lakshmi Menon. She is undergoing a medical procedure, my lord, today. And so the request is, my lord, if the matter can be had tomorrow at top of the board. The status,
Then you have
whatever,
withdrawn. It's
My
okay.
lord.
The others are here.
my lord, I can't make submissions for, on her behalf.
Let
The
us
only
hear
thing
the
is her
others.
withdrawal in question is,
Let us hear the others. Only for her we can have tomorrow. We don't need to push it tomorrow because tomorrow is CMP day.
There's also a possibility, my lord, that she will be out discharged by around 2, my lord, is what we've been told.
We'll give her time to tomorrow, no issue. We'll hear the rest of the councils.
Yes.
We thought we'll pass an order today itself because it should not delay.
Yes.
But since you are making that submission, we'll have for her submission tomorrow.
Yes, sir.
Let the other submissions happen.
Yes, sir.
But basically, it's only two issues. Who is producing the video and who is producing the?
I have the pen drive also I have downloaded. We have two pen drives. One the entire. I have also downloaded on my laptop if you want. One pen drive.
Let everybody see.
Then I'll give the pen drive. One is my lord.
Call the technician.
In that context, my
That is
lord.
for the entire process. That will go into hours. One we have cut it only so far as the presently
that particular.
In that context, my lord, if I may make one submission, my lord, or rather 2 submissions actually. I may need 5 minutes on that submission, my lord.
We'll give you 10 minutes. We'll take 10
Then I will take 10 minutes, my lord.
He's in a hurry to make a submission. Let him make a submission.
No, they can.
Let it be played and then you can make your submission. Once it gets played, unless there's any doubt, we have expressed. Let us see the video.
As far as, my lord, my submission is twofold, my lord. I haven't watched the video. Nobody here has watched the video, my lord. We've of course been in the.
Going to be, we also have not watched it. All of us can watch it together.
Yes, my lord. My
No
submission
tickets.
is, my lord, as far as.
Lordships have two covers are there. One contains the.
Which cover do you want? Which pen drive do you want?
The cover is the smaller version pertaining only to the concerned petition.
The white cover.
The green cover.
Green cover.
The white cover contains entire thing. It runs into hours and hours. Not necessary.
The green cover.
This is an extract where they have pinned only. There are about 5 or 6 small bits.
Green cover open ಮಾಡಿ.
May. The first submission on this point is, if I may make my submission. The first submission on the point is, it doesn't matter when the payment was made on the day of the scrutiny of the nominations, whether it was made at 9 a.m., 12 p.m., during the scrutiny of the nominations or thereafter. The position of law, my lord, on this is very clear. What matters is that.
You're arguing for whom?
I am for respondent number 3, my lord.
3.
Mr. Venkatesh Prasad.
For Lakshmi Menon.
Mr. Venkatesh Prasad, my lord.
Respondent number 3.
Respondent number 4 is Lakshmi Menon, my lord. She is for Miss Kalpana.
Okay. Yesterday there was some.
KVT was filed by Lakshmi Menon.
Yes, Vishwajit.
Yes, my lord.
You are AS Vishwajit.
Yes, my lord.
Yes.
Now, my lord, my submission is this.
We'll come to your submission. It's a petitioner who has to start. Why are you in such a hurry?
It's in the context of the video, my lord. It's the only.
Let us first play the video.
Yes, my lord.
Why are you in such a hurry?
Because my submission, my lord, is at the point in which maybe the exercise is not
Anybody
required.
running away from here?
No, my lord. I'm not
Nobody.
running away from the video.
We are also here. Don't worry. Let us first play the video. Let us hear the petitioner.
Yes, my lord.
Let us hear the electoral officer who is the important person.
Yes, my lord.
Then we'll come to you.
Yes, my lord.
You want 5 minutes, 10 minutes, we'll give you 10 minutes. Don't worry.
Then I may need longer after they're done, my lord.
Then it may be better that we hurry him first for reducing the time. Illama. ಕರಿಬೇಕಾಗಿತ್ತು ಮುಂಚೆ. Let us first play the video, Ms. Naganan, and then in that context, because it is only limited context.
How can an institutional member become elected? I'm told, my lord, the earlier regulations were that before the Lodha committee, any of these clubs and associations, they are called founder institutional members. Earlier procedure, it seems, was that institution will contest for the post. And if that institution secures majority and becomes elected, institution will then nominate a person to represent it in meeting. That's how the regulation reads.
People will not know who is going to be the.
That is the problem, my lord. What used to happen was some institution will get elected. Some other influential person will say, you nominate me. So though he has nothing to, he will get nominated and he will come and sit. And that is how they reformed it. And after Lodha committee, they said, no, institution cannot contest at all. It is only individual who can contest.
But you are bound by what your institution does. or
Yes,
does not?
Correct. But the
You are not independent of the institution.
Yeah, I'm representing it only. But the distinction is not this rule 3B, it was in the earlier regime. Why they put both these melodies, if a founder life member can contest, I'm not a life member in this case, a founder institutional member can contest. And if that founder institutional member had arrears, then the restriction would apply. But if that clause relating to contest by a founder institutional...
We'll come to that. Let me play the...
Please.
Because those are not matters which we'll be considering here anyway.
Please.
We are only on whether the payment has been made and it was made prior to, because the operative word in the clause is so long as it stays in arrears or something like that.
In fact, I found a constitution bench judgment of the Honorable Supreme Court which deals with exactly this issue and says it's on the date of scrutiny.
We will.
Yes,
I have a response to that also, my lord.
We'll hear you saying the same thing.
Apologies.
Play money. Except the playing of the video. All these issues will...
Now, if I'm not paid in time, this other argument is that I'll present later.
That argument will be only in other proceedings, not this proceedings. Which one do you want us to?
Starting audio.
First one. In ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಮಾಡಬೇಡಿ ಎಲ್ಲ ಕಾಣಿಸುತ್ತೆ ಶೇರ್ ಮಾಡಿ What was this clip about, Mr. Panina?
They enter the Honorable Justice first starts. There are queues. Then the discussion is to get the records about the queues.
So he's gone to get the records.
The CEO informs he get the records.
The person who was standing was the CEO.
Yes, sir. He was
Second.
This is not required.
How they argue.
When was it handed over? Was it handed over or not?
The first bit, my lord, is the only one crucial. Before when it's taken up itself, they ask whether there is arrears.
So was it during the meeting or during the deliberations,
Scrutiny.
during the scrutiny deliberation, was the challan for having receipt or challan for having made payment presented before the scrutiny officer?
But my instructions are the first bit which your lordship saw. When they told, they asked about the arrears and he was informed about the arrears.
Yes, that's it.
So he goes out
Hmm.
and he goes out. Then gets the payment done and comes back. Later, says the payment is done.
Before the
Scrutiny was taken out. So scrutiny itself, he was informed that.
before the completion of the scrutiny, it was paid. It's very,
Actually, my lord, scrutiny is.
Mr. Panditra, that is the crux of the issue.
The scrutiny is, once I take up for scrutiny, at that time, everything should be in order. There's nothing like even, of course, if there are any minor corrections to be done, normal electoral practices, you ask them to make out if it's a minor correction. But my
What
instructions
we
are.
need for you to make a statement is, on instruction, if you want to get the
Yes.
instruction, then make the submission, is whether the receipt was submitted prior to the completion of the scrutiny or after the completion of the scrutiny.
That I'll find.
So that is the crucial part.
Because what I
Timing.
was informed is, I will find out, Manoj. What I was informed is, he was informed about the arrears. So at that point, candidate goes out, it should have got completed. There can't be installments in scrutiny. And later again comes back, then it is these arguments, everything takes place with the receipt having paid the.
So by the time the arguments took place, the receipt was given.
That's what my instruction, I can still.
UPI payment is there, Manoj.
Please get that clarification.
My lords. My lord, I understand.
Very much.
My colleague was in the room, my lord.
My lords, if I may just submit.
1 second.
In fact, I was in the room and I had argued on behalf of Mr. Venkatesh Prasad. The entire video will show that. And the entire video, when we argued, there was no receipt that was produced or argued to be
Asking
produced.
the electoral officers
I bowed
council
down. I bowed down, my lords. It's also
what he
video.
says. Because he is an independent party. We'll go by what the electoral officer says and what the association says. All of you are contestants. Each of you will have your own
Perhaps.
way of putting it across and your own context and your own interpretation. We understand that you can present that. There's no issue about it. But as a question of fact, or as a matter of fact, we'll go by what the electoral officer
Big
would say.
questions what your lordships have asked me, I'll still again call up and find out. But this is what I was instructed, so your lordships wants to know whether the scrutiny continued till 5 o'clock.
Because the argument, the explanation has been sought for that. This is what Mr. Naganan, that is the only reason why we have taken up this matter. Otherwise, we would not have taken up the
Give me
matter.
about 5-10 minutes.
We can have it at 2:30, no issue. If
Perhaps
Come back
3:30,
in-
my lord.
After 2:30, I'm leaving to Hubli. It's a wedding to attend, that's why, not on professional work, so I'll come back in 10 minutes.
you can represent all of us, Mr. Jagdish Patil's daughter's wedding. Yes.
That's it. Otherwise,
Then you'll get back in 5 minutes. We'll hear that constitutional bench judgment that Mr. Naganan is
I am,
speaking
they
of.
have given served a copy of.
Because explicitly now, basically it appears that before the scrutiny was completed,
Completed. I'll find out when it was completed, what is this, which was.
was the receipt given? When it was completed, not relevant. Was the receipt for payment available as on, before the scrutiny was completed? Because the submission is that the situation at the time of scrutiny needs to be taken into consideration. That limited aspect is what we are considering. Non-applicability, interpretation of the provisions, we are not considering any of it, is what we are told yesterday only.
Please.
Yes,
No, I have
Mr.
been served with a memo, my lord, which shows the timelines of the payment. I find that the timeline is at 3 hours and few minutes.
You have
I think KC has filed it. a bit blurred.
Video and ಬೇಕಾಗಿಲ್ಲ ನೀವಿರ್ರಿ
3 hours 30 minutes ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
you stay here.
The timeline which is lordship see in this is 5 hours. My lord. What happened, my lord, was initially they called office bearer wise.
Which memo are you referring to?
Just now I've been served.
Passed it on now.
Suraj Sampath has filed.
He is filed. Okay, this is your memo.
I don't know if the copy given is clear or blurred ಆಗಿದೆಯಾ.
The best copy of it.
Blur ಆಗಿದೆ. ಇದಿದೆಯಾ ನಮ್ಮ ಹತ್ರ ಫೋನಲ್ಲಿ? Somewhere in the middle, my lord. ₹500 credit ondiದೆ.
Yes. What is the time?
That, my lord, time is 3 hours and some 36 minutes.
Where do you get that? Third page.
Second column, November 24th, 2025, page number 3. I've just highlighted that, my lords, on the side. November 24th, 2025, 3.06.
ID number 5446515299.
Correct, my lords. That this is the Yes Bank statement online when the amount is credited is 306. They make an entry of that in their tally statement, which is on page 2. After getting confirmation from the bank, half an hour later at 3:36 PM, they also make an entry in their tally statement, which is at the bottom.
So 306 it was paid.
It was paid. 3:36 is the tally statement.
The proceeding goes on at 5 o'clock. Apparently, what has happened, my lord, is they called office bearer wise. So presidents first they took up the scrutiny, and after they pointed out these people went out, then the next office bearer was called. After finishing 2 more, then they came back.
Scrutiny was between 11 AM to 4 PM. As per the calendar of events.
Yeah, as a calendar of events, but factually, my lord, it started, then they broke up for president, then they took the next office bearer, then they broke up, that took the third one, they called back, like your lordships will pass over or something like that. After some time, they said, you go and come back.
Yes.
And it seems it continued, my lord, till late in the night. By the time they finished this process, it was sometime around nearing midnight. This proceeding was dictated at that time, therefore they didn't give it to us. They said, you come tomorrow and collect.
Only in respect of the president or everything
No,
else?
all of them. All of them.
All this scrutiny went on till midnight.
Now, my lord, I'd like to cite one decision on this question about what is the relevance of the date and time, my lord, for this disqualification.
Same. Yes, please.
Your lordships will, I'll take a lordship straight away to that portion, then come back to the relevant facts. Kindly turn to page number para 61. The printed page in this report is 782, my lord. Conclusion.
Para 61.
61. To sum up, our findings on the questions arising for decision in these appeals are as under. The question of qualification or disqualification of a returned candidate within the meaning of section 101A of the Representation of People's Act 1951 has to be determined by reference to the date of his election, which date as defined in section 67A of the Act shall be the date on which the candidate is declared by the returning officer to be elected. Whether a nomination was improperly accepted shall have to be determined for the purpose of section 101D1 by reference to the date fixed for scrutiny of nomination, the expression occurring in section 36(2)A of the Act. Such dates are the focal point for the purpose of determining whether the candidate is not qualified or disqualified for being chosen to fill the seat in a house. It is by reference to such focal point dates that the question of disqualification under subsection 1, 2, and 3 of section 8 shall have to be determined. The factum of pendency of an appeal against conviction is irrelevant and inconsequential. So also a subsequent decision in appeal or revision setting aside the conviction or sentence or the reduction sentence would not have the effect of wiping out the disqualification which did exist on the focal point dates referred to herein above. The decisive dates are the date of election and the date of scrutiny of nomination, not the date of judgment in an election petition or in an appeal thereagainst. So the disqualification there, one of conviction. So if on the date of scrutiny, if that the bar was not there, that is what is relevant, my lord, is what the lordships have said. Bombay High Court, my lord, has taken an identical view in an election, my lord, of societies, cooperative societies. In this case also, my lord, there was a case of a defaulter, and their provision, my lord, your lordships may see at page 209.
What are the facts in this earlier matter? He was convicted post the scrutiny before the election.
Yes. Prior conviction.
Is that the fact? Or?
Set aside later. Your lordships will get the facts. Paragraph 2. In connection with an incident dated 7/12/91, respondent was facing trial charged with several offences. On 9/7/97, judicial magistrate so-and-so held that respondent guilty of offences, sentenced him to undergo imprisonment as under. Kindly note that date, not 9/4. Then next page, not para 4. The nomination paper filed by the respondent was objected to by the appellant on the ground that respondent, having been convicted and sentenced to imprisonment for a term of 2 years, was disqualified from contesting election. However, the objection was overruled with the returning officer and the nomination of the respondent was accepted. The returning officer formed an opinion that the respondent was convicted for many offences and any of the terms of the imprisonment for which he was sentenced was not 2 years. Therefore, the disqualification in the meaning of section 8(3) was not attracted. On 15/6/2001, appellant filed an election petition under section 2, mainly on the ground that respondent was disqualified. Therefore, neither his nomination was valid nor he has been declared elected. Para 6. On 25/7/2000.
The nomination was accepted. It was challenged on the ground that it improper accepted.
Yes. Appeal at para 6, my lord, the appeal against that was allowed. On 25/7/2001, the Court of Session partly allowed the appeal filed by respondent. The conviction of the accused and sentences passed on him were maintained, subject to modification. Substantive sentences of imprisonment for several offences for which the respondent was found guilty were made to run concurrently.
So it becomes 1 year.
So if you add all of them, it would exceed 2 years. But if they were to run concurrently, no. So it was on the basis
1
of
year, that is the maximum.
based on this appellate order, which came before the scrutiny.
The nomination was filed on 24/4/2001.
Nomination is 24/4/2001.
Poll was held on 10/5/2001.
By that time, my lord, there were these convictions were there. The appeal order is 25/7/2001.
27/5 is post the scrutiny.
On 25/7/2001, my lord, the appellate court made the sentences run concurrently, so that 2 year was not there. So the Honorable Supreme Court held that on the date on which you are to test his disqualification, the 2 year sentence was not there.
"25/7 is post the declaration of results, which was declared
No,
on
25/7, my lord, was the order of the Court of Session.
Yes.
Now, my lord, if your lordship should go back to
Para 1.
Yeah.
Nomination were filed on 24/4/2001.
Yes,
Poll held on 10/5/2001. Result declared on 13/5/2001.
Yeah.
The setting aside yes.
That's why, my lord, in para 61, The question was on the date of scrutiny, what was his position?
He was convicted.
He was convicted. But subsequently, that 2-year conviction was not there because of the appellate order.
Election petition was allowed.
Yeah. So on the date of scrutiny, the position had to be seen.
Two aspects that you have to address on the date of the scrutiny. And
Kindly
can we
see-
take up this issue in this writ petition?
Para 41, my lord. Para 41, page 775.
Yes.
The correct position of law is that nomination of a person disqualified within the meaning of subsection 3 of 8 of the RP Act on the date of scrutiny of nominations under section 36(2)A shall be liable to be rejected as invalid, and the decision of the returning officer cannot be held to be illegal or ignored merely because conviction is set aside or so altered as to go outside the ambit of 8(3). Consequent upon decision. So they sustained the action. Even though later,
Later the sentence was modified, but as on the date of the scrutiny.
So
they are relying on it only for the purpose of the focal point of time and date.
In the Bombay High Court, my lord, is somewhat identical issues arisen. It's 1995, one MLA. Kindly turn to my lord, notice the date here at page 209, that is paragraph number 5, my lord. Or para 4, your lordship will notice the date. The petitioner is a producer member of respondent 3, so and so society, for the purpose of the Cooperative Societies Act. Election for the managing committee were declared on 16/6/94. The last date for filing nomination was 22/6/94. The date fixed for scrutiny was 23/6/94. Then, my lord, at the time of scrutiny, respondent 4 filed objection that the petitioner was a defaulter inasmuch as an amount of rupees 3,427 was due to Karnataka from him. Scrutiny was therefore adjourned under proviso to sub-rule 23(5), specified cooperative so and so. On that day, petitioner tendered, that is on 24/6. The petitioner tendered before the returning officer a challan from ADCC Bank Aurangabad showing the deposit of rupees 3,000 into the account of the respondent Karkana on 24/6/94, that is the adjourned date of scrutiny. The returning officer took a view that the relevant date for determining the disqualification on account of default under section 73 FF of the Maharashtra Act was 16/6. And as the petitioner was a defaulter on that date, though the amount was paid on a subsequent date, he was disqualified for being elected to the managing committee. He therefore rejected the nomination paper. It's exactly our fact situation. Kindly now turn to page 212, one line just above para 12, right on top of the page, second line. Page 212.
212, yes.
Just one line above para 12. The finding of the returning officer that the petitioner was a defaulter and the consequent rejection of the nomination paper was therefore not warranted by law, both must be quashed and set aside. Then, my lord, the discussion, your lordships may please turn to next page 213. It's a continuation of para 14, about 5-6 lines from the bottom. Thus, it will be clear that the point in context of disqualification of a candidate that is to be decided by the returning officer after summary inquiry is whether or not the candidate is disqualified for being chosen to fill the seat by or under the Act. Entire Rule 23 of the Specified Cooperative Societies election rules does not give an indication as to the date on which the person should be found disqualified for filing a nomination paper for the election. That is to say, whether he should be without disqualification on the date on which the nomination paper was filed or on the date on which the decision regarding the scrutiny was taken. And para 17, just above para 17, my lord. The sentence begins like this. It is not that the disqualification spoken of there is not curable at all times. Here also, my lord, the rule says, so long as he is a defaulter. The explanation cannot be construed to mean that a person who was a defaulter, say about 10 to 15 years ago, who has since paid all his dues, could be treated as a defaulter for the elections held 10 to 15 years after the default. if payments are already made by him in the previous years. To conclude, it may be said that the disqualification of being a defaulter is a curable one. If that disqualification is a curable disqualification, there is no reason to suppose that a person who has, with awareness or with unawareness, remained in arrears of the dues of the society till the date on which he filed his nomination, should not be allowed to mend his mistake and do away with the temporary curable disqualification that he has earned. If this is so, there is no reason to suppose the returning officer has to consider the question of disqualification with reference to the date on which the nomination paper was filed, not with reference to the date on which the decision of scrutiny was to be recorded. Then, my lord, they continue. This is the argument. The sentence is a bit confusing, my lord. It says, there is no reason to suppose. That's how the sentence begins. It's put in the negative.
Yes. It's a complex sentence.
Therefore, my lord, my submission is that having regard to the language, there can be not the benefit of doubt ought to be given.
Can we, two questions that we posed was, one is the date, please. Two is the, can we exercise our jurisdiction in a writ petition of this nature? Or is it a matter which will have to go in an election petition later?
On that, my lord, your lordships may see, my lord, the judgment, a very old judgment of this honorable court in DL Suresh Babu. Yesterday, my lord, I handed it over. 1982. My lord, in this case, what happened, my lord, was the writ petitioners were chartered accountants who were contesting for the position, my lord, of member of the council, central council of the institute.
Yes.
Now, their nomination papers were rejected on the ground that they had not correctly described their constituency. The lordships, you see these, there is a date schedules are given there. Paragraph 7, the reason for disqualification is in bold letters, my lord. DL Suresh Babu, on scrutiny of the nominations, it was found that the name of the constituency from which you propose to seek election has not been specified correctly in any of them. There is no constituency southern for the council. Details of the constituency reproduced in the instructions issued to candidates may be referred to in this connection. I therefore regret to inform you, nominations have been rejected. But they didn't put the full description, they only put southern.
It did not say region.
Yes. Then, my lord, at para 19, this was our argument for the respondents in that case, saying, please don't entertain the writ petition. That famous case, my lord, of Pannusamy and other rulings. And in para 20, court's view following Pannusamy was cited. And para 21 onwards, my lord, several other decisions were cited to support our submission. Then, my lord, para 34. An act must be read as a whole and effect must be given to every part of the statute is elementary. As I apprehend, the mandate of explanation 1 of regulation 6710 borrowed from similar provisions found in other election laws of the country directs the panel or the returning officer to ignore technical defects in a nomination paper, reject it only for defects of a substantial character only. But unfortunately, the panel has made a mountain out of a mole and has rejected them on extremely technical considerations, contrary to the specific and clear mandate of explanation of regulation 6710. Without any doubt, the panel, if it had kept before it the said provision, was bound to hold that nomination papers of the petitioners did not suffer from a defect of substantial character and accepted by them, which would have been in accord with the principles enunciated Supreme Court, Karnataka, etc. With all respect to the panel, I am constrained to say that the rejection of the nomination papers of the petitioners was for a plainly absurd and egregious reason, therefore calls for my interference. Then, my lord, the petition is entertained, the petition is allowed, and the directions are at para 42. There also, my lord, in paragraph 40, how the institution made a submission, and though there is no
You
interim.
have based your prayer in this petition on this order.
Though I was party to this
Having
decision.
lost that matter, now you seek to win in this matter on that basis.
This is the law, my lord. After noticing.
Privilege of the council.
When the honorable court, my lord, lays down something, we may argue so many things, but we are all bound by what your lordships will lay down.
Your prayer is more or less identical to what has been laid down.
I had nothing to do with the drafting of this petition. Mr. Rajendra, my lord, is probably said, read this judgment, I don't know.
Yes.
And direction was given, my lord, that it should be done. After all, my lord, today, it's an election process. The argument is that I have other remedies. What is the other remedy, my lord, is go to file a suit. And we know, no, my lord, what is the fate of a suit that is filed now. It is never going to see the end of the day. And another aspect, my lord, is this election itself is being held as per your lordship's directions. Rightly, I would submit, the honorable court intervened in election matter, gave certain directions to say this is how it should be held. These are the parameters. This is your lordships even took the trouble of appointing an election observer. And they're all working in terms of your lordship's order now. Now, if they interpret, my lord, this in such an absurd manner, my submission, my lord, that justice must not only be done.
Vicariously liable.
One other argument is there, my lord. I'll just take 2 minutes and say it and leave it, my lord. The old rules, as I submitted, my lord, said that an institution itself will become the applicant for election. No name is there. So XYZ association will apply for nomination and for the post of an office bearer. Only qualification is that you should have had a certain number of years. So once it elects, gets elected, let us say, ABC institution gets elected. Then that elected body will have to nominate one of its nominees to hold that office, attend the meeting. That was the scheme of the act. The old rules are there, my lord. I'll not trouble a lot. Old rule says all that. No, my lord, after all this change that came about since post the Lodha committee report and the Honorable Supreme Court's orders, they did away with that. No institution can actually be.
We are not deciding any of those things.
Only reason why I'm mentioning this is, my lord, is 3B, as it is worded, it is contemplated that the institution could also apply. Therefore, dues of that institution.
That is not the issue before us, or thankfully so far has not been raised.
One of the contentions.
If it is raised, then we'll probably get back to you. But it may not be raised, is what.
No, I am submitting, my lord, that if you ignore Rule 3B.
The nodding of the heads indicates that.
No, I am saying, my lord, if you ignore Rule 3B because it's not applicable, then you go only to 6A. In 6A, there is no disqualification at all on arrears. 3B.
If there are no arrears as in time at the scrutiny was, we have only two questions here.
Yes, please.
The limited aspect of whether the payment was made before the order by the scrutiny committee had been passed. Because what is there, is that what we have to take into consideration? You have pointed out one judgment subject to what they point out. Two is whether we can exercise jurisdiction in a writ petition at this stage. These are the only two issues that we are looking at. And that will go by the electoral officer as to when was the payment made. As per the receipt, it says 306.
I spoke. The whole sequence, my lords, is initially, my lords, the nomination papers were taken up. That's, my lords, segregation. Then, my lords, it was taken up. President's nomination was taken up. And the issue came up whether there is arrears or not from the. But there are no records produced by the CEO to show the arrears list. So, my lords, that's when the CEO was asked to get the list. That took time. So, the scrutiny was kept aside for the president's post. In order to save time, they went into the vice president's scrutiny. Then, my lords, by the time the records came up and it was taken up, the receipt also was submitted by the candidate, which shows some time, that is after the first appearance and before the scrutiny was actually completed.
Because let them also hear it out and let us also record it properly. Your submission is that at the time when the matter was taken up for scrutiny, the receipt for payment was available.
Second, initially it was taken up.
Because the documents were not there, it was
Not
not
there,
taken up.
because even there was no proof whether he is in arrears or not in arrears.
There were no documents of the club also available
Yes.
to verify.
To verify.
So the club documents were called for. And when the club documents were called off for, that is when the scrutiny process as regard this particular nomination
Then it was deferred
taken up.
until the documents came. The president's, it was taken up, but because there were no documents on the arrears part, so my lords, it was deferred. The CEO was asked to bring the records, and instead of waiting for the records to come and continue with the process of scrutiny for the president's board, it was taking time. So they went into vice president's scrutiny, and this was kept aside. It was not completed.
But when it was taken up,
It was
receipt
the
was
receipt
there.
was produced.
Was there.
It was there. But the order says it should have been on the date of that. I will leave it. I will not.
That is what we will.
That, my lords. But
If the receipt itself was not there, we need not go into any of these.
This is the sequence of events on instructions, my lords. I am submitting. Because the rest we don't want to justify anything.
You cannot
We leave
justify
it.
anything.
That's why, my lords.
Now the club
Except
can
bringing
justify
this.
anything, and we'll have to go by as per the law.
That's
Only these two
they will,
sides
they
can,
will now, my lords.
can say whatever they want to say.
And
Yes.
the video shows all these things happening. So that's the videograph.
No. 10 minutes or more than 10 minutes?
Slightly longer, my lord.
You can take more. This is an important issue for your client, we understand.
Now, my lord, yesterday, my lord, we submitted a compilation of a memo of docs.
Lords, I'll join a little later, my lords.
My lords can see.
You can go with your other work. There's nothing that your statement is only this. So that is clear for everybody.
Yes.
Yes.
Document number 8, my lord, it starts at 151.
Document number 8.
This is a
Number 8
decision,
is
my
a
lord.
judgment.
Yeah, Mangu Singh.
Yes.
Before I get to the judgment, my lord, I'll just lay down the propositions that I'm arguing here. Proposition number 1, my lord, it does not matter whether the payment was made at 3:36 or 3:16, or whether the payment was made in the morning of the scrutiny. What matters is that the disqualification in concern attaches on the date of nomination. And there are a line of judgments that hold that, my lord, including from the Karnataka High Court.
Yes.
Secondly, my lord, as to the issue, assuming it's the date of the scrutiny and not the date of the nomination, even then, my lord, it doesn't matter whether a payment was made again during the course of the day. It matters what was the situation just on that day. And I will show judgments to that effect of this Honorable High Court as well.
Yes.
And the third point, my lord, as my lords had mentioned when Mr. Naganan was arguing on the question of maintainability, the division bench of this High Court has already held. In fact, my lord, yesterday my lords had made a remark that if this was a case relating to acceptance of a nomination and they had challenged the nomination, writ petition would not be maintainable. In fact, the division bench says it doesn't matter whether it's an acceptance or rejection because these are questions of fact, and my lords have already seen. Now we are getting into the question of at what time the payment was made, when was the scrutiny called for, who went into the room, who went out of the room, at what time.
We're not getting into all that.
All these are questions.
The electoral officer has clearly stated that when the scrutiny was taken up,
yes,
it was available.
Yes, my lord.
So now your only issue is, according to you, whether it is the date of the nomination,
yes,
or the date of scrutiny.
Yes, my lord. I will also, if I may be permitted, my lord, at the end make 2-minute submission on maintainability. I'll leave it to my lords after that. Now, as far as Mangu Singh, my lord, my lords can see.
Page number? You're not given the page numbers.
151.
151, my lord. I apologize.
151.
And I will also, my lord, answer all the judgments that Mr. Naganan has produced.
Please.
At 151, my lord, paragraph 5, last paragraph, where it starts with it was pointed out. This was, my lord, specifically a case of arrears. In that, my lord, in paragraph 5, towards the end, my lord, it was pointed out in NP Ponnaswamy was a returning officer that election is a continuous process consisting of several stages and embracing many steps, of which nomination is one. Nomination is the foundation of a candidate's right to go to the polls and must be treated as an integral part of the election. If a person is disqualified on the date of nomination, he cannot be chosen as a candidate because the disqualification mentioned in section 13D attaches to him on that date. Please then, my lord, see paragraph 7. We now turn to the second proviso to section 13D. The submission of the learned counsel for the appellant is that, as stated,
Yes, good.
we now turn to the second proviso to section 13D. The submission of the learned counsel for the appellant is that, as stated in the proviso, the disqualification is transient and ceases to operate as soon as the arrears are paid on October 10, 1953. The appellant was no longer disqualified and therefore he could be chosen as on the date of the poll, that is October 26, 1953. The argument is that in the case of such a transient disqualification, the second proviso must be read as to mean that a disqualification subsisting on the day of nomination can be wiped off completely by subsequent payment of arrears of tax. Otherwise, a disqualification at the time of nomination will disentitle a person to stand for election, even though it ceases to operate before the day of the poll. The argument also we cannot accept as correct. It is really the first argument in a different form. The wiping off of the disqualification under the second proviso has no retrospective effect, and the disqualification which subsisted on the day of filing nominations did not cease to subsist on the day by reason of a subsequent payment of the arrears of municipal tax. On this point, we accept as correct the view expressed in Ahmad Hussain versus Ashwini Kumar, where a similar question under the Bengal Municipal Act fell for consideration. The question was, if a person disqualified on the date of nomination could shake off his pre-existing disqualification by acquiring a new right between the date of nomination and the date of scrutiny. What happened in that case was this: on the material date, that is the last date of submission of nominations, a person was in arrears for more than 3 months in payment of tax, which he was liable to pay, and he came with the mischief of clause G of the amended section 22 of the Bengal Municipal Act. The contention was that the name of the press of which the candidate was the proprietor and not his name was recorded in the books of the municipality as the SSE, and that the name of the candidate was in the electoral rolls by reason of his educational qualifications. This contention was repelled and was observed that if a person was disqualified on the date of the nomination, he could not shake off his pre-existing disqualification by acquiring a new right between the date of nomination and the date of scrutiny. There is also other judicial authority which supports the same view. In Harford versus Linsky, which we produced, my lord, but I won't take my loss to that. A similar question arose for decision under the Municipal Corporations Act 1882, section 12 whereof enacted that a person shall be disqualified for being elected and for being a councillor if, while he is interested in contracts with the corporation. The petitioner in that case admitted that at the time of his nomination, he was interested in contracts with the corporation, but contending that he could and would have got rid of his disqualification before the date fixed for the poll, and was therefore not disqualified for nomination. The question was whether he was so disqualified. Right J, delivering the judgment, the court observed, in the absence of any guide, we think it's safest to hold that in the cases of elections under the Municipal Corporations Act, a person who at the time of nomination is disqualified for election in the manner in which the petitioner was disqualified is disqualified also for nomination. The nomination is for the purpose and essential part of the election, and if there are no competitors, it of itself constitutes the election by virtue of the express words of section 56. A different construction might produce much confusion. On the nomination day, no one could know whether the person nominated will at the poll be effective candidates or not. It is true that in the case put, the disqualification may be removed before the election is completed. But what is the effect if the disqualification continues until the poll begins, or until the middle of the polling day, or until the close of the poll? Will the votes given before the removal of the disqualification be valid? If not, how is the number of them to be ascertained? It seems to us unreasonable to hold that the Act means to leave the matter in such a state of uncertainty, and for these reasons we think that this petitioner was disqualified for nomination of election. The same state of uncertainty and confusion to which a reference has been made in the aforesaid observations will arise if the construction which learned counsel for the appellant has pressed for our acceptance is adopted in the case before us. So, my lord, Mangu Singh, my lord, has not been...
In this case, what was it? The disqualification was removed before scrutiny or before the poll?
Before the poll, my lord.
After scrutiny.
After scrutiny, before the poll.
After scrutiny, before the poll. Because you were disqualified.
The judgment you have...
There's a judgment...
Ms. Nagananda cited a judgment which deals with before scrutiny.
Yes, my lord.
After scrutiny, there's no doubt about it.
Yes, my lord.
And that is not the insistence. In the compilation that you have produced, or otherwise, do you have any judgment, or any of you have any judgment which indicates, contrary to what Ms. Nagananda has relied upon,
yes, my lord,
that even if you were to get over the disqualification prior to the scrutiny, that cannot be considered?
My lord,
Because we are only on that issue.
even on this question of scrutiny, my lord, if I may take my lord directly to the division bench judgment. The other one. New list of authorities. Sign on this. No, no.
Vishwajit, what has been relied upon is a Supreme Court judgment.
Yes, my
A
lord.
constitutional bench judgment. Of
I will
5
distinguish
judges.
that, my lord. The answer to that is straightforward. I will get to that question as well.
It's a 5 judge bench judgment.
Yes, my lord.
Unless you have something contrary to this judgment. We are bound by the Supreme Court judgment.
Yes, my submission is that this judgment will not apply to the facts of this case, and I will come to that.
That you can
Yes,
distinguish.
I will first.
But referring to any other judgment of a lower bench strength
Yes, my lord.
will not help.
I understand, my lord. My submission is that the constitutional bench judgment does not apply in our facts at all, and I'll come to that because there, my lord.
Then you may as well start from there.
Oh, yes, my lord. In that judgment, my lord, there are two things that we have to consider. And this, in fact, was tying into my second limb of argument, my lord, but I will answer this directly. One, my lord, there the question was a conviction or a change of sentencing post-poll. And the issue there was, my lord, conviction or an acquittal, which is not time sensitive as it is in our case, my lord. Now, the question before my lords is, when was the arrears paid? Was it paid at the time of the scrutiny or?
The principle laid down by the constitutional bench is that the decisive dates are the date of election and the date of scrutiny of nomination and not the date of judgment in an election petition or in an appeal thereafter.
Yes, ma'am.
So what the constitutional bench has said is the date of scrutiny of nomination is important.
And my lord, I would just pause there on the words date of scrutiny. That is what is important, my lord. I will show what date of scrutiny means through the other judgments that I produced in the memo that I've just given, my lord. Because my submission is, if the nominations happened on the 24th, if the scrutiny happened, I apologize, the scrutiny happened on the 24th, what we need to look at, even in terms of what the constitutional bench judgment has said, is what was the situation as on when the clock hit 24th, not when the payment was made during the course of the day. And there are judgments to support this honorable court itself in the context of arrears. Please see, my lord.
Yes.
Before I get to our High Court's judgment, my lord, please see the Supreme Court judgment of a full bench judgment, my lord, of 1968.
Page number?
This is page 2, my lord.
Page 2.
Page 2. This was, of course, my lord, in the
Page 2 is the list. Memo for production. Page 2 is
top numbering, my lord.
Top numbering. You have produced something else apart from this?
There are just two judgments, my lord, in that list. Yes, in those two judgments, my lord.
In this, there are some documents, and then from serial number 3 to serial number 13, there are judgments.
No, my lord, not the we just gave, my lord. That's the another list. Yes.
This is filed by Karan Gupta.
Yes, my lord. Same.
Yes.
This, my lord, is a full bench judgment.
This is Pashupati Nath Singh.
Yes, my lord. In the context of this was in the context of whether an oath that he was supposed to take, the candidate was supposed to give, was in time or not. Please see page 2, my lord. The High Court held that the nomination of the petitioner was rightly, paragraph 3, I apologize, paragraph 3.
Yes.
The High Court held that the nomination of the petitioner was rightly rejected by the returning officer on the ground that he was not qualified to be chosen to fill a seat in the state legislature, since he had not made and subscribed the requisite oath or affirmation as enjoined by Clause A of Article 173 of the Constitution, either before scrutiny of nominations or even subsequently on the date of scrutiny. The short question which arises in this appeal is whether it is necessary for a candidate to make and subscribe the requisite oath or affirmation as enjoined by Clause A of Article 173 of the Constitution, before the date fixed for scrutiny of nomination paper. In other words, is a candidate entitled to make and subscribe the requisite oath when objection is taken before the returning officer, or must he have made or subscribed to the requisite oath or affirmation before the scrutiny of nomination commenced? The answer to this question mainly depends on the interpretation of section 36(2) of the Act. It will, however, be necessary to refer to some other sections of the Act in order to fully appreciate. Then, my lords, please turn to paragraph 13 at page 4.
Yes.
Or rather, my lord, if I may just show paragraph 12, which is a contention. Mr. Gokhale, who appears for the petitioner, contends that on objection being taken under section 36(2), that the petitioner had not made and subscribed an oath or affirmation according to the form set out above, he was entitled to make and subscribe the oath or affirmation immediately before the objection was considered by the returning officer, which is exactly what has happened in our case. He says that as soon as the candidate takes the oath or makes or subscribes the oath or affirmation, he would become qualified within the terms of Article 173 of the Constitution. And this qualification would exist on the date fixed for the scrutiny, because the date of scrutiny of nomination paper, in this case Jan 21st, 1967, would not have passed away by the time the oath or affirmation is taken or subscribed. It seems to us that the expression on the date fixed for scrutiny in section 36(2)(a) means on the whole of the day on which the scrutiny of nomination has to take place. In other words, the qualification must exist from the earliest moment of the day of scrutiny. It will be noticed that on this date, the returning officer has to decide the objections, and the objections have to be made by the other candidates after examining the nomination papers and in the light of section 36(2) of the Act and other provisions. On the date of the scrutiny, the other candidate should be in a position to raise all possible objections before the scrutiny of a particular nomination paper starts. In a particular case, an objection may be taken to the form of the oath. The form of the oath may have been modified, or the oath may not have been sworn before the person authorized in this behalf by the Election Commission. It is not necessary under Article 173 that the person authorized by the Election Commission should be the returning officer. 16, my lord. In this connection, it must be borne in mind, and this is critical, my lord. In this connection, it must also be borne in mind that the law disregards, as far as possible, fractions of the day. It would lead to great confusion if it were held that a candidate would be entitled to qualify for being chosen to fill a seat till the very end of the date fixed for scrutiny of nominations. If the learned counsel for the petitioner is right, the candidate could ask the returning officer to wait till 11:55 p.m. on the date fixed for the scrutiny to enable him to take the oath. What has happened here? They call him. First round of scrutiny happens. The case here does not have documents in place. They leave the room. By then, he's gone and made the payment. This judgment, my lord, of the full bench of the Supreme Court squarely answers this question, therefore. And this has been followed by a division bench of this honorable court, my lord. Please see the next page, my lord, page 7. Of course, Mysore High Court, my lord, 1970.
Same high
The first paragraph, same.
Yeah, just a minute.
Name it.
What was the final holding in this?
Final holding, my lord. Appeal fails, my lord.
This was an appeal filed
by the candidate, my lord, whose election he had, who had taken the oath subsequently, who was disqualified.
So the person who submitted his nomination, which was rejected, challenged the election of the returning candidate.
Yes. If my lords may see.
And the High Court held that it was rightly rejected.
Yes, my lord.
So rejection was affirmed by the High Court. But the Supreme Court set aside the High Court order.
High Court, my lord, paragraph 3, the High Court held that the nomination of the petitioner was rightly rejected by the returning officer on the ground that he was not qualified to be chosen to fill a seat in the state legislature.
Yes.
And then, my lord, that is taken in appeal.
So
and in 19,
High Court held that it was rightly rejected.
Yes.
But Supreme Court set aside the High Court judgment,
No,
therefore
my
held
lord.
it to be valid.
No, my lord, paragraph 19. In the result, the appeal fails. May I, if my laws may permit, if I may show the next
Can
chart.
be said, and High Court proceeded on wrong basis. Says High Court proceeded on just on. Let's read this paragraph.
My lord, which paragraphs, my lord?
Para 18.
That is only on a short point that was relied on by the High Court, my lord. That's the only distinction that
Yes, anyway, we'll read the judgment. Next judgment.
This paragraph, page 7, my lord, is the decision of this honorable court, a division bench judgment, my lord, on the aspect of arrears. May I read the first paragraph, my lord? That's the facts. That
Page
will
number?
establish page 7, my lord.
Yes.
My lords have that?
Yes.
The petitioner was one of the candidates for election to the city of Bangalore Municipal Corporation from the 43rd Division. He presented his nomination paper on the 21st November 1970, according to the calendar of events relating to the election. The last date for presentation of nomination papers was the 23rd November 1970, and the date fixed for scrutiny of the nomination papers was the 25th of November 1970. At the scrutiny, M. Obanna Raju, another candidate for election from the same division, raised an objection to the reception of the nomination paper of the petitioner on the ground that the petitioner had not paid the property tax payable to the corporation by him in respect of his property in division number 43. The petitioner produced a receipt for payment of taxes made by him at 3:30 p.m. on the same day, which is 25th November 1970. According to the receipt, payments made was of taxes for the years 68, 69, 69, 70 and 70, 71. Thereupon, the returning officer rejected the nomination paper, recording his decision in that regard as follows. It is clear from the receipt produced by Mr. S. Narayanchari that he had paid on 25/11/1970, and so there were arrears to the corporation on the date he filed the nomination on 23/11/1970. Hence, objection is upheld and the nomination of Sri Narayanchari is rejected. So, exactly on our facts. Now, please see.
That again, this judgment considered it as on the date of nomination.
My lord, if I may just take my lords to the relevant paragraph, because this objection was raised at the time of scrutiny. Please see paragraph 54 at page 20.
Yes.
They rely on Pashupati Nath Singh, my lord, which was the previous judgment I read. 54. Now, on the facts of this case, it is clear that up to 3:30 p.m. on the 25th of November 1970, the petitioner had not paid the property tax in respect of his property payable for the years 1968, 69, 69, 70 and 70, 71.
So, Vishwajit, again, let us remind you, there's a full constitutional bench judgment, says date of scrutiny.
Yes, my lord. So, I am assuming, let's accept that proposition as date of scrutiny. We are bound by the constitution bench.
So, unless there is an interpretation of the Supreme Court on that aspect, that scrutiny would be the starting of the day, as what you tried to contend on that. This judgment is date of nomination, but it won't help.
Pashupati Nath Singh, my lord.
Division bench judgment of the High Court.
Yes, my lord. But Pashupati Nath Singh talks about, let me go back to the constitution bench judgment, my lord. That judgment talks about the date of scrutiny. Now, my submission, my lord, is the date of scrutiny is not through the course of the day of the scrutiny, but what was the situation when the clock hit 12 on the day of scrutiny?
That is the interpretation that you are seeking.
That is what I am submitting, my lord. And in support of that, my lord, the Honorable Full Bench of the Supreme Court has said that it doesn't matter during the course of the day of scrutiny, you give your oath. As long as on that day you were disqualified, even if assuming my argument that nomination is not the correct day.
That is fair, we'll consider that.
Yes, my lord.
This judgment may not.
This judgment, if I may just read the relevant paragraphs, my lord, just to show the application of Pashupati, because there here also arrears were paid on the date of scrutiny.
After this, there is a full bench judgment of the Supreme Court. You can't go back to a High Court judgment.
Yes, my lord. Can
we say, is respect to the Supreme Court, High Court says this? Right.
I'm not saying that.
Why are you?
I'm only pointing out that Pashupati Nath Singh
focus it on the relevant issues.
Yes, ma'am.
If there is a judgment of the Honorable Apex Court of a bench strength of more than 5
yes,
in your support, that's what you can rely on.
Yes,
the boundaries are drawn.
Yes, my lord.
You can't go below that now.
Yeah.
The bar is set.
Yes, my lord. Now,
5-judge bench and below it has to be above. You can't come below that.
Yes, my lord. Now, if I may just lay out my proposition, therefore, if I won't go into the division bench of the Karnataka High Court, my lord. The proposition is this: even assuming that the law is that it is on the date of scrutiny, Here, my lord, Pashupati Nath, because the constitutional bench judgment just says date of scrutiny. It does not talk about time. It does not deal with a situation where that defect could be cured during the course of the day, because obviously conviction or acquittal cannot be cured during the course of the day, my lord.
Yes, that cannot.
So factually, we are on a different terrain altogether. But having said that, if we have
That is why the Supreme Court said curable defect.
yes, my lord. Now, insofar as the question of date of scrutiny is concerned, what is date of scrutiny is answered by Pashupati, my lord. Date of scrutiny is when the clock hits 12. Because very clearly in Pashupati Nath Singh also, my lord, an objection was raised as to the oath. They go take the oath and then come back and say, now I am eligible.
That is because in that matter, the date of scrutiny was fixed as so-and-so date. There's no time fixed.
Yes, my lord.
There's a time fixed from so-and-so to 4 p.m.
Yes, my lord. And
so till 4 p.m. is the scrutiny.
Yes, my lord. The same logic, if I may.
306 is when it was paid.
Yes, my lord. If I may respond to that, my lord. In Pashupati Nath Singh, the day of scrutiny was provided. My lords, in our situation, had given a time period for for scrutiny. If I have to take my submission to this next logical conclusion, my lord, then what is relevant is at the time the scrutiny had started. That is the trigger point of your disqualification.
The scrutiny started. When it started, the receipt was available. That is what the electoral
No,
officer
my lord.
said.
In fact, that was not. They had called them in. They had called them in. They had asked for documents.
But the KCA records were not there.
Yes, my lord.
To even take it up.
Yes.
So it was not taken up. It proceeded to the vice president.
Yes, my lord.
So scrutiny was not taken up about the president.
Yes, my lord.
That is why we asked Mr. Panindra to get clear instructions on that.
Yes, my lord.
And his clear submission, categorical submission is that when it was taken up for scrutiny, the receipt was available.
Yes, my lord. That the same facts are parallel to Pashupati also, my lord. At that time, scrutiny was not completed. Scrutiny was only completed after he came and took the oath.
Yes.
And then afterwards, the officer said, we reject.
That was a situation.
If I may read paragraph 3.
Technical, but you also want to use hyper-technicality to get rid of a candidate in a democratic process. So the court will probably have to lean on enabling election with contest rather than disqualifying somebody on a technical ground. Let us be clear on that. So you being hyper-technical on that, you are entitled to, you have to do that. But we can't be that hyper-technical on those.
My lord, if the bylaws say what they say,
there's a judgment to the contrary.
No, factually, my lord,
The judgment to the contrary, we'll follow it.
Not Pashupati's case, factually, my lord, my learned friend is harping on facts. What happened there was on 25th November was a scrutiny. They noticed that the payment was not made by him on that day. The payment was made.
Adjourned. It was adjourned and next day it was made.
No, 23rd was the date for scrutiny. He paid it on 25th.
25th because he sought for an adjournment to reply to the objection, and when it was taken up, by that time it has been paid. Here is a situation where when it was taken up for scrutiny, the payment has been made.
My lord, if I may read.
Your proposition is fine.
If I may read paragraph 3 of Pashupati, my lord. Pashupati, in fact, my lord, has nothing to do with the areas. It was on the question of oath. So.
That was the other decision.
Yes.
Yes. This is Pashupati is as regard the oath.
Paragraph 3, my lord.
Full bench is full bench is 68. Constitutional bench is 2005. They go by curable defect.
My lord, the submission so far as the constitution.
Jurisprudence on election has
my lord,
changed
the Supreme. I think the curable defect. My lord, I may be wrong, and Mr. Naganan perhaps is. The curable defect point comes in the division bench of the High Court, my lord, not of the Supreme Court. That dealt with acquittal and conviction. There can't be a question of curable defect. Is my.
In that circumstance of acquittal and yes, it can't be cured in one day. We understand that. But if these are curable defects before the scrutiny is completed, like payment, some signature, some document not being produced, some particular aspect which has been raised, should that not be allowed to be cured before scrutiny is completed? Why should somebody be deprived of contesting on a hyper-technicality?
Because the law is overwhelming on the side of, even if it is.
Who has the law? The law we have right now is the full bench, constitutional bench.
Constitutional bench, my lord.
Defect. Any other judgment you show us?
My lord, as far as I understand, and I know I shouldn't be making this kind of a submission, but the constitutional bench doesn't talk about curable defect, my lord. It is the division bench of the Bombay High Court. I may be wrong, because it was a situation of acquittal or conviction. There is no finding on curable
date of the scrutiny. Date of scrutiny.
And to that, my submission is not. So the question of whether it's a curable defect or not is clearly answered by Pashupati, my lord. It's a full bench judgment. Taking of the oath is a curable defect. Even then, my lords had said, as on the date of scrutiny, you did not take the relevant oath, and therefore you are disqualified.
Yes.
So curable defect, my lord, is not something you have to reckon with. The only
It's
thing you have to
not
reckon.
by the
Yes, my lord.
constitutional bench. Yes.
So the only thing, therefore, we have to reckon with is what does date of scrutiny mean?
Yes.
The Honorable Supreme Court in the Constitutional Bench has not laid down what date of scrutiny means. If a date of oath taking is not considered a curable defect, my lord, by the Honorable Supreme Court, in Mangu Singh, the date of payment of arrears is not considered as a curable defect, my lord, then in this situation also you cannot consider the fact that he has paid the amount after the time for scrutiny started, after he was asked to go out of the room to pay, to verify records and then make the payment. That can't be considered, my lord, as a curable defect that can be permitted, my lord. That sets a precedent where then this is essentially overruling Pashupati Singh, in my humble submission.
The constitutional bench has not dealt with curable.
Yes,
the Bombay High Court which dealt with.
The only question that has been dealt with that we are concerned with is date of scrutiny. And date of scrutiny, my lord, as Pashupati Nath Singh clarifies, of course it's a judgment prior, but it clarifies what date of scrutiny is. And date of scrutiny is when the clock hits 12. Because how will I otherwise raise my objection? But for KCA having the records, any other candidate or we would have raised our objection at that point. He gets the chance to get out of the room and go and rectify his defect. And I understand, my lord, as a matter of optics, 200 rupees means is nothing.
That is what is troubling us.
Yes, my lord. But my lord, if I may put it differently, and I know this is not the forum for this, but it's 200 rupees that could not be paid by a presidential candidate. Over a course of 5 years.
It was institution.
It's 50 rupees. It's his institution. 50 rupees every year is 5 years or 4 years of arrears was not paid. So one angle, my lord, is to say it's only 200 rupees. Is also to say a president of the Karnataka State Cricket Association did not manage to pay 50 bucks. So my submission is, if my lords have to look at the constitutional bench judgment, then my lords will have to look at the date of scrutiny. And that date of scrutiny cannot be cured. It has to be done at that time the scrutiny started. My lords have seen the video. They entered the room. At that point, the payment was not made. It was at 2:15 or...
Nobody asked about the payment. They asked for the records of the case.
Correct. And when the scrutiny
started... That issue was not raised.
Yes, my lord. The issue was not raised. But when the scrutiny started, at that point, my lord, admittedly, no one here is saying that payment was made. When the scrutiny started, mid-scrutiny payment was made. There are sufficient judgments to show Pashupati Nath Singh on this point is categorical.
Yes.
Now, my lord, if I may just go back, take the clock back a little bit to the maintainability issue. At the end of the day, my lord, we are arguing essentially on aspects which are fairly factual. Now, my lord, the division bench of this court, my lords, Mr. Naganand, of course, has produced a judgment of a single judge to point out that the writ jurisdiction is maintainable in this kind of a matter. If I may first take my lords to that particular judgment, my lord. Where is it? At paragraph 20, my lord, this is the judgment that Mr. Naganand has produced.
Yes.
Suresh Babu. Paragraph 20. Mudamalappa's case, that being one of the earliest cases, a division bench of this court speaking through Somnath Iyer J, examining the power of the High Court to interfere with the rejection of the nomination paper under the Mysore Village Panchayat
Codes Act and the rules before the completion of elections in the light of principles enunciated by the Supreme Court in Ponnuswamy's case observed thus. The principle that there should be no interruption of an election while it is in progress and that no attack should be made on the validity of any proceeding relating to such election until its completion is, as I understand it, a sound principle of election law which ordinarily justifies the refusal of the exercise of such jurisdiction. But to say that this is not the same thing as saying that even in a case where the impugned order of an election officer is so plainly absurd, or where the order made by him cannot but be regarded as one which it was impossible for him to make under the statutory provisions under which he was functioning, we should nevertheless, even in such a case, decline to exercise our jurisdiction. In cases falling within that exceptional category, it is clear that it will be our plain duty to correct at the earliest stage such egregious errors, which, if the election is allowed to continue unimpeded, would inevitably result in the wasteful expenditure of public time and money. Then please see paragraph 21, my lord. The last thing I'll point to this. In Fakirappa Yellappa Kali's case, Rama Joyce J, in his context of the bar created by sub-article 3 of Article 226 of the Constitution, substituted by the 42nd Amendment of the Constitution, that was then in force, reviewing all the earlier cases of the Supreme Court, and this court ruled that it was open to the court to interfere with the rejection of a nomination in exceptional circumstances. What are the exceptional circumstances? That is the bar. The fact that it is 200 rupees is not.
So what are the exceptional circumstances?
They don't define, my lord. So in this case,
can we say 200?
In this case, my lord, what
exceptional circumstance?
In this case, my lord, what is the exceptional circumstance? There was a typographical error as to where they were standing from. The court considered that to be an exceptional circumstance because everything else was valid.
Southern region.
Yes,
region
that's
was
it.
not mentioned.
That is, my lord, quite plainly, if I may submit, an exceptional circumstance because it's a merely typographical error. Here, the bylaws say pay your arrears and you didn't pay your arrears is not an exceptional circumstance.
Yes.
Now, please see the judgment, my lord, of Jayamuthu, my lord, which is produced in the thicker compilation, my lord.
Yes. Page number.
My lord, this is document 159, page 159, my lord.
Yes.
Paragraph 23, my lord, this is at page 188. Taking up the first contention, at the outset, it is held that there can be no distinction between a case of improper rejection of a nomination of a candidate in an election and improper acceptance of a nomination in the context of filing of a writ petition in order to assail the same, though there is a vital difference between the two. In that, the former case, the aggrieved party cannot participate in the election process, and in the latter case, the aggrieved party would be entitled to participate in the election process. However, on getting the election of successful party whose nomination was illegally accepted being set aside in a properly constituted election petition, the aggrieved party would get the relief. But the point is whether, because of the aforesaid difference, it can be held that in the case of an improper rejection of nomination, a writ petition could be filed by the aggrieved party and not at the instance of an aggrieved party, when it is a case of improper or illegal acceptance of a nomination. We do not think that such distinction could be made for the purpose of Article 226 of the Constitution. In either case, whether it is a case of improper acceptance of nomination or improper rejection of a nomination, the same would require proof of facts which cannot be adjudicated upon in writ petition merely on the basis of affidavit and counter affidavits, as the reasons for improper rejection or improper acceptance of nomination would be for myriad reasons, and merely because in particular case proof of disputed question of fact would not arise, it cannot be held that the writ petition could be maintained. Therefore, when once the election process has commenced, courts ought not to interfere in the election process, and particularly in the High Court under 226 of the Constitution should not interfere with an election process. While saying so, we rely upon an early decision and time-tested precedent of the Honorable Supreme Court in the case of Ponnuswamy, which case arose precisely on the question of improper rejection of nomination of a candidate therein. Though in that case, Article 329B of the Constitution applied, nevertheless, the principles propounded therein would apply with all force to all elections. In Ponnuswamy's case, in fact, he has been followed by the Honorable Supreme Court in Nahu Mal versus Hiramal, which has been a case of election to a municipal board, where it has been held that the election to the office of the president could be challenged only according to the procedure prescribed by the Municipalities Act, that is, by means of an election petition presented in accordance with the provisions of the Act and no other way. Thus, a post-election remedy by way of election petition is, our view, an adequate remedy to give relief to an aggrieved party. An improper rejection or acceptance of the nomination of a candidate is always a ground to assail an election. Even, my lord, if we accept that the video is categorically clear, there are no factual disputes, even then the division bench of this Honorable High Court has said there is no question of an election, of a nomination being rejected, being adjudicated under Article 226, ma'am. The remedy, my lord, is either you file a civil suit or you go before the ombudsman. It is not to come before my lords. And the answer, therefore, is to not also say, because the civil, we know how civil courts work, therefore we can't go to the civil court. Then, my lord, that applies across the board to all disputes. There's no special circumstance here. Be it this an election dispute or any other dispute.
Yes.
That is all, my lord.
My lords, there's only one question that I want to respond, which has fallen from my lords in respect of that constitution bench decision. There are three reasons as to why it is not squarely applicable in addition to what Vishwajit said. The entire judgment deals with what happens in relation to an acquittal in criminal proceedings. When an acquittal is passed, it dates back insofar as a disqualification never existed in the first place. That is not the case when there is an arrear of payment, and if it is cured subsequently, it is still an acknowledged fact that the arrear existed. The second reason, my lords, and it doesn't take away from Mangu Singh, is that the entire judgment is referred to in the context of Section 36 of the Representation of People Act. All judgments that say that it is at the time of scrutiny, not at the time of nomination, is specific to Section 36. If I may just read one portion from that, my lords.
Portion of?
Section 36. It is the context in which the judgment is delivered.
Yes.
Which is why, my lords, we have two bodies. We have one body of law which says that the relevant time is the nomination. And we have one body of law which says it is scrutiny. The Constitution bench is specifically interpreting Section 36.
Yes.
If I may read Section 36, 1 and 2, my lords. On the date fixed for the scrutiny of nominations under Section 30, the candidates, their election agents, one proposer of each candidate, and one other person duly authorized in writing by each candidate, but no other person, may attend at such time and place as the returning officer may appoint, and the returning officer shall give them all reasonable facilities for examining the nomination papers of all candidates, which have been delivered within the time and in the manner laid down in Section 33. Now, my lords, the returning officer shall then examine the nomination papers and shall decide all objections which may be made to any nomination, and may either on such objection or on his own motion, after such summary inquiry, if any, as he thinks necessary, reject any nomination on any of the following grounds. And this is important, my lords, that on the date fixed for the scrutiny of nominations, and the Constitution bench is specifically dealing with Section 36(2) of the Representation of People Act to say that the time of intervention is based on statute. Because the statute says that it is at the time of scrutiny, it is in that context which the judgment is delivered. It does not, my lords, in any way detract from the body of law which says that the relevant point of time is actually the nomination. Now, like Vishwajit said, my lords, even if it is on the day when the scrutiny is taken up, the timing has to be decided by the court. And the submission on that is, my lords, when the scrutiny was in fact taken up, now the electoral officer has said that the payment receipt was available. Whether that payment receipt was brought to the attention of the electoral officer is a completely different question. Now, when the matter was argued, my lords, the electoral officer looks at the CEO of the Karnataka State Cricket Association and asks a question. This is at 5:30, and the video will show that. Is there an arrear? The CEO responds that there is an arrear. And it is that submission which is in fact recorded in the order to say that the CEO has submitted at the time of scrutiny, which is taking place at 5:30, that there is an arrear.
That's a factually incorrect statement.
Correct. That I bow down.
306 is the payment.
That I bow down. The submission only stands on this, and all of these are also in the context of election petitions.
That is the only reason why we are examining this.
I bow down.
Because
the only
the
final
goalpost is changed to nomination. When the payment has been made, and on a hyper-technical approach, can a candidate be disallowed from contesting?
That one thing will have to be
Which in
considered.
time will save 9.
One thing will have to be considered is that there is also another candidate who got disqualified on the exact same ground.
He or she is not before us. We are only consider what is before us.
So the only thing that has to be considered here, my lords, and all of these cases are in the context of election petitions. There is the remedy insofar as writ jurisdiction is concerned, the position of law is fairly clear.
Yes, Mr. Nagan.
Not only two answers, my lord. On writ jurisdiction, my lord. It's entirely in the matter of discretion of the honorable court. In the facts of case.
But the honorable division bench has said that it should not,
No,
even
no,
in improper rejection.
No, what I am submitting, my
Para
lord,
23 of the judgment.
I'm conscious and aware of that decision. What I'm submitting is this, my lord. Whether a petition in the event of an alternate remedy being there, in the event of an election, when election process has commenced, whether the court should intervene or no, there are any number of decisions, starting as I said from Ponuswamy. But the exception to the rule, my lord, is that if it appeals to the conscience of the court that this is something which is completely unjust and unfair, then, my lord, it is not a bar on the jurisdiction of the court. It is that's not alternate remedy is always discretionary, my lord. If in a particular case, if the court comes to the conclusion on the facts now presented before the court, that there was, in fact, it was available. There is now the authority, my lord, is saying yes, there was no arrears on that day, and the decision.
The conscience, we have to be bound by the judgment which has been passed by the higher bench.
No, what I am saying, my lord, is the decision of the division bench, my lord, which holds that in the facts of that case, my lord, your lordships may see the facts of that case, what it was. That is the reason why they said we do not want to interfere.
Facts in that.
Yes. The court, my lord, the single judge had dismissed it on the ground of alternate remedy in regard to an election. At page 170, there's a complaint on ineligibility. And there was questions of fact to be investigated into that. In this case, my lord, my submission is I'm covered by two propositions. One is the rule itself says so long as arrears. And the reasoning is that page 189, my lord. Kindly notice, my lord, what the observations are, that this question will involve a detailed investigation of fact about whether that is disqualified or no. Page 189, my lord, lower half. In either case, whether it is a case of improper acceptance of a nomination or improper rejection of a nomination, the same would require proof of facts which cannot be adjudicated upon in a writ petition, mainly on the basis of affidavit and counter affidavits. Now, my lord, today the election officer has clarified the fact. There is no dispute on fact.
I may just request the next line answers this question. Whether it is factual or not is very categorically held by the division bench to say
there is no question. My lord, the rejection of the nomination was questioned on the ground. The court found that on that question, it's a very disputed question of fact relating to the qualification of that person or that society. Here, there is no such issue. And under those provisions, alternate remedy was available. Now I have no alternate remedy except to go to civil court.
That's an alternate remedy.
But what I'm submitting, my lord, is will that come in the way of the court exercising jurisdiction at 226, especially, my lord, when the election is being ordered and conducted by your lordship's
order? What do you have to say about the full bench decision? Saying as on the date, as beginning of the day, not the fraction of the day.
My lord, my submission is this, my lord. The Bombay High Court had occasion to see that. Then the Pashupati's case, my lord, your lordships have seen the facts, what happened in that case. And the Constitution bench, my lord,
was also curable. It was only taking a oath.
Correct.
Oath was not taken. And unlike the conviction or the acquittal.
No, but
if he had not taken the oath and he took the oath thereafter on scrutiny having commenced, the full bench said, no, sorry, it was not taken.
But the language, my lord, which we now have in this rule, kindly see, my lord, and then we have to ignore the words. In the rule, 3B says, so long as, then what, my lord, would be the understanding? We will have to ignore those words if we accept the argument of the other side. That wording your lordships will get, my lord, it's in the writ petition at page 8, bottom it begins. They could have just stopped there without adding those words. Last 3 lines, my lord, at page 8.
Page 44.
Yes,
Is the
page
actual-
44 is the printed version. Yes. In case a life member whose payment of more than so and so is in arrears and a founder member is in arrears, then such life member or founder member shall not be allowed to attend, contest, or vote at any meeting or be allowed to enjoy the privileges of association as long as they are in arrears. I'm told, my lord, this club follows a practice that at the election, if some member goes to vote and they say some arrears, okay, ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಬಂದ್ಬಿಡಿ ಅಂತ. So that is for voting.
Be the normal way of doing it.
Yes. Now, my lord, here it
It
says,
should not be on that ground.
if the other side's contention is to be accepted, then this last phrase will have to be just erased and ignored. There was no need to state that. If it could just stopped as that. If it was an arrears, not allowed to attend.
Their ground is that if you are also eliminated here, everybody is gone, only one
Or
person
ಒಬ್ರೇ
survives.
ಇರ್ತಾರೆ. That's there.
Uncontested.
That is what it is. So that's what they want.
May
It's an electoral.
Wanting is right.
May I just-
No fault can be found in wanting.
No, I'm not
May I
saying
just
you
respond
should
to this
not
one
want.
contention?
I
with
also
PV,
want
my lord?
so many things, but I don't get it. So, my lord, ultimately it's the justice that ought to prevail, my lord. Apart from technicalities. If they say they rely on technicality, then in none of these decisions which they rely upon, this phrase is there. My lord, as long as it's been interpreted, my lord, as an English language to mean a time duration. The expression as long as means it is a time duration. So when you say is in arrears as long as, and that as long as comes to an end when he is paid, then there is no disability.
May I respond to that one point? My lord?
Anything else?
That's all.
Yes, your response now.
My lord, if I may just read that, because there are words there that are crucial to understand the scope of what this means and the implications of what Mr. Naganan is arguing. Life member, instead, in case of a life member whose any payment of more than rupees 100 is in arrears and a founder institutional member whose subscription or payment of more than rupees 100 is in arrears, such life member or founder institutional member shall not be allowed to attend, contest, or vote at any meeting or be allowed to enjoy privileges of the association as long as they are in arrears. Now, my lord, as long as they are in arrears, they suppose in this candidate's case, the petitioner's case, the interpretation, there's only one interpretation, my lord, in my submission that is possible, which is he can now, given that he's cleared the arrears, attend the AGM where voting has to happen. He can also vote because those are continuous. But contest starts from the time you file your nomination, because if the
Attend stroke contest, if we accept your submission that he can attend, it is stroke contest, then he can contest.
if I'll explain the implication, my lord, of what happens if, as long as arrears is to be read as broadly in the context of a candidate running for an election. Suppose in this case, my lord, he had not paid, scrutiny is rejected, and then on the last day of nomination or the last day of elections, on the day of the poll, he pays. He's technically cleared the arrears. Then is the question: is he allowed to contest?
Is complete and rejection. That's a hypothetical.
The implication
situation.
should apply, my lord, in my
It's a
respectful
hypothetical
submission.
situation.
And sorry, apologies.
That's hypothetical, completely. After scrutiny, if he comes back and says, I want to vote, there's no ballot paper for him to, to contest, there's no ballot paper for him to contest.
My lord, but these have to be tested in hypothetical situations, because the implication tomorrow is what you have to look at. My lords are laying down the law.
Between hypertechnical and equitable.
My lord, equitable. All I have to
All
say
the
is,
arguments here on equity, buttressed by a little bit of law. All arguments here are only on hypertechnicality. There's nothing else.
I don't know, my lord.
6A disqualification. 6A fraud. They are allowed depending on DP. 6A is the one which qualifies election.
in fact, my lord,
Yes, now you have addressed argument. Mr. Navadgi had appeared yesterday. Is he appearing?
no, my lord.
He is not appearing. So you have addressed arguments for respond number
3, my lord.
3. Mr. Orla is addressed for respond number 2. Mr. Panindra for respond number 1. Who did you address your arguments for?
My lord, I am with respondent number 3. I just wanted to respond to the
Additional.
point on the
Okay,
constitution
What
bench.
about Lakshmi Menon?
My lord, she's the, no, my lord, Mr. Navat,
She'll be in the afternoon or tomorrow?
I will have to check, my lord, because she had mentioned her
Will
surgery is
pass
about
over the
4,
matter
5.
or have it for tomorrow? What
My
do
lords
you-
can pass it over. If she's not in a position, my lord, then maybe my lords can.
Or we'll have it tomorrow. Why should?
Top
We'll
of the
have it
board, my
tomorrow.
lord.
Tomorrow, top of the board, let's finish that.
Yes.
Okay. We also thought that, but it is not so. Third, Shri Ken Pandinal and Senior Counsel, who appears for the electoral officer, has produced the videographs as regard the
My lord,
happenings at the scrutiny, during the scrutiny.
I apologize for interrupting, my lord. If it can be passed over,
No, we are only recording this and we'll list it tomorrow.
if it can be passed over, if Ms. Menon has any additional submissions to make, my lord, if she doesn't have to make
We are not
submissions.
dictating, we are only recording what happened today. We are not dictating the order.
No, not order, my lord. I'm saying instead of adjourning it to tomorrow, my lords can have it passed over.
Fair enough. We'll pass it over after we record what happened. Produce the video recording of the happenings of the scrutiny meeting. The said video was played in open court for the benefit of all concerned. On inquiry, Shri K.N. Pandinal and Senior Counsel, after obtaining instructions, categorically makes a submission that at the time when the nomination paper of the petitioner was taken up for scrutiny, the receipt for having paid the arrears was available. His submission is placed on record. It is in the context of the said submission that the hearing of the matter was taken up. Heard Shri S.S. Naganan, learned Senior Counsel appearing for the petitioner, Shri A.S. Vishwajit, learned counsel for respondent number 3. Mr. Ola, anything further you have to say apart from what you said yesterday? Your two submissions are that the list was not ready.
Correct. That's all, my lord. More than that.
They
my
were
lord,
learned
as-
Senior
as-
Counsel appearing for respondent number 2 association had yesterday submitted that the respondent number 2 association had not made a list of defaulters and not made a list of, and as such the question of making it known to all the concerned did not arise. His submission is that respondent number 2 has committed a mistake and a fault. What do you say about that? That's all.
I leave it to the court, my lord. More than that, my lord, because ultimately, my lord, we are
If
the
you had done it,
association.
all these things would not have happened. Finally, it is, you are to blame.
The difficulty is for life members, we send messages, my lord, but for institutional members, we do not.
Fine, you have their mobile number, you have their email ID, everything you should send.
And they were permitted to, my lord, participate in the matches in February 2025. They were not.
This year, my lord.
Anyway.
And they played all league.
Without the fee, we have allowed them to participate in the tournament.
So that is an error on the KCA, not a permission to let him contest.
They paid 5,000 for the tournament, not the 50 rupees for the annual subscription.
And we also placed before your lordship, my lord, that bank statement and
yes.
I mean, that,
Yes,
that's what your lordship wanted us to.
And those two things.
Yes.
His further submission today, by relying on a memo which has been filed, is that the payments of the arrears arrears have been made payment of by the petitioners at 3:06 p.m. on 24th November 2025. Lastly, he submits that even though there was a default on part of the petitioner had been the institution member of which the petitioner is a representative had been permitted to participate in what tournament?
League matches, my lord.
In
Of the
all the
conducted by
league
the-
matches.
I think that's produced also.
What was the election in May now?
The
Nobody objected at that time.
Precisely why I'm not previous round of litigation happened, but to get to that point.
Has been permitted to participate in so and so. Pass over.
It says in the sheet that you've been given, my lord, in the figure 336. That's the tally statement.
336 or 06?
Is the tally statement.
statement.
The bank account hits at 36, my lord.
First one, just show that.
Transaction date 24th November 306:39. We used even the
Lord, the account
magnifying
statement.
glass.
That is the tally statement.
Page 3, the transaction ID is 5465152299, November 25th, 306:29.
306, my lord. Then I get confirmation from the bank. Only then I enter it in my tally system, which is
This is a
336.
UPI payment, you get confirmation immediately. How can you? Wow.
Yes.
All of you are getting hyper technical. So we pass over. Pass over. Yes, to that. Only, yes. Because she will also be affected because of her withdrawal. So if she may say that if probably what she intended to say yesterday and made that submission, but that if we were to allow you, we should have to allow her to withdraw her withdrawal.
She has nothing more to argue.
No, she has some medical emergency. So if she can't come today, tomorrow we'll have it. Cause this today.
Fresh matters, serial number 2, Dinesh Rao.
Yes, Mr. Rao. Hmm. Hmm. You're not running the machine, Alva? Hmm.
Because they had not publicated this order of the state level committee who had already sanctioned. Section G. Section G.
Okay. Hmm.
ದಿನಾಂಕ 30/11/2022 ರಂದು ನಡೆದ 8ನೇ ರಾಜ್ಯಸಭಾ ಮಟ್ಟದ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಸಭಾ ನಡವಳಿಕೆ ಅಜೆಂಡಾ
It's only a delegation. It's only a delegation. Correct.
ಅದನ್ನ ನನಗೆ they communicated on 28/10/2024
Yes.
after my bill was seized.
Hmm.
No, I am not on that. I am on a simple question.
To consider your request.
It is the implement ಮಾಡಿದ ಅಷ್ಟೇ.
Petitioner is before this, learned AG accepts notice for respond number 1 to 4. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the application submitted by the petitioner for installation of additional horizontal saw and 2 peeling machines on 25/6/2015 has not been considered by respond number 2. Despite a delegation having been made in favor of respond number 2 on 28/10/2024 at Annexure G. Whenever any application is made to a state authority for grant or otherwise of a license or permission, it is required for the said application to be considered and necessary orders passed within a reasonable period of time, either accepting or rejecting the request made. Neither having been done in the present case, I pass the following order. Writ petition is allowed, a mandamus is issued directing respondents to respond number 2 to consider the application of the petitioner dated 25/6/2015 at Annexure A and the representation dated 9/10/24 at Annexure F and pass necessary orders within a period of
4 weeks.
30 days from the date of receipt of a copy of this order.
Serial number 3, Abdul Mazid.
Mr. Majid? Yes, please. Freezing of bank account. KPID. ಯಾವತ್ತಿದೆ ಅಮ್ಮ freezing?
9th December.
9th December. KPID, you made a party. Who has frozen the? Yes. Yaar KPID ke?
Viresh Budhiyal.
Shri Viresh Budhiyal is directed to accept notice for respondent. Relist counsel for the petition to furnish 2 sets of the petition along with annexures on said counsel. Relist on 10th December. Connect with birth court, please. Make a note of it. Has it come up before the court earlier or it has still come?
Serial number 4.
How is 7 Rule 11 applicable to a consumer matter? CPC does not apply. It will be taken up on merit. 7 Rule 11 does not apply to a consumer. Now, final orders have been passed. So, if final orders have been passed, then you have to go before the State Commission. What are you challenging here, Mr. Counsel? So you have to go on appeal.
10th December.
7 Rule 11 is not available for you under the Consumer Protection Act. CPC does not apply. If final order has been passed, you go on appeal. You can't come circuitously in a writ petition. We understand, but now a final order has been passed. If it was even the earlier thing, then we would have said the same thing. That could be a ground for you before the State Commission, not before us. You will have to do that. That doesn't mean that you come before us. The petitioner is before this court seeking for the following reliefs. You have an alternate remedy, you'll have to go there. It's a clear and categorical thing. According. That High Court should be the appellate authority for a district forum. Is such an order there? You show us. Yes. Page. (31).
Serial number 3. 9th December.
Now there's a final order passed. That's the discretion which has been recognized. That discretion. In a civil court, not in a consumer forum. It doesn't apply. CPC doesn't apply to a consumer matter. If we apply CPC to consumer matter, then nothing will happen. 6 months will dispose of it. Sorry, Mr. Counsel. Petitioner is before this court seeking for the following reliefs. What is being challenged is a final order passed by the First Additional District Consumer Dispute Redressal Commission, Shantinagar, Bangalore, in consumer complaint number 03 of 2024. The petitioner The learned counsel for the petitioner seeks to assail the same on two grounds. Firstly, on the ground that an application which had been filed under Rule 11 of Order 7 of the Code of Civil Procedure before the said consumer forum was not considered prior to the final order being passed. Secondly, the learned counsel for the petitioner would submit that irrespective of a statutory appeal being available to the state commission, secondly, by relying on the decision of the Honorable Apex Court in Ibrat Faizan versus Omax Buildhome Private Limited 2023-11 SEC 594, his submission is that irrespective of a statutory appeal being available to the state commission, this court could exercise its discretionary power under Article 227 of the Constitution of India. I am unable to agree to both the submission. Insofar as the first submission is concerned, the provision of CPC not being applicable to the consumer proceedings, and it cannot be a ground for the petitioner to contend that an application under Rule 11 of Order 7 of the Code of Civil Procedure was required to be considered prior to the order to be passed by the District Commission. At the most, it could be contended that the contentions in the said application would have to be considered during the final arguments. Now that a final order has been passed by the District Consumer Redressal Forum, the petitioner has an alternative efficacious remedy of an appeal before the State Commission under the Consumer Protection Act, reserving liberty to the petitioner to urge all the grounds urged in the present petition in the said appeal as and when filed. The petition stands dismissed. We are seeing a lot of consumer matters coming up before this court. Every day we are dismissing around 3-4 of them. NCLT are coming up before this court. There are other remedies which are available. Only thing we are not doing is we are not imposing cost on these matters. At some stage, probably we'll have to impose cost because this is not the remedy. We'll have to go there. Petitioner will be entitled to the benefit of Section 14 for the time spent in prosecuting the above matter.
Serial number 5, MR Videmata.
Registry is directed to return any original or certified copy of the documents filed by the petitioner by following due procedure as expeditiously as possible. Yes, madam. Hmm. 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 Have you filed execution proceedings? Have you filed execution proceedings? You should file execution proceedings. And in that matter, you will have to seek for police protection. Then they will give you the police protection. Ade helidare. Petitioner is before land AG accepts notice for response. Petitioner is before this court seeking for the following leaves. The petitioner claims to be the decree holder in OS number 186 of 2022, wherein an order of injunction has been passed. The grievance of the petitioner is that the police are not coming forward to give effect to the said injunction order despite a request having been made by the petitioner. On inquiry as to whether the petitioner has filed any execution proceedings, the counsel for the petition submit that no such proceedings have been filed, reserving liberty to the petitioner to file such execution proceedings and seek for police help in those proceedings. Petition stands disposed. We can't do that. It has to be factually considered by that court and then orders passed.
Serial number 6, Rohit BJ.
Hmm. Hmm. If you are not taking care of them, so are you willing to pay any money for their upkeep and maintenance? Are you going to give them anything now apart from that? They went to the court saying, AC saying that you are not taking care. It is their property, it's not your property. You are claiming under them. Supreme Court has said if there is a government made that you are not taking care of it, whether the clause is there or not, it is fine. Are you willing to take care? Are you willing to take care of your parents? How much are you willing to pay? If you make some submission, we'll issue notice. Otherwise, we won't issue notice. Hmm. Page number? Yes. Yes, and the father gifted it to you. You don't want to take care of your father, then we'll dismiss it now. And AG accepts notice for respondent number 1, notice to respondent number 2 to 8 is deferred for now. Counsel for the petitioner seeks for and is granted a week's time to obtain instruction, make a submission as to what is the amount that the petitioner is willing to make payment of as maintenance for respondent number 2. He is 80 years old. When will you tell us? We'll list on Monday. No interim order, please. No interim order at all. You 80-year-old father, you take care of him, make a deposit. When you come on Monday, come with a demand draft. Then go there. Don't come here.
7.
Let them all come. We'll get some money from them also to the father.
Sachin BS.
Yes.
Number 1, wherein under section 23, release deed executed by respondent number 2 was cancelled, my lord. If my lords were to see annexure D, my lords, it is a agreement to sale, my lord, entered by the petitioner and respondent, my lords.
How are you related to the respondent?
I am her daughter, my lord. Daughter and son-in-law of the respondent number 2, my lords. I have entered into an agreement wherein I have.
There is no sale deed in your favor.
No.
Annexure E is only a receipt.
True, my lords. But in annexure C, there is a release deed after the agreement, my lord. After my payment, the respondent number 2 has executed a release deed in my favor, my lords.
What are the details of your payment? What documents do you have to show that you have paid that money?
My lord, if my lords were to see page number 27, my lords.
Yes.
ದಿನಾಂಕ 31/7/2020.
Cash. There is no sakshigalu, nobody.
There are signatures of the respondent.
Yes, signatures are there always. In all these senior citizen matters, we are saying they are 75, 80, 85, manne ondral 90. Their signatures, you will get it. It's their property, paid cash, no document.
There are also 2 sons, my lords.
Yes.
They are taking.
You are also a daughter.
That is true, my lord.
You want the property but not take care.
I am ready to take care.
How much are you willing to pay?
If my lords.
Navalla nee veli. How much do you think your father is worth to pay?
4,000.
Your father is worth only 4,000 rupees. And AG accepts notice for respondent number 1, issue notice to respondent number 2.
My lord.
Returnable by January. Respondent is restrained from any manner alienating dealing with subject property till the next date of hearing.
Grateful, my lord.
Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically. Only we have restrained them from dealing with. It's not come to you, don't worry.
Grateful.
So by that time, see what you can do.
I'm ready to.
Serial number 8.
My lords, I'm ready to pay 5,000, my lords, because I have already paid.
Let them,
17 for
let
17
them come.
lakh.
If they are agreeable for that,
Yes, my lords,
we'll see.
it is already stated in the order, earlier order also, my lords. That's the,
75 years old.
yes, my lords,
And you want that person to
no, my lords.
medical,
Why? My lords,
Tinnakku agala, medical expenses will be there.
my lords, I am a housewife. That's why, my lords, I am a housewife.
You want the property
Yes, my lords.
belonging to them?
Yes, my lords. Yes, my
Then
lords. I'm
leave the
ready.
property, they will take care of themselves.
It may be 10,000, my lords.
Let us see what they agree for.
Much.
Serial number 8.
8, my lords, senior counsel. Sorry, my lords, I'm unable to keep myself physically
Yes,
present.
Krishnavatji?
Sorry, my lord, I have to appear through VC mode. But annexure A is the impugned order.
You have the privilege of doing so.
No, my lords, normally I come, but today I'm.
No, not necessary. You can always come through VC, not a issue.
Yes.
Yes.
Annexure A, my lord, is an archak. Petitioner is an archak of a temple. He was initially appointed on a temporary basis because there were allegations against the existing archaks. Then, my lords, Tahsildar passed an order reinstating those persons back into the archak post, removing me. Matter went up to the division bench, my lord, and the division bench, my lord, stayed the order reinstating them and my lord, directed the learned single judge to continue with the matter. Page 51, if lordships could kindly see. 50 para 13. We are the appellants. Insofar as the submission of the learned senior counsel for the appellants.
Where are you reading? Page number?
Page 50 para 13.
50.
50
Yes,
paragraph
50.
13.
Yes.
Para 13. Insofar as the submission of the learned senior counsel for the appellants that the Tahsildar has taken steps to implement the orders of annexure A and B, which would virtually amount to reinstatement of respondents 2 to 4 is concerned. Respondent 2 to 4 are the archaks who were removed in my place. It is needless to observe that in view of the orders passed by this court, remitting the writ petition to the learned single judge to dispose of the same in accordance with law by any such orders passed by the Tahsildar shall be kept in abeyance till the disposal of the writ petition. That is what we were allowed to therefore continue. Learned single judge himself disposed of the petition thereafter at page 75. Wherein, my lords, the learned single judge records at para 13 again, commencing from page 74. In view of the impugned order dated 28/10/2004 passed by the respondent number 1 being upheld, the petitioner in WP number so and so was appointed as archak of the temples temporarily in view of the order passed by the deputy commissioner is not entitled to any reliefs in the petition. That is insofar as I am concerned. But kindly look, hence in petition number so and so is dismissed. However, if the respondents 2, 3 and are found ineligible, that is the other archaks in my place, the respondent number 5 commissioner or the deputy commissioner is concerned may consider appointing me, that is petitioner, as the archak of the temple in view of he clearing the Vaishaka Sagama Pravara examination. They were expected to hold an inquiry. Now, pursuant to which inquiry, there was a notice issued to hold an inquiry as to whether they were eligible to be appointed in my place. 83 is the notice issued. 83.
Yes.
83 bottom, at the bottom.
Yes.
The type, yes.
Yes, we have seen that.
Yeah, now, lords, even before this inquiry is completed, the Tahsildar obviously does not have jurisdiction because it was the deputy commissioner. Without, he issued a notice, I replied, he has removed me now. I have replied, given a detailed.
So that benefit which was granted by the division bench ought to continue.
Yes, no, continue till the inquiry is held and those permanent people are eligible.
And AGA accepts notice for respond number 1 to 5. Issue notice to respond number 6. Written KVT. Though a KVT petition has been filed for respond number 6.
He
and
is a
service has been
corporator.
effected, none appears for respond number 6. Considering that the division bench of this court ಯಾವ temple
Venkataramaణ Swami and Lakshminarayana Swami, Alambagiri village, Chintamani.
Venkataramaణ
Swami.
Swami and Anjaneya Swami. Correct. Temple at Alamgiri village, Kasba. It's order dated 29 November 23 in WP number 2093. Had directed an inquiry to consider if respondent therein are invalid, and if so, to appoint the petitioner as the actual said temple. An inquiry having been initiated by the Deputy Commissioner. Before the inquiry is completed, respondent number 5 Tahsildar has impugned order date 28/10/2025, removing the petitioner from the post of Archak, which stands in the teeth of the division bench and the learned single judge. Hence, the order dated 28/10/25 at Annexure A is stayed till the next date of hearing, released in January.
27 Jan. Serial number 9. Sriram Adiga.
Petitioner in this case, my lord.
Yes.
I have challenged the notice issued by the respondent number 1, that is MSME FC, my lord. Basically, the fact of the case is, my lord, the petitioner is the subcontractor, taking the contract from the government and giving it to the third party vendors like respondent number 2. Thereafter, my lord, what have my purchase?
Respondent number 2 is a MSME.
Yes, my lord. He said.
Approach the first respondent.
Yes, my lord. Respondent number 2 approach the
How
first.
can you have any grievance with that?
Grievance is, my lord, kindly see the purchase order annexure C, my lord. The MSMED Act only entertain for, my lord, work contract. They can't interfere for recovery of the any delayed payment. This is the
everything they can.
Yes, my lord. As per the
claim for money.
Yes.
Conciliation, then arbitration.
Yes, my lord. But there is a separation. There is a considered composite contracts that combines both goods and services, which the Act does not intend to cover.
How does it not cover? It covers everything.
It's, my lord.
MSME Act.
My lord, kindly see, my lord. Section 18.
Any claim for money is covered.
Yes, claim for money, they have to file a money recovery suit, not under the MSMED Act, my lord. It's also settled by the several judgments of the Supreme Court.
Recent Supreme Court judgment.
Yes, my lord. And also the
MSME will have precedents over everything.
MSMEs have, my lord, but MSMED Act, they are not bound with the work contracts. Work contract is different.
Say so.
Yes, my lord. Section 18, my lord. For recovery. Recovery of section 17 says, my lord, recovery of amount due for any goods supplied or services rendered by the supplier. The buyer shall be liable to pay the amount with interest thereon as provided under section 16. And also, my lord, section 18 says, reference to the micro small enterprises facilitation council. Clause 1. Notwithstanding anything contained in any other law for the time being force, any part to a dispute may, with regard to any amount due under section 17, make a reference to the MSMEF council. And also, my lord, in the present case, it will not covered under the said act only because, my lord, the award purchase order given by the petitioner is purely work contract, my lord. For work contract, MSMED
it is goods and services.
Yes.
Work contract will come under services.
Work contract, my lord, what as per my purchase order, implementation, man, kindly see that page number 20.
It's both the supply of goods and implementation. It's covered.
No, my
Only
lord.
the goods and services bit. What else is there?
See, this, my lord, my submission is they should go for further proceedings to recover the same. And also, my lord, the invoice which he has raised by the respondent number 2 is completely fake, my lord.
That is to be decided there, not
Yes,
here.
and also, my lord, and also one judgment I have to produce as per the yes,
judgment you want?
It will says, my lord. Kindly see the paragraph number 23. It's also same issue, my lord. Without jurisdiction, MSME council that awarded for recovery of money. And also, my lord, page number 20, paragraph number 23, page number 16 of my judgment. Says, my lord, a similar stance was taken by the Allahabad High Court in Rahul Singh versus Union of India. The court categorically ruled that work contracts fall outside the ambits of the MSMED Act. The case concerned dispute where the MSME suppliers attempt to claim benefits under section 18 of the Act by categorizing work contracts as simply supply transactions. The court rejected this approach, holding that the MSMED Act is designed to govern buyer-seller relationship of goods and services, not compensate work contracts involving both. The Allahabad High Court's decision reinforced the principle that statutory arbitration under the MSMED Act is restricted and cannot extend to every form of commercial arrangement involving MSMEs. The judgment aligned with the earlier Delhi High Court
You
ruling.
said works contract is not.
Yes, my lord. The contention of, yeah, and also that this court allowed them.
Notice to respond number 1 and 2, written out by January, in view of the judgment of the Honorable Apex Court. Hey, Apex Court alla iddu.
Yes, that is a order passed by the Honorable High Court of Orissa. And also that
The Supreme Court has said that everything is before them.
the Supreme Court also stated, my lord, in the several judgment, paragraph number 20, my lord. That's a matter of Con Elevator India Private Limited was a state of Tamil Nadu. Delivered landmark judgment, paragraph number 20, page number 14 of my judgment. Page number 14. Legal character of works contracts. A constitution bench rejected the earlier dominant nature test, which had previously been applied to classify contracts based on their
The issue
predominant
notice to the
purpose.
respondents returnable by January 2nd. In view of the decision of the Honorable High Court of Orissa at Cuttack, dated 29/2025, in WP bracket C number 30966 of 2024, wherein it has been categorically held that a composite works contract cannot be referred to the MSMED. The notice issued by respondent number 1 bearing number so and so dated 8/10/2025 at annexure A is stayed till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated.
Obliged, my lord.
Serial number 10. Sirajuddin Ahmad.
Parole.
Appearing for petitioner, your lordship.
Externment.
No, your lordship,
Yeah.
in this case, the respondent number 2 has issued the external.
We can't hear you.
notice against the
Your
petitioner.
connectivity is very bad. We can't hear you.
Externment note against the petitioner has all.
Go to a proper place with connectivity and log in. We'll take it in the afternoon. Pass over.
Now,
We can't hear him. We can't pass an order without hearing him. Pass over.
Serial number 11.
Lord, this pertains to Janoshadi Kendra. I am passing Janoshadi Kendra.
Janoshadi.
I am passing
Same
the
order.
interim order.
Yes.
Same order in 14, 15,
11,
14,
14,
15,
15,
19,
19,
and 32, man. And 32.
32.
Huh. The name
Till
of
how
the,
many are left?
ಇನ್ನೊಂದು 3-4 ಇವತ್ತು ಬಂತು.
ಇವತ್ತು 3-4 ಆಗ್ತಿದೆ.
The relist on 12/12.
12-12.
The name of the hospital will change in every. I've mentioned it. Man.
You mentioned it.
I've mentioned. Grateful.
You do one thing. You give the case number and the name of the hospital.
ಆ ಇಂಟ್ರಿ ಮಾಡೋ ಹಿಂದೆ ಅದನ್ನೇ ಬರ್ತಿದ್ದೀನಿ.
ಎಲ್ಲಿ ಬರ್ದಿದೆ ತೋರಿಸಿ.
ಹಿಂದ್ಗಡೆ ಎಲ್ಲ ಬರ್ತಿದೆ.
ಆಮೇಲೆ ಅದು. Yes.
I'm grateful.
Serial number 12.
Yes.
3 days earlier, says copy of the
3 days early. ಬಹಳ ದಿನ ಆಯ್ತಲ್ಲ. Quite a bit.
What happened? What has
Senior
happened?
citizen.
ಅವ್ರು ಒಂದ್ ವಾರದ ಮುಂಚೆನೆ ಕಳ್ಸಿದೀವಿ ಸರ್.
Is any possibility of settlement?
Settlement.
Mediation?
ಹೇಳ್ತೇನೆ.
Shall we refer it to mediation?
ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಇದ್ರ ಆಲ್ರೆಡಿ 2 ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅದ್ರ ಮೇಲೆನೆ ತಂದೆ
ಅದನ್ನು ಸಾರ್ಟ್ ಔಟ್ ಆಗುತ್ತೆ.
ತಂದೆ ಮತ್ತು ಸಿಸ್ಟರ್ಸ್ ಡಿಕ್ಲರೇಷನ್ ದಟ್ ದ ಗಿಫ್ಟ್ ಡೀಡ್ ಈಸ್ ನಲ್ ಅಂಡ್ ವೈಡ್, ಪಾರ್ಟಿಷನ್, that it is the old property ಅಂತ ಹೇಳಿ ಅವರೊಂದು ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು.
ಆಮೇಲೆ ಇವರು ಒಂದು ಹಾಕಿದ್ದಾರೆ ಮಗ.
ಹ್ಮ್.
ನಂತರ ಇವರು ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಕೇಳಿದ್ದಾರೆ.
ಹೌದು.
ಆಮೇಲೆ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಹಾಕಿ ಅದರಲ್ಲಿ ವಿದೌಟ್ ದಿ ಗಿಫ್ಟ್ ಡೀಡ್ ಡಸ್ ನಾಟ್ ಕಂಟೈನ್ ಎನಿ ಸಚ್ ಕಂಡೀಷನ್. That is the factor. And the second condition is that
whose property is it?
ಅವ್ರ ಸೈಟ್ ನಾನು ಕಟ್ಸಿದೀನಿ ಆಮೇಲೆ ಮನೆನೇ. ನಾನು ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡು.
ಒಳ್ಳೆ ಆಯ್ತು, ನಿಮ್ಮನ್ನು ಬೆಳೆಸಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲಿ ಬೆಳೆಸಿದ್ದಾರೆ, ನಾನು ತಪ್ಪು ಹೇಳ್ತಾ ಇಲ್ಲ. They are residing in the very same building. The same building address is given.
If you had taken care of your parents' property, it would not have come to this.
After the marriage, one second. After the marriage, there was a problem. Then both the son and the daughter-in-law
accepts notice
went
for
out of
respondent
the
number
house.
1 to 4, Nelmangla City Municipal Council.
Kalyanar.
Shri Kalyanar for respondent number 5. Shri V. Keshavrao Mohite, who has filed caveat for respondent number 6, accepts notice for respondent number 6.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Seeks for a week's time to file a statement of objection.
Till then.
Relist on, no till then.
ಅಲ್ಲ,
Relist
please.
on 10th December.
ಇಲ್ಲ, ಆಲ್ರೆಡಿ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು ಒಂದೇ ದಿನದಲ್ಲಿ they got the property transferred to their name. ಈಗ ನಂತರ ಅವ್ರು ಯಾರಿಗಾದ್ರೂ ಬೇರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಮಲ್ಟಿಪ್ಲಿಸಿಟಿ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗುತ್ತೆ.
Next.
Multiplicity printing ಆಗುತ್ತೆ. Kindly till filing of the objections.
We are not inclined to interfere in any of these matters.
Please see, my lord, there is judgment of the Supreme Court, judgment of division bench
See that
judgment.
after they file their objections.
ಅಲ್ಲಿವರೆಗೂ ಅವ್ರು ಏನು ಮಾಡಬಾರ್ದು, not to alienate, my lord. Till until
ನೀವು ಏನಾದ್ರು ಕೊಡ್ತೀರಾ ದುಡ್ಡು to take care of their maintenance?
Oh,
Till now you have been having only problems with them.
No, once
You have been making all kind of allegation against your parents.
no, not at all. I am not making any allegation. Kindly see, it is not like any other.
Interim order which is sought for is refused.
Please, my lord.
Next. Next.
Appealing for the,
Yes.
appealing for the petitioner worship, permission.
Yes.
Worship, this is a matter where the tender is floated by the respondent department for supply of
Yes.
food materials. 3 times they have floated. In 3 times I have secured financial bid as a successful. Once again, for the 3rd time also, I am heard as a successful bidder. When they are supposed to issue for work order, they say that they will recall.
EGA accepts notice for respondent number 1 to 4. She seeks for and is granted a week's time to obtain instruction, make a submission. Relist on 11th December
The preliminary hearing is
in preliminary hearing.
obliged.
Sorry for the interruption, lord. Better. Next.
Once again, when the interim order is sought for, is rejected. ಅವ್ರು ಕೇಳ್ತಾ ಇರ್ತಾರೆ, ನೀವು ಬರ್ಕೊಂತಾ ಇರ್ತೀರಿ. Next.
Date next. Any
Date
date.
ಕೊಟ್ಟಾಗಿದೆ 11th.
10th. Great.
10th. Serial number 14, 15, adjourn 16, P.N. Vishwanatha.
I sought for writ of mandamus to enter in book 1, my lord, following section 89(4), because I am the purchaser and sale certificate has been issued. And DR has issued a letter to the sub-registrar. Sub-registrar has not carried out the index entry. That is the only grievance, my lord, because I have invested money and I have paid 65 lakhs. And as per section 89.
Have you given any representation?
Yes, my lord.
Where is the representation?
Annex G is the representation along with the sale certificate. Thereafterwards, the matter was sent to the DR, district registrar. The district registrar has issued Annex H along with this. Annex H is the
Stamp duty has been paid?
What?
Stamp duty has been paid?
Everything. Sale certificate, there is no necessity. Only the entry is, my lord, section 89 subclass 4.
Sale certificate, you want to register, you'll get
Not
ownership.
the register, my lord. 89 subclass 4, there will be entry in book 1, my lord.
So you don't want a sale deed?
No, they will enter, that's all, my lord. That
You
is
don't
the-
want a sale deed?
Sale certificate itself is a sale.
And then you have to pay stamp duty as
exemption
a
is there.
conveyance.
Stamp duty exemption is there, my lord. 89 subclass 4 may kindly be seen.
Where is the exemption of stamp duty?
Rule 17, that is the procedure, my lord. Only, I'm seeking only entry, my lord.
If there is a conveyance, if there is a transfer of title and if a record, you have to pay the stamp duty and registration fee.
So that's not the same. I'll place, my lord. I'll
Place it.
I'll
Then you
convince.
place it, we'll consider.
I'll convince.
Then all the banks will be very happy.
No, sales.
So they'll also be issuing sales certificate. All public auction, there's no.
Correct, my
ಇದು
lord.
ಅಂದ್ರೆ
Correct? I'm
That
not on
is-
this. I'll place it.
Yes. Learned AGA accepts notice for respondent number 1 to 3. Learned counsel for the petitioner seeks one is granted a week's time to place on record the relevant rules, relevant statute, rules or judgment indicating that a sales certificate issued in a public auction, there would be no requirement to make payment of stamp duty or registration fee.
Only entry, that's with book one entry, that's all.
Book 1 entry andre sale. Book 1 is what is, will come in the encumbrance certificate.
Next week, Mulad.
ನೀವು ಬುಕ್ 4 ಅಲ್ಲಿ ಬೇಕಂದ್ರೆ ತಗೊಳ್ಳಿ.
We'll ಮಾಡಿದ್ರೆ.
ಬುಕ್ 1 ಬೇಕು ಅಂದ್ರೆ ಬೇರೆ. Book 1 is the title.
Correct.
So you can't get title without paying the stamp duty and registration fee.
Next date.
ಯಾವತ್ತು ಹೇಳಿ? When will you give us that?
7th, December
7th. 7th Sunday.
That I saw that.
8th.
8th.
17. Shakir Abbas.
Challenging the inquiry report of respondent number 2, my lord.
Challenging the?
Inquiry report passed by the respondent number 2 is a assistant secretary of the board and consequence proceedings of the board. On the ground that my lordship that R2 lacks jurisdiction to pass such an to hold an inquiry under order 51 of the Karnataka rules, my lordship. Kindly see
rules.
Wherein he recommends to register disputed property under section 36 of the act. Kindly
Why
see
would he not have power under 51?
51 only says not below the rank of additional chief executive officer to hold the inquiry. But here assistant secretary passes an inquiry report.
Delegation alva.
Also that my lordship, the petitioner is the owner of the property, my lordship.
That is a different issue. That is what will come in the inquiry. That you
Because
can
he
place it
lacks
on-
jurisdiction. There is no delegation there as such. Kindly see section rule 51 of the rules. Manner of inquiry under section 40 of the act. The authorized officer not below the rank of additional chief executive
Rule
officer
51 is
shall,
power to proceed for removal of encroachment.
no, rule 51 of Karnataka of rules, my lordship.
Karnataka of rules 97.
Not 2017.
2017.
2017.
2017 ಇದೆಯಾ? ಇದು ಹಳೇದು. ಈಗ ಹೊಸದು ಅಮೆಂಡ್ಮೆಂಟ್ ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ಲ, ಕೊಟ್ಟಿಲ್ವಾ? Is the inquiry initiated when?
Inquiry initiated after April 2025, my lordship. Because this act is already defunct. It was done in accordance with the old act. That is also one of my contention.
No, inquiry was initiated under the old act or the new act?
Old act.
Then why are you bringing the new act?
No, that is one of my contention. But rule 51 will apply.
Will
This is
apply only for
2017
the
rule.
next proceedings after the new rules come into force, not for the old ones.
No, but 2017 rules will apply to these proceedings.
Where does it say that? That pending proceedings it will apply? Repeal and saving says otherwise.
No, I am saying, my lordship, 2017 rules. As per 2017 rules, inquiry should be conducted by the officer not below the rank of ACU.
Provided such repeal shall not affect the previous operation at corresponding law and subject thereto. So whatever is being done earlier will continue to be done.
That is okay, my lordship. But rule 51, my lordship.
Rule 51 will come in only if after the rules come into force, if an inquiry is initiated.
Inquiry initiated recently. Recently, my lordship.
That's why we asked you, when was the inquiry initiated?
In April 2025.
Where is that order?
Order is at annexure A, my lordship.
This is the report.
Annexure A is the report.
When was the inquiry ordered? What is
Order
the
was
order?
24th July 2025.
24th July is the inquiry report, Mr. Counsel.
Yes, my lordship.
When was the inquiry ordered?
Order date is not, it is not mentioned in the
So
report.
that is the law on that date which will be applicable.
That's okay, my lordship, but it should have been conducted
That's
by.
not okay. When was the inquiry ordered? 22/7/23. So this rule will not apply.
No, Karnataka work rules will apply, my lordship, because.
Not apply, Mr. Counsel. Petitioner is before
My
this
lordship,
court.
one more ground is that, my lordship, I am the owner of the property.
That will be in the inquiry. That is, now that the inquiry report has been submitted, you continue that procedure under 51, 52.
No,
That will
inquiry
have
is
to be done.
enclosed and procedure, it is recommended under, as per annexure B, my lordship. Inquiry is concluded.
Yes.
Inquiry is concluded. Now it is approved by the board as per annexure B. So I am challenging both the orders.
That cannot be challenged here.
My lordship, he lacks jurisdiction.
He
Respondent
has
number two-
jurisdiction is what we are holding now.
Yes.
Petitioner is before this court seeking for the following reliefs. What has been challenged is the inquiry report stroke recommendation dated 24/7/2025 passed by respondent number 2 inquiry officer and assistant secretary admin, Karnataka State Board of Wakaf. The contention of the counsel for the petitioner is that in terms of Rule 51 of the Karnataka Wakaf Rules 2017, it would be the additional chief executive officer, a authorized officer not below the rank of additional chief executive officer who can conduct the inquiry. And in the present matter, the assistant secretary having conducted the inquiry, the same falls foul of Rule 51 of the opposite rules. A peril of the inquiry report indicates that the inquiry was ordered on 22/7/2023, even prior to the, when did this come into force?
It's 2017 rules.
17.
2017 rules.
17.
2017 rules, that's what I meant.
Correct. Then you are correct. Shri P. Usman is directed to accept notice for respondent number 1. Issue notice to respondent number 2 and 3 returnable by January.
27 January.
Inquiry having been ordered on 22/7/2023, the inquiry has been conducted by the assistant secretary, which is contrary to Rule 51 of
Karnataka Work Rules 2017.
the Karnataka Wakaf Rules 2000. When did this come into force? Manne tane?
ಅಲ್ಲ,
Challenge
ಅದು
was
ಬೇರೆ,
recent.
ಅದು ಬೇರೆ, ಅದು ಇನ್ನೂ ರೂಲ್ಸ್ ಬಂದಿಲ್ಲ. 2025 Act ರೂಲ್ಸ್ ಬಂದಿಲ್ಲ.
This has come into force?
This was in 2017 itself.
Where do we get the details of when it came into force?
ಅದು ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
Where the draft is so and so. Shall come into force on the date of the official publication. Yes. Process fee and copies to be furnished by end of day tomorrow.
Stay, my lord.
27
stayed.
January.
Obliged.
18. Siddharth B. Muchandi.
Petitioner. Petitioner Milord is the daughter. Respondent number 2 Milord is the mother. Gift Milord was executed, registered gift deed. Thereafter Milord she files a petition before the respondent number 1 for cancellation of the gift. And by the impugned order Milord, the gift Milord has been ordered to be cancelled. Now the whole thing Milord that says Milord that she has not been maintained, all of that. Milord, we have filed our detailed objections. All Milord, we have spent so much.
Are you willing to take care of her
Yes, Milord, even now,
maintenance?
we have in fact offered her to come Milord to stay with us. Or Milord,
May
to
not
pay-
want to stay
she
with
will,
you.
But even in fact, monetary also.
How much
we
are
have
you willing to pay?
About 30,000 rupees per month.
30,000. Learned AGA accepts notice for respondent number 1, issue notice to respondent number 2, returnable by January.
So 27 January.
The submission of learned counsel for the petitioner is that the petitioner has always been ready and willing to take care of the well-being of respondent number 2, who is a mother.
Please.
In that view of the matter, respondent number 2 is restrained from alienating dealing with changing the character of the property subject matter of the above petition till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated. Please.
Serial number 19, adjourn. 20, Maruti, yes.
Mr. Maruti.
As such, my lord, the direction is there to lodge a FIR. That's all, my lord. How this writ can
Maintainable. None appears for the petition. Learned AGA accepts notice for respondent number 1 to 5. If none were to appear for the petition on the next date of hearing, petition would be liable to be dismissed for non-prosecution. Relist on
20.
10th December.
He's there.
Yes. How is it maintainable?
Sorry, my lord. It has become infractious, my lord. It has become infractious.
Infractious alarm. Learned AGA accept notice for respondent. Petitioner is before this court seeking for the following reliefs. Learned counsel for the petition submit that the above petition has been rendered infractious. Accepting submission, petition is dismissed as infractious.
21,
Yes, Abhinav, IA 1 of 25 is allowed.
Lord, the matter pertains to, my lord, suspension of an archak of Balepet, my lord, Narsim Swami temple. Lord, right from 2015, my lord, there is a dispute about hereditary rights. My lords, may please take, my lord.
Only from 2015.
Yes, my lord, 2015. Annexure C, my lord, page number 26. Till the dispute is decided, my lord, one Dodda Venkata Ramanachar is appointed, my lord, as my lord archak of this temple till the dispute is decided. That my lords will get at page number 26. Annexure C. Dodda Venkata Ramanachar, my lord, is appointed as an in charge Pradhan Archak of the temple.
So, Ibru Sayaka
temporary basis. Temporary basis, my lord, he is appointed. Dodda Venkata Ramanachar.
With two Sayaka.
With two Sayaka Archaks. My lord, I have got nothing to do with Dodda Venkata Ramanachar. Then, my lord, please turn to Annexure D, page 31.
Yes.
At page 35, para 6. My lord, this honorable court, my lord, directs the deputy commissioner to decide this dispute. Page number 35, para 6. This honorable court, my lord, directs the dispute to be decided. Till then, whatever arrangement was there, that is
within 3 weeks.
Yes, my lord. Dodda Venkata Ramanachar, my lord, he will continue to officiate as Pradhan Archak.
Yes.
Then an order is passed against the petitioner's father saying he is not entitled to these rights.
How are you? Who is the petitioner's father? And
Satish, my lord. One Satish. My lord, he is the writ petitioner, my lord, in Annexure D. Annexure D, page number 31.
Yes.
My lord, Satish is my father. He is the writ petitioner. His claim is rejected. Then my lords will kindly see, my lord, that order is challenged. Now please turn to my lord. Annexure G, page number 45. At page number 50, my lord, the rights are to be decided afresh. Is what this honorable court would direct.
Another single bench. Another.
Yes, another single bench, my lord. This is what my lord has been directed.
So you came on record.
My lord, I came on record then. My lord, in the meantime, I am appointed as assistant archak. Please see Annexure E, page 37.
Yes.
On 25th of July 2023, my lord, I am appointed as an assistant
You are
archak
assisting the
on probation.
Dodda Venkatacharya.
Yes, my lord.
Yes.
Then, my lord, please see, my lord, Annexure F, page number 41. There is a theft in the temple. My lord, a confession statement is given by the Paricharak, one B and Kiran, saying that he is responsible. He will make good the loss. My lord, the amount can be deducted from his salary. This is on 7th of June 2023. Now, my lord, what is happening is, my lord, the managing committee then sends a communication with a Annexure J, page 65. My lord, saying that the petitioner who is appointed as assistant archak, he should be dismissed from service because he is treating devotees in a partisan manner. And my lord, he is promoting, my lord, devotees of one particular political committee. Annexure J, page number 65. A detailed representation is given by the chairman of the managing committee to the, my lord, commissioner, saying please dismiss the petitioner. So therefore, the attempt has always been, my lord, to somehow see that I am removed. Then now please take the division bench order, My lord, at annexure H, page number 52, where the learned single judge's order, my lord, is confirmed, but the order granting hereditary rights in favor of the rival claimant or rival group is set aside at page number 62, para 14.
Respondent number 2 is directed to decide.
Yes, my lord, that order which gave them the rights, my lord, is set aside. Then what happens, my lord, is then a notice is given to me. Now please see the suspension order which is issued to me, my lord, annexure V.
What happened to respondent number 2's decision on this?
Well, it is still pending.
Still pending.
Now, my lord, they want to remove me from, my lord, officiating as assistant Archak. Therefore, annexure V, page number 118.
If the decision on it is pending, how can you remove him till then?
I am suspended,
Have
saying
to
that.
take instructions and submit, my lord, in this.
Pass orders on that and then take. Until then, don't suspend him.
Let it be out on Monday, my lord. I'll take instructions and submit.
Learned AGA accepts notice for respondent number 1 to 5. He is called upon to obtain instruction and make a submission as to whether the respondent number 2 has passed any orders post the order dated 8th October 2025
By the division.
WA number 1610 of 2024.
Yes.
Relist on Monday.
Grateful.
Yes, my lord.
IA 1 of 25 is allowed
22.
Fresh matters list. my lord.
in preliminary hearing.
Yes, grateful.
Serial number 22.
Petitioner is a Samiti Millards which has been formed for the awareness Millards itself. On tomorrow Millards, they have organized a awareness program in Tamagundlu Millards. It is
Awareness program.
awareness program Millards. It is going to be of 1,000 people.
What is the awareness that you want to create?
Millards, there is a Rishabhavati V Valley project Millards. The government has now proposed through this V Valley project Millards to the Nelamangala rural area Millards, around 69 ponds would be filled with secondary treated water Millards, which has Millards, which is not purified water, and also it has industrial releases Millards. Against that, they want to conduct an awareness program Millards that is organized for
Why have
tomorrow.
you rejected the request?
In fact, we had sought for some
You said rejected.
Millards, we had sought for bandobast protection Millards. Page number 20, 21, 22.
ಮುಂದಿನ ಕಾಮ ಹಿರಿಯ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳು.
Millards, no.
You have not rejected it.
Millards, tomorrow is the awareness program that is going to be held Millards.
Yes,
However,
but then you go on 24th.
we have been
You can't be going in the last moment to the authorities for permission.
we approached them on 20th of October Millards.
Madam, there are arrangements which are required to be made. If you want police bandobast, police have to be made available from different aspects. They're not available for you whenever you want it. So you should take this permission, then organize. You say tomorrow I'm organizing, get the police and can we remove the police from other?
My representations at page number 20,
Please
21,
meet
22 may kindly be seen.
Meet the next officer to whom you have to give all the details. They'll consider it.
Millards, we have gone. They have gone Millards.
ಯಾವಾಗ ಹೋಗಿದ್ದೀರಾ?
Yesterday and today also they were there.
Find out, madam, pass over.
They were
Find
there.
out if
Kindly pass.
they have gone and given all the details.
They had gone.
Give the details as to who they have met.
I will submit.
If they are satisfied, then they'll pass orders.
Please.
Can't be
Kindly
doing
pass.
this.
Now, we had a conversation with Lakshmi. She said she will be unable to.
We'll have it tomorrow.
And she said that it can be reserved, or orders can be passed.
Let her make a submission. We'll have it tomorrow.
It's on her submission, my lord. She said, she just wants to take some things on record, we can submit, and necessary course of action can be taken place.
And when we come back at 2:30, not now.
My lord, 67th matter may be posted for 8th December. I am traveling out of Bangalore.
67th
matter. It may be posted for 3rd or 8th December.
We'll post it on the date that is available. Have you informed the respondent?
Yes, ma'am. I've informed.
My lord, serial number.
The surface matter.
It is OTS matter. Cancellation of OTS.
67 at the request of counsel for the petitioner released January.
My lord, serial number 55. serial number 127. Respond number 5, undertake to file wakalat.
127.
127.
Yes.
Advice time to.
You'll file wakalat for respond number 5.
Yeah.
So she submit that you'll be filing wakalat number for respond number 5. Registry is direct print his name, one such wakalat number is filed. I-1 of 25 is allowed.
Serial number 55 or.
For the petitioner in that. Inform ಮಾಡಿದೀರಾ petitioner ಗೆ?
Petition ಮಾಡಿಲ್ಲ sir.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
My lord, serial number 55 or.
What is the urgency?
129.
What is the urgency?
Police are harassing Lord to depose before them. Not in a case where one motor vehicle accident has been taken place. Lord, they want
to depose.
They are trying to pressurize the petitioners. Some are given some intel.
You are the witness, you have to depose.
But he has already went to the police station. He has given his statement also, my lord. Still, my lord, they want to fix somebody for which.
Serial number 55 or 55. Due to inconvenience or senior ಗೆ ಸ್ವಲ್ಪ ಇಲ್ಲೇ ಹೆಲ್ತ್ ಇದೆ. Any date may be fixed.
That at the request of counsel for the petitioner January.
Please.
24. You want to file an application. Counsel for the petition. They will come back and see. Yes. 64? What are you mentioning? We are not understanding.
Even the order, your lordship, that respondents are there. So, representative of those respondents, your order has been.
We'll come back and see. Yes. 37. 37. Have you informed the respondent? The request of the counsel for the petitioner?
Lordship, 68, Lordship.
January.
Lord, 68.
Yes.
Adjournment for next week, Lordship.
68. Have you informed the respondent?
The bar council, Lordship.
So bar council doesn't need to be informed.
I will personally go and probably.
Bar council you don't want to inform.
I will inform as a.
First inform them.
Sir, mention ಮಾಡಿದ್ರು sir. ಮಾಡಿದ್ರು.
ಹೌದಾ? ಹೌದಾ?
ಏನಂತ ನೋಡೋಣ
ನೋಡಿ, ಅಡ್ಜೆಂಟ್ಸ್ಗಳಲ್ಲಿ
ಟೈಮ್
ನೋಡೋದಿದ್ ನೋಡಿ.
ನಾವು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿ ರೀಚ್ ಆಗಿಲ್ಲ
ಮಾಡ್ಬೋದು, ಯಾಕಾಗಲ್ಲ? ಅಂದ್ರೆ ದಿನ ಬರ್ತಾರೆ ಕೋರ್ಟ್ಗೆ, ನಂಬರ್ ಎಲ್ಲ ಇಲ್ಲ.
ಪಾಸ್ಪೋರ್ಟ್ ಅದಕ್ಕೆ
ಇಲ್ಲ, ಫಸ್ಟ್ ಧಾರವಾಡ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. 1 hour 4-5 ಇದೆ. 1 hour.
ಕೇಳ್ಬಿಡ್ಬೇಕು, ಆ ಥರ ಏನೋ ಡೈರೆಕ್ಷನ್ ತಗೋಬೋದಾ? ಕೇಳ್ಬಿಡ್ಬೇಕು, ಡೈರೆಕ್ಷನ್ ತಗೋಬೋದಾ? ನೋಟಿಸ್ ಹೋಗ್ತೀವಿ,
ಇವ್ರಿಬ್ರು ಇಲ್ಲಿದಾರಲ್ವಾ, ಇವ್ರನ್ನ ನಾನು ತಗೋಬೇಕಾ ತಗೋಬಾರ್ದು? ಅಂದ್ರೆ ಅವರು ಲೈನ್ ಬರಲ್ವಾ? ಅದೇ ಇಲ್ಲಿದ್ದಾರೆ, ಇಲ್ಲಿದ್ದಾರೆ. ಏನದು ಮೆಮೋ ಅಂದ್ರೆ ಏನದು?
ಅದು ಮೆಮೋ ಅಂತಂದ್ರೆ ಮೇಡಮ್, ಇವಾಗ ಬೆಳಗ್ಗೆ ನೀವು ಮೆಮೋ ಕಾಲ್ ಮಾಡ್ತೀರಾ, ಅದು ಮೇಡಮ್ ಅಷ್ಟೇ. ಅದು ಅವ್ರು ಎಷ್ಟು ಕಾಲ್ ಅಪ್ ಮಾಡಿದ್ರು
Lordship. 108.
ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲಿ.
108 memo of withdrawal dismissed as withdrawn. ಏನಪ್ಪ 100? What is the urgency? How is the charge sheet before us? It had to go before 482 court. If it reaches, we'll take it up. So it will be listed tomorrow.
Lordship, really, serial number 129, my lords. Post.
So you should have come after tomorrow, no?
Lordship.
Yes. Surface in, huh? E-auction under surface A. Not before our court, board report called 20. Allogi, it's not before our court.
Post lunch session, Senior Counsel Mr. Arun Shah had made a submission with regard to serial number 129, my lord.
If it reaches, we'll take it up. It's unlikely to.
Some time slot may be fixed, my lord, because almost 1 week I notice put the police are behind me.
Time slot ಏನಂತ fix ಮಾಡ್ಬೇಕಪ್ಪ?
4 ಗಂಟೆಗೆ ನಾಳೆಗಾದ್ರೂ ಪರವಾಗಿಲ್ಲ.
If it reaches, ಹಂಗಿಲ್ಲ ಇಲ್ಲ.
Please. The coordinate bench has given stay the same crime number, my lord.
If it reaches, we'll take. Everybody wants exceptions. ಇವಾಗ ಅದು 100 ಮಾಡಿದ್ರು, ಇವಾಗ 129. ಹಂಗ್ ತಗೊಳ್ಳೋಣ, ಲಿಸ್ಟ್ ತಗೊಳ್ಳೋಣ. What do? Do we follow a structure or unstructured? Whoever is ready, come. ಆಗಲ್ಲ ಹಂಗೆ. 90?
93, my lords, is a tender matter may be disposed of with the direction to the respondent to
That's all.
consider the appeal.
If your withdrawing is what we'll consider, otherwise when it reaches.
May I make one submission?
Yes.
29, my lord. At serial number 29 in first list, my lord. It could be taken up, my lord, because
29 when it reaches, we'll take it up. It will reach. In then 5 matters are.
Your lordship,
430, they have all the principal.
Take it up.
Your lordship, in list 1, serial number 1, I am advocate on record for Advocate Lakshmi Menon. I have spoken to her and she has informed that she will not be able to appear today or tomorrow. However, with the court's permission, she has requested Advocate Karan and Advocate Vishwajit to make a short submission on her.
We ask them, they'll make the submission. Next.
Dharwad bench matters. Serial number 1, Dayanand Dempati.
My lords,
Harvard bench.
Dharwad.
Yes. Harvard bench.
my lords, I'm appearing respondent to my lords. 1 week time. Next week, my lords. Every time.
And AG. Kodi ಅದು. Where is respond number 2?
My lords, I'm appearing respondent to my lords.
Where is respond number 2?
My lords, Raven.
If you don't report compliance, respond number 2 was to appear through video conferencing today.
Next week, my lords. 1 week time, my lords.
Where is he today? You are not reporting compliance. You are not kept respond number 2 present. Bari 1 week ಅಂತ ಹೇಳಿದ್ರೆ.
Next week, any date.
Next week bailable warrant, non-bailable warrant. Non-bailable warrant will issue. What is this, Mr. Counsel? There's a compliance to be reported and you don't report, and next week antira. Third, SCGP submit that he has neither reported compliance nor is respond number 2 present before this court through video conferencing as directed on 29/10/2025. Hence, issue bailable warrant to respond number 2 for a sum of rupees 20,000 returnable by 10th December.
Serial number 2.
Serial number 2.
Is serial number 2, my lords, is main matter KBCNL matter pending matter is there, my lords. Is there connected, my lords?
Connect
for respondent in this case, my lord.
What is the number?
100,130/25, my lords.
100?
130.
130 of 20?
5, my lords.
25. Connect with so and so. Date value. Respond number 2, process fee kodbekalappa.
Yes, my lords, I will pay, my lords, today, my lord.
If process fee is paid
Yes.
by the counsel for the petitioner, issue emergent notice to respond number 2. Yes.
Much.
List number 2. Serial number 1. P. Anand.
For the respondent.
Third day, ma'am.
Yes.
Lordships, I will only bring to your Lordship's notice about that Abu Bakar's case and I leave it to your Lordships. Wherein it was held that when there are two factions and two reports are submitted, it is not a final decision. The parties are free to go before the civil court. This has been referred to in the other judgment also.
Correct, but the facts which have been recorded at para 2.
Please.
Because the petitioner submitted objection to the application for renewal. It is the respondent which is submitted.
Please.
That is why probably it's got, you were to go to the civil court.
Either of the
Petition was
parties.
required to be allowed.
Please.
If that one fact changes, the petition was required to be allowed and you were to be permitted to go to civil court.
Please.
The order has to be set aside.
Please.
Correct? Huh? Right. Petitioner is before this court seeking for the following reliefs. By way of order dated 21st August 2024, the coordinate bench of this court in WP number 15076 of 2024 had disposed the said petition, reserving the petitioner liberty to agitate their rights before the jurisdictional civil court. On the ground that in terms of the decision of this court in Nanjun-Swamy versus District Registrar, 2010 4 Karnataka Law Journal 350, no adjudication of the claims or counterclaims could be made under section 13 of the Karnataka Cooperative Societies Act 1959. The Societies Registration Act 1960. The above petition has been filed seeking for review of the said order. Shri M.R. Rajgopal, learned senior counsel appearing for the petitioner, would submit that the application for renewal had been submitted by the respondents by the petitioners, and objections had been filed by the respondents, which has been considered and a adjudication done by respondent number 1 after inquiry and the impugned orders had been passed. The perusal of papers indicates that indeed it is the petitioner who had filed the application for renewal and it is the respondents who had filed the objections. It is this error, the perusal of the petition indicates that there is error in the
Para 7 of the petition.
Para 7 of the petition indicates that there is error in the factual representation, where it has been stated that the petitioner had submitted objections to the application for renewal, which is the cause of the order dated 21st August 2024. If the correct facts are taken into consideration and the application for renewal were to be submitted by the petitioner and objections by the respondent, then no adjudication could have been made by respondent number 1 and section 13 of the Karnataka Societies Registration Act 1960. As such, this error having crept into the order would require review at the hands of this court, and as such I pass the following order. Review petition is allowed. The order dated 21st August 2025 stands recalled. The petition courier. The order dated
34/24.
34/2024 passed by the first respondent.
Respondent number 2.
First respondent or respondent number 2?
Respondent number 2.
By respondent number 2 is set aside. Liberty is however reserved to the respondents to approach the appropriate forum seeking for appropriate reliefs.
Writ petition also disposed.
The writ petition stands already disposed again.
Please.
Further hearing, serial number 2. Sridhar Negre.
Please, my lord, I appear for
Phone number 3, my
additional.
lord. I'm filing the written submission.
Nimdaita. The counsel for respondent has today filed.
For
his
number
written
3
submission.
Sorry, my lord.
Respondent number 3 has filed his written submission. Oral arguments have been heard, reserved for judgment.
Please.
Serial number 3, Suraj Sampath.
They had given on citation on the last date.
They wanted to make some mention.
My lords, I'm filing the written submissions, written arguments.
submission.
Written arguments, my lords.
Ms. Kothari wanted to take us through some judgment and she wanted to make
Yes, my
some.
lords, it is, we have submitted one Jane Kaushik judgment.
Hmm.
We have filed a memo also. My lords, if may go through page 112 of the judgment. May I read it out, my lords?
Have you mentioned which para numbers?
Yes, my
in the
lords.
written submission?
Yes, my lords, it's
Nothing
very
more to
mentioned.
say?
No, my lords, it's just focuses on how the Disabilities Act, it is also included for private sectors as well. So that is one point that I would like to highlight
Mr.
from the Jane Kaushik judgment, my lords.
My lords, this
Want to say
entire
anything?
judgment, my lords, may see, kindly see the para 1, my lords. It's not on the Disabilities Act, my lords. It's on the Transgender Persons Protection of Rights Act 2019. In para 1.
My lords, but in fact, the judgment itself says how
Just
this.
don't interrupt when the other person is.
Yes.
You can reply later.
Yes, my lords.
Otherwise it will be a table tennis match.
My apologies, my lord.
What is the judgment? Which judgment?
My lords, they filed a single judgment on 23rd October.
What were the parties?
Jane Kaushik versus Union Amendment.
Yes.
Page 3, my lords, para 1. It has been more than a decade since the Transgender Persons Protection of Rights Act 2019. This is in the context of that act, my lords, first and foremost. Then, my lords, in this judgment, they consider two judgments pertaining to the Disabilities Act. One of which being the Vikas Kumar, my lords, where it was an appointment of a scribe to a government university.
Yes.
The facts there were specifically pertaining to a government job and not to a private job. And then they refer to Jija Ghosh, where it's a private airline. My lords will recall, my lords, that
Both those judgments were cited and they have been.
correct. We have dealt with it. Jija Ghosh, just to refresh my lord's memory, my lords, was a situation where even private airlines are covered by
Yes.
the relevant
Indigo.
civil aviation. No, this was SpiceJet. my lords.
SpiceJet or Indigo?
SpiceJet.
SpiceJet.
Para 9 of that, my lords, they had only filed it earlier. That's at page 63 of their earlier compilation.
Yes.
I'll just read that one short para, my lords. It is claimed that such behavior by the airline's crew is outrageous as it is illegal. SpiceJet staff clearly violated civil aviation requirements dated so and so with regard to carriage by air of persons with disability and or persons with reduced mobility. So here there is a sub legislation or delegated legislation which also binds private airlines. So in that context, there was an order against the private airline. But we have cited, my lords, several.
All that you have argued.
Yes, my lord.
Do you have
So-
to say anything about, do you have
In
anything to
this
say about this judgment?
Yes, my lord. In this judgment, they rely on those two judgments. Vikas Kumar, which pertains to a government scribe, and Jija Ghosh, which pertains to a private airline, which is governed by that statute. Apart from that, this entire act is on the Transgender Persons Act, my lord, which is maybe both are beneficial enactments, but it considers the provisions of that act and talks about reasonable accommodation in the context of that act. And also then awards compensation to a private person who files a writ petition. Here we are, our scope, my lords, is a situation where whether the state commissioner has the power or not under section 80, whether after 5 years she could lodge a complaint, when she had an alternative remedy which prescribed a time limit of 3 months under the Education Act. Karnataka Education Act provides an alternative remedy. She files it after 4.5 years.
All that you have
Yes,
argued.
my lord.
Don't repeat those.
Those are the points which they've not answered. The only point that they would answer is whether a private entity, by going through all of these judgments, is bound by the act or not. The private entities may be bound to have an equal opportunity policy, but not for the state commissioner to pass an order in the nature that has been passed in this matter, is my humble submission. No power to order compensation, to reinstate. He can only give recommendations. The act itself contains, if I don't have an equal opportunity policy, 10,000 is my fine, my lords, under the act.
My lords, one submission I have to make. The judgment of Jane Kaushik, it states that how the fundamental rights are having a horizontal effect, and how they extend their relationship between private individuals and entities as well. So in paragraph number 134, it says that even apart from the Transgender Act, the Indian statutes have long reflected the horizontal application of constitutional principles. So in the Jane Kaushik judgment itself, they say that the horizontal application would apply for other acts as well. And my lords, may I read the relevant paragraphs from the judgment, my lords?
134.
131, my lords. 131 and 134. We have extracted the same in our written arguments.
Then you don't need to read it.
Yes, my lords.
Anything else you want to say on this? So your contention is that though it is under the Transgender Act,
yes,
all beneficial acts have to be read in a similar manner.
Yes, my lords,
And the benefit
and it
has to be
should get a
extended.
horizontal effect, my lords. And also, my lords, regarding the point that the commissioner does not have equal power, I have
That has already been
extracted
answered.
judgments and made our submissions in the written arguments, my lords.
Right, counsel for respondent has filed a
My lord,
written submission, the same is taken on.
so far as state is concerned, filed an affidavit of the commissioner where we have taken a stand that the Disability Act will apply, because considering the object and nature of the grievance and all those things, the act will come into
Will
picture.
apply both to public and private.
Yes, my lord, that is the stand that we have taken. In so far as 80,
You'll have to get them to implement. So far as?
section 80, 81, where the lack of jurisdiction, and that also we have covered, said that they have the power to make rules, regulations, even into the private institution also. That is the stand of the state government.
May I also be given liberty to file written submissions?
You filed your written submissions.
No, only they have filed it today, my lord. I have not.
You had earlier filed it.
They haven't filed it, my lords.
Not filed.
Not filed.
You
No, my
filed.
lords.
We have not filed.
And the last
Compilation,
date,
you filed
They have given a compilation.
You filed compilation. Lord, counsel for respondent number 1 has filed a written submission, the same is taken on record. Counsel for the petitioner seeks fund is granted.
Maybe just after this case election. my lord.
Case
May-
election,
May I seek for 10, 15 days, my lord?
you won't do anything apart from case CFO.
My lord, my learned friends on the other side have kept us busy with this, my lord.
Seeks fund is granted 10 days
10
to
days
file
time.
his written submission. Released on 11th December.
which obliged, my
The
lords.
interim order may kindly be extended.
Interim order earlier granted is extended.
Serial number 4, Vikram Ji.
Now, this is a case where the railways have put up a construction on a public road. And my lord, considering the order that was passed by this honorable court on 21st September 2025, this court wanted to appoint a commissioner to see whether it has been.
We have no objection, my lord.
The issue in the present matter is as regards the construction which has been put up, whether it has been on a public road or
And obstructing a canal.
beside the public road. If it has been put up on the public road, whether it obstructs the natural flow of water in a canal situate thereon. In that view of the matter, the jurisdictional ADLR, both the councils submit that a commissioner could be appointed to verify the facts and make the submission. In that view of the matter, jurisdictional ADLR.
Lord, along with PWD engineer, my lord.
Why PWD?
Because the internal roads, it comes within his jurisdiction. Public Works Department.
He will take assistance of everybody. He has all the documents. ADLR is appointed to carry out, as a commissioner, to carry out a inspection of the property bearing survey number 2/1, Shivapura, Madur Taluk, Mandya district, the road situate abutting thereto, namely Old Koppa Road, connecting the service road or the Madur Koppa main road. Access from the Bangalore-Mysore Old Highway to ascertain if the property to be identified by the petitioner and respondent. The commissioner shall inspect the property, carry out a survey thereof, and prepare a survey sketch commencing from 10:30, which work shall be commenced from 10:30 AM on 9th December 2025, and report to the above effect to be submitted by 15th December, released on 18th December. Petitioner and the respondent. Since the order is passed in the presence of the counsel for the petitioner and the respondent, they would be entitled to participate in the said survey. In the event of they not participating, they will not be entitled to any equities. In the event of participating, they would be required to identify the property to the ADLR. And AGA is directed to bring the above order to the notice. AGA is directed to bring the above order to the notice of the to the jurisdictional ADLR.
Maddur, Milord.
Registry is direct print the name of the AGA in the cause list to enable coordination and filing of the report.
Milord, ADLR Maddur, Milord.
Jurisdictional ADLR.
Jurisdiction.
Serial number 5, Mallikarjun Reddy.
This case, for the respondent, need 1 week's time to file my objections to IM. There is 441 this delay. Within 1 week, I will file objection.
And counsel for respondent seeks fund is granted a week's time to file objections to IA 1 or 25. Objections, if any, to be filed on or before 5th December, released on 10th December.
Serial number 6, Dheeraj SJ.
Yes.
Lords, the gift deed
3 to 5 was served. Yes.
Lords, the gift deed did not contain any condition, specific condition to look after. Lords, the gift deed was executed in the year 2013. They go before the.
Who was the counsel who appeared for respondent number 3 to 5 earlier? They were unrepresented.
The R3, H. Sunil Kumar filed Vakalat.
It's Sunil Kumar.
H.
It's indicated that Shri H. Sunil Kumar has filed Wakalat number for respondent number 3. Registry is direct print his name as such and relist on 9th December.
Great Sunil.
Serial number 7.
Kindly pass over the madam. Senior is on his way.
Pass over.
The
Serial
two
number 8.
WPs are, pleadings are complete. They are filed by
Not
the.
complete?
No, pleadings are complete.
So ready?
I'm ready in those two WPs.
RP?
RP also I'm ready.
Then what are you not
No,
ready?
the counsel for, I think, senior counsel Raghavan appears only in RP. Milord. The other two.
It will all be taken up together.
Yes.
We can't distribute.
Serial number 8, Srihari K.
So Srihari, FIR ಯಾರು ಫೈಲ್ ಮಾಡಬೇಕಾಗಿತ್ತು? Petitioner or respondent? Hi. FIR, you have to place on record. First information report, you have to place on record. Pass over.
Serial number 9,
Maharaj, this relates to birth and death certificate, Maharaj. Now the in view of corporations, now new other 5 corporations have been
January we'll have it.
January.
By that time it will be settled.
By the time, because they are giving instructions.
Pawan Kumar submit that due to the constitution of the Greater Bangalore Authority, the officers are
now they
extremely
are
busy in allocation of the work and as such the compliance could not be reported. He seeks for 6 weeks time. It's January end.
30th January.
obligations.
Serial number 10, Milord. Connected matter is posted on 11/12. 11/12. It was listed before day before yesterday. Recognition, the commissioner is appointed.
List on 11/12, connect with so and so.
Serial number 10, S. Sudarshan.
Ade 11/12.
Passed over matters. List number 1, serial number 1.
Yes, who would be making the submission?
Only with my lord's permission, there are two submissions that she's asked us to make. The first is, my lords, on the potential domino effect which may result in any relief being granted in the writ, because Miss Kalpana, who's respondent number 4,
Withdrawn.
has withdrawn. She had put a nomination for 6 different positions. Now, in the list which has been released of the candidates who are going to contest, the precedence post has been put on hold by this honorable court. Her name has come for institutional member Bangalore. So she is shown to now be the contesting qualified candidate for institutional member Bangalore. If the withdrawal is allowed for the writ petition for the president's post, then that has a domino effect in terms of what the implications will be, because they can
Wants to
contest
the post for president?
that, my lords. I'll have to get instructions.
This is
The
what you have to
idea,
make your submission.
the submission here is she is withdrawn based on a considered call of who the candidate
Morning
is.
we asked you, does she want to withdraw? Yesterday it seemed like she asked for time.
She has
Yesterday
withdrawn
to
on
say
the consideration, my lords, that there is one candidate. Now, what the
council, yesterday when she made a submission, we asked her to verify whether she wants to withdraw or withdrawal. That is the submission which was required to be made today.
My lords, the withdrawal is based on whoever is the list of
You
candidates
don't
that
want
are
to
there.
withdraw your withdrawal. So that is what we'll take it as.
The idea is the decision as to who is withdrawing, when they are withdrawing, if she is withdrawing, is to be made based on the final list of candidates that are there eligible.
We'll just take it that you don't want to withdraw your withdrawal.
If that is so, my lords, that will still have an effect on the fact that she is now
It's
a
a different
candidate.
issue. That we'll deal with.
That's the first submission, my lords. The second submission is vis-a-vis the time of the.
You do not want to withdraw. Yes.
The second submission, my lords, in terms of the scrutiny time, what I've been instructed to say is that when the matter was first called for scrutiny at around 2:30, far before it was recalled at 5:30 or 1 o'clock when it was first called, and that time it was pointed out that there is an arrear. And it is because it was pointed out that there is an arrear when the matter was called, it cannot be said that the scrutiny began only at 5
That
o'clock.
is not something that will go by what the electoral officer says.
That is a submission to be made. I'm under instructions, my lords. I've made these submissions.
Since Ms. Lakshmi Menon is indisposed, she had requested, who did she request?
Karan.
Mr. Karan
Gupta, my lords.
Gupta to make his submission. Mr. Karan Gupta categorically states that respondent number 4 does not wish to withdraw the withdrawal of the nomination made by respondent number 4. Apart from that, he makes a submission.
And the domino effect, my lords.
As regards the effect that we'll deal with, as regards, he makes a submission. Heard, reserved.
My lord, may I make one small submission, my lord?
Yes, Mr. Najanan.
My lord, they are cited one decision of the division bench, your lordship, not I put that to me. I have, my lord, 3 decisions of different division benches spread over different periods of time related to election itself. And what they have clarified, my lord, is it's a matter for discretion of the learned judge every time to see what is the nature of the problem. It's not
Now
that
you'll have to give it to them, they'll have to see it.
No, these are
Reply,
decisions.
This way it will never end.
reply if you're giving citation, it'll be a problem.
No, they have cited one case only for that, my lord. If your lordship permits, I'll give only one decision, my lord. That's all.
Give it to them, copy.
Please. ILR 1991 Karnataka 4421. The relevant paras are 20 to 22. In para 20, the lordship summarized. Which is at page 4450, para 20 mark. This is also an election case only. The argument was that it should not have been interfered with the electoral process. To sum up our conclusions on the questions of law arising for consideration as follows. Under Article 226 of the Constitution, this court has the jurisdiction to interfere with illegality committed in the course of holding election to offices of any authority body which is regulated by statutory provisions, notwithstanding the existence of an alternate remedy by way of filing an election petition, if violation of law is established, in other words, such a writ petition is maintainable. Then Lord, next day elaborate it as a general rule what it is and in what circumstances Lord, the court would entertain it. That's all.
Can I respond, my lord?
Yes.
We see the second point. However, the jurisdiction of this court under Article 226 being an extraordinary one, this court as a general rule will not and should not entertain a petition in matters connected with such elections, even if an illegality is shown to have been committed, if the law provides an effective alternative remedy and the illegality is such in respect of which adequate relief could be granted in an election petition. In other words, the court will not and should not entertain writ petitions lightly, as held by the Supreme Court in the case of Muthuswamy. And point one, my lord, again, points out that the interference is only exceptional circumstance. So unless the establishment is exceptional and there is an illegality or a breach of law, my lords, my humble submission is 226 cannot be exercised.
Finally, it boils down to our discretion.
Yes, at the end of the day, my lord, it is my lord's
discretion. You don't do it, they said you do it. That's all.
There's nothing efficacious that will happen.
Hyper technicality, they are on equity. Reserved.
Much obliged.
The respondent number 2, you are 2, right? Respondent number 2 is restrained from notifying the final list insofar as the respondent number 1. Respondent number 1 is restrained from notifying the final list insofar as the president is concerned, till further orders, which we'll see if we, by Monday we can pass.
As far as fourth respondent is concerned, her name is also forthcoming as far as Bangalore zone is concerned. She's contesting for that, having withdrawn here.
She is contesting?
For Bangalore zone.
She can.
That's the difficulty.
Now anyway, they don't want to withdraw the withdrawal. So that is clear. That's why that is the submission that was required to be made.
Yeah. Subject.
That is not in dispute. Don't cause any more dispute. All because of you, this is. Don't cause any more dispute. That would have been necessary if they were withdrawing the withdrawal. They don't want to withdraw. That's clear. The pen drive, which has been submitted by Learned Counsel for petition number 1, is retained on the file. Respondent number 1 is
by
retained
respondent.
Serial number 10.
Much obliged.
Sirajuddin Ahmad.
Yes.
In this case, the externment notice is issued against the petitioner by the respondent number 2. Out of 7 cases, already 5 cases has been acquitted. And there are 2 pending cases in which already.
Was a show cause notice issued?
In
But
annex.
this is a show cause notice.
Yes, ma'am.
You have to go and reply there. This is a show cause notice.
We have already
He has
replied.
given a reply also, my lord. Through mail, he has given the reply.
That is to be considered.
Then order is not at passed, my lord. That is not produced.
Petitioner learned AG accepts notice for the respondent. Petitioner is before this court seeking for the following reliefs. What is challenged is show cause notice of externment issued by respondent number 2 at annexure A dated 5/11/2025, as regards which the petitioner has already replied by email dated 12th November 2025. Learned AG submit that the said reply would be considered and necessary orders passed in accordance with law. Submission answers the grievance of the petitioner, placing a submission on record, petition stands disposed.
Much of it.
22.
Lord, kindly pass over, my lord. I'm getting answered.
Still pass over.
This assembly, my lord, is being conducted in a private land, not in public.
Yes, but you want police bandobast.
Police bandobast.
Bandobast. In fact, my
If you don't want bandobast, then it is fine.
My present instructions are that they seriously wouldn't want, because they anticipate only a peaceful gathering as such.
If you don't want police bandobast, then we can direct them to give the permission. If you want police bandobast, they'll need to make arrangements. It is for tomorrow.
Without bandobast, we would proceed with the event. It's in a private land as such.
Yes.
It's only a gathering, my lords, where they will be
You are responsible for the gathering. That is what we'll make note of.
Please.
It should not be like RCB.
No, I do understand pursuant to
You are
that.
We'll be making note that you will be responsible.
Please, please, Lord.
Petitioner is before this court seeking for the following reliefs. The petitioner organization intends to conduct a public awareness program called Jalagraha Jana Jagruti
Senior.
on 28/11/2025 near Sri Gangamma Devi Temple, Tyamgundu village, Nelmangla Taluk. In order to lodge a peaceful protest as regard the proposal of the state to fill several tanks in Nelmangla Taluka.
Please, Lord.
In Nelmangla Taluk.
It's a peaceful public awareness program, not even a protest as such.
Peaceful public awareness program.
That is what they say, no? Public awareness.
As regards the alleged deleterious effect of filling up the tanks in Nelmangla Taluk with secondary treated water from sewage treatment plants from the Vrishabhavati river. It is in that background that the petitioner had approached the respondents seeking for permission to hold the said program and for police bandobast. The respondent had, by their endorsement dated 24/11/2025, had called upon the petitioners to furnish details and to contact the superior officer insofar as the police bandobast is concerned. Today, Sri Amar Korea, learned counsel for the petitioner, categorically makes a submission that the petitioner does not require police bandobast. The petitioner will only be conducting an awareness program, and that the petitioners would be responsible, but officers of the petitioner association would be responsible for the proper conduct of the said program.
And it is being conducted in a private land as such. No?
Which is being conducted in a private land. In that view of the matter, when the petitioners have, the office bearers of the petitioners have categorically taken on the responsibility of conducting the said program, and that they would be responsible for any incident untoward or otherwise, I am the considered opinion that for the purpose of running a program, the respondents could be directed to provide necessary permission. It is made clear that there is no order insofar as police bandobast is concerned. In the above background, I pass the following order. Respondents are directed to grant permission to the petitioner to conduct public awareness program in survey number?
Survey number 9.
86/1. Bairashettihalli, Gollalli Post, Nelmangla, Bangalore Rural District, Nelmangla, Bangalore Rural.
It will be survey number 9, my lords, in the private land specifically, though.
You have given 86/1.
Other in the initial application. Now, my lords, specifically the land is survey number 9.
Now, if you are changing it, they'll have to get their they'll have to verify.
This land is a private land in which they are now proposed to conduct.
You are changing the land, they'll have to get instructions.
So kindly observe that either that or survey number 9.
Can't do. If you are changing the location, earlier it was only regarding police bandobast. If you are changing location, they'll have to verify those details.
Also, in that,
And
kindly
change it
observe
now.
either that land or this survey number.
If it is only this, we'll grant Mr. Korea. If it's other, then they'll have to verify.
Please.
It is so and so. Commencing from what time?
Tomorrow,
Time to what time?
11 a.m. to 1 p.m. noon.
On 28/11/2025 from 11 a.m. to 1 p.m.
Please. hand delivery mechanism.
and delivery order.
Placements. Right.
Serial number 23. Venkatesh Sarbati.
ಈ ಕಡೆನಾ ಆ ಕಡೆನಾ? Where are you going? What is the dismissal which has happened?
The request for grant of sanction not is rejected. So I am not
Yes.
the respond number 1, not the competent authority. Annexure A, not is the impugned order. But on the ground, Lord, that there is no explanation in relation to the voice sample analysis. But of course, but this is a case of demand and acceptance of bribe amount, where Lord, during the acceptance,
So
the
what is this order that has been placed on record of SLP?
ಇದರಲ್ಲಿ
571?
ನಮಗೆ ಲೋಕಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. Then I placed the judgment of the division bench of the South
Yes.
Court that there is locus. Then apparently SLP against that order was there.
That SLP has been dispersed.
Yes, ma'am. But I tried to.
So the division bench order stays.
Yes, ma'am. That division bench order stands affirmed. That's the instruction.
So the locus to challenge is.
But by reading of the division bench order, but of course, categorical, in fact, there was a reference made to the division bench by a lordship specifically as to whether Lokayukta will have a locus standi. That has been answered affirmatively, holding that they have.
Yes. So there were two conflicts.
Yes, yes, no. Lordship Justice Nagaprasanna and Lordship Justice Natraj. I think lordships themselves had. No, subsequently, lordship.
Subsequently, we have dealt with
Yes,
it.
lordship. Of course, this one more, he is aware.
But then we adjourned some of the matters because
Yes, yes,
SLP
no,
was
but
pending.
there is one recent development, my friend is aware. Another division bench has now taken a view that Lokayukta will not have jurisdiction in respect of any order passed by the disciplinary authority. I'll just point out that.
Writ appeal ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
Not writ appeal.
Short 1.5
Locus
page
standi
order.
ಬಗ್ಗೆ.
It
It's a
does
short
not
order.
consider. It does not consider, my lord, all the other.
Short or long, it's an order, Mr.
Lord,
Sarvati. You can't say short
Lord,
for that.
Value of
What is of the
presumption, my lord,
division
your
bench is
lordship.
an
No,
order
I am
of
not saying anything, Lord. I am only bringing to lordship. Paragraph 2, Lords. We fail to understand how the Lokayukta can be aggrieved by judgment and order in as much as Lokayukta is not a disciplinary of the respondent. Under the provisions of the Karnataka Lokayukta Act, the Lokayukta is a watchdog and the investigating authority and not the disciplinary. Lokayukta can recommend punishment after the entrustment order is passed to the disciplinary authority for conducting the inquiry against a delinquent officer. But it does not have power to inflict the punishment. But this
Sanction will be different from this.
no, correct, no, but the principle is you act as a watchdog. You do not take the sides. Or in fact, I think Malanet friend only had argued there. Sorry, some other counsel.
Again, there are two conflicting decisions.
Andre, he's aware, Mulats. In fact, I was also there. I think they filed a review petition also.
ಇದ್ರ ಮೇಲೆ ರಿವ್ಯೂ ಹಾಕಿದ್ವಿ.
ಹಾಕಿದ್ದೀರಾ?
What their lordships hold is, subject to what my learned friend says, is you just act as a ombudsman. You don't carry anything to the court, in a single minute, go to the court. If any orders are passed, you accept it as it is. Something like that. That was it.
You do your investigation. That's
Yes, yes, whatever is.
Once the report is
if an
submitted.
authority takes a view, one way or the other, then you accept. Of course, now.
That was a single judge's opinion.
Correct. I always felt, and subject to what now the division bench is there. But investigating agencies, according to me, forget whether it's Lokayukta or ACB or a state police, must only investigate and leave it at once. It is the prosecution wing.
Oh, division bench judgment is.
No, I am not. Therefore, this principle, is what is ingrained here. Of course,
the SLP was dismissed at the admission stage.
That's correct.
Doctrine of merger will not apply. So
there is one judgment of Madhya Pradesh High Court which took this view
Honorable Supreme Court, of course, not there dismissed. That's saying that the Lokayukta fund.
Then we have to wait till the review petition is heard. We can't do.
ಆಯ್ತು ನನಗೆ
No, my learned friend must also clarify whether these questions had arisen there.
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಬಂದಿಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿರೋ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ದಟ್ ಈಸ್ ದಿ SLP dismissal. And what Leonard Senior, not my senior, is saying of Madhya Pradesh High Court judgment, that is also considered in Justice Anushiravan's bench, division bench judgment.
Oh, that went up to Supreme Court now. Oh, that, and then the Honorable Supreme Court.
What has happened in the Supreme?
There they say it's not maintainable. Yes, because
Madhya Pradesh
yes,
said it is maintainable, which went to Supreme Court.
No, Madhya Pradesh High Court also said not maintainable. Honorable Supreme Court affirmed that judgment, but there, by mistake, what they had done, Lords, is instead of Lokayukta directly filing it, Madhya Pradesh government through Lokayukta anta anti-corruption bureau that. Honorable Supreme Court said, how can you challenge the sanction order is what I'm trying to get the
detailed order or
the
detailed order.
Honorable Supreme Court order is a detailed order. Madhya Pradesh judgment, I'm trying to get it. So that I thought I'll
place it on record. Let us see what the review happens. Then we'll take it. When two division benches are there, single bench will be. Learned Shri Prabhuling Nawadgi, learned senior counsel, by relying upon the judgment dated 23rd October 2025 in writ appeal number 168 of 2025, submits that a division bench of this court has categorically held that under the provision of the Karnataka Lokayukta Act, the Lokayukta is the investigating authority and not a disciplinary authority. And on that basis submits that the Lokayukta cannot seek for sanction of sanction.
Sanction is rejected. Proposal for sanction is rejected. That cannot be challenged.
Challenge the sanction, non-grant of sanction. Learned counsel for the petition submit that a review petition has been filed in respect thereto, which is pending. RP number eno. An RP number so and so. In that view of the matter, there being two. In that view of the matter, released in January on
28th January.
28th January.
Serial number 24.
One submission, serial number 22. The property which my lords observed, there are survey number 86/1. That the registered, the society is registered there.
22.
The society is registered in that place. The property, my lords, we have given in a representation, page number 20.
B was your representation.
Page number 20, my lords. First para therein. We have not mentioned survey number, but survey number is 9. Same property, same place, survey number is 9. It's page 20.
Where have you mentioned the property details?
It's page 20.
This 86/1 is your registered office.
Please, my lords. That's registered office of the society. Page 20, my lords.
ದೇವಾಲಯ ಹತ್ತಿರ
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ
ಜನಾಗೃತಿ ಕೃಷಿ ಸೋನ್ಸ ಒಂದು ಮಹತ್ವದ ಕಾರ್ಯಕ್ರಮವನ್ನು ಹತ್ತಿರ ಅಂದ್ರೆ
the place will remain the same. The survey number is 9. I've been given the RTC of the said land, my lords. I have the RTC.
Private survey number 9.
9, my lords.
In ಯಾವ village ಅದು?
Bidulur, my lords. Amanikere
Write it
Bidulur.
down and give it to us. The 86/1 ಬದಲು that survey number.
9, survey number 9, please.
Serial number 24.
Days accommodation to implement the subsequent.
What is questioned is Malav
Iಡಿ
notification.
ಸಂಜೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಪಾರ್ಟಿ.
Tender notification. It's already participated as unsuccessful. Financial bid or technical bid, everything open, work order also
The
issued.
interim order is there.
No, my lord. ಅವರು you want to implement others ಅಂತ ಅಷ್ಟೇ.
So there is no interim order. What is? Learned counsel for the petition seeks for a short accommodation released on 10th December.
25, Chokka Reddy.
Total 7 ಅಲ್ಲಿ Total 7 ಅಲ್ಲಿ ಇದೆ.
ಬರ್ತಾರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲಿ ಬರ್ತಾರೆ.
ಪಾಸು.
26, Mahesh Arupin on connected matter.
Appearing for the petitioner. Kindly praise for the time, my lords. Kindly praise for the time to file.
It was rejected in the morning, madam. Mr. Upin objected.
Annexure F is the impugned order, Lord.
Can't again ask for time when it's been rejected.
I appear for respondent number 1, my lord.
Yes.
Lord, petitioner is a cooperative bank, Lord. In order, in view of the RBI directions, Lord, it has opened in a current account in the first respondent bank, Lord. And it has also obtained, Lord, internet banking permission by providing a mobile number. But some third party, Lord, annexure, you will ask me kindly see, Lord. Some unknown person has filed an application before the telecom department, Lord, seeking, Lord, change of mobile number, the SIM, replacement of SIM. Last me kindly see name of the subscriber. He has mentioned Basveshwara Pattana Sahakara Niyamita.
Your name has been.
Son of Lord Sahakara Pattana. He seems to be a North Indian, Lord. He was in fact arrested and criminal case is pending. On the basis of this application, duplicate SIM was issued. Then, Lord, the bank, Lord, has provided, Lord, the password. He withdrawn about 87 lakhs, Lord, by transferring the amount of the petitioner from current account. Yes, Lord. 87 lakh. Out of that, Lord, 30 lakhs was reversed in our account on complaint. Then, Lord, it was 7 lakhs, Lord, was seized. That was given to us by the learned magistrate, Lord. Criminal case is pending. We have filed a petition before, Lord, local under legal service authority, Lord. There, Lord, the settlement was not reached between parties. The authority, Lord, has adjudicated the issue and granted only 5 lakhs and not compensation. Because reason is this, Lord, during pendency, Lord, we got, Lord, 57 lakhs from the insurance department through Canara Bank, Lord. Now, what we are claiming is that, Lord, for 2 years, Lord, we are deprived of this amount, Lord. We were made to withdraw from other account to maintain cash reserve fund as per direction of the RBI, Lord. We were deprived of the amount, Lord, for our business. We are entitled for compensation. That is one thing. Second is that, Lord, many of the customers, Lord, withdrawn the amount from our bank, Lord, because of this fraud, Lord. They were afraid of, Lord, their money, Lord, to continue in our bank. Only 5 lakhs is awarded. Against that, they have filed writ petition. The department has filed writ petition on the ground that, Lord, it is not maintainable. Our petition before legal service authority is not maintainable. And I have filed this petition for enhancement.
You have filed a criminal proceedings.
Please, Lord.
They filed a criminal proceedings against them.
Criminal proceeding, Lord, is pending.
You filed.
It is filed, Lord, by state as registered.
Against whom?
Lord, against, Lord, unknown person, Lord.
No, you should have filed it against respondent number 2.
So now complaint now put to our government.
Respondent number 2 has acted on this application. Son of Sahakara Pattana. So that shows how negligent they have been.
No, my lords, we have not.
Obviously.
No, my lords, we have not done. It was based on R1, my lords, Canara Bank. It was the.
You issued the SIM card.
No, my lords, we have not issued.
Who issued the duplicate SIM card?
No, we have not issued any.
You're not issued.
We have not issued any SIM
Sure.
cards. Sure, my lords.
Madam, please be careful.
Yes.
The whole thing has happened because of duplicate SIM scam.
No, my lords.
And your offices have issued the duplicate SIM.
No, my lords.
And with that duplicate SIM, after 24 hours, OTP gets activated there.
No,
They have
yes.
used the OTP there.
Yes.
And done the transaction.
No,
There's a
no.
regular duplicate SIM scam which is happening. And many of the offices of the telecom service providers are involved in this.
No, my lords, they have not
So
involved.
that is why we'll direct that inquiry in this.
It was happening, they are contesting that it was happening in Bangalore. It was
Where is your senior?
senior with shorted, my lords. He will come on
We'll
Monday.
have it on Monday.
Sure.
Get him ready.
Petitioners have not given the paper book, finally directed.
Ready.
Interim order may be extended. my lords.
ಇದರಲ್ಲಿ ಇನ್ನೂ ಒಂದು ಡೂಪ್ಲಿಕೇಟ್ ಸಿಮ್ ಸ್ಕ್ಯಾಮ್. So we'll be directing an inquiry into this because the matters which are coming up before us, the people who are in the telecom company are involved. We are directing you to inquire into it, registered FIR and inquire. Then that freezing and this, both of these are all interrelated. Ilindane, that dot goes into the different accounts. This is a very old scam. There are different varieties of scam. Duplicate SIM scam is one of the oldest. Must open, get the details of all the criminal complaints that you have
Please,
filed
I will get it.
and give it
In
to
one of
us.
the writ petition, they have not submitted the copies to us for Canara Bank.
They are given.
Yeah, let them give, I will file my objections.
They are given the copies. You can file your objection by Monday.
Yes, my lord.
My lord, since interim order may be extended now.
Yes, madam.
26.
For now, till Monday, it will be extended. The request of counsel for the petitioner in WP 4674 of 2025 released on Monday at 2:30 p.m. Interim order earlier granted is extended till next date of hearing. Learned counsel for the petitioner in WP 16104 of 2025 is directed to place on record all the criminal complaints which have been filed by the said
Registered.
petitioner.
Yes.
Copy thereof to be supplied to learned AGA, who is directed to secure instruction as regards the status of the inquiry therein.
Yes.
Being of the opinion that, which is the SHO? Who is the investigator?
Station officer.
Where have you submitted the complaint?
Bangalore. It is pending.
Bangalore ಅಂದ್ರೆ
Bangalore.
ಅಲ್ಲ, ಅದು ಶಿರಾಲ್ಕೊಪ್ಪ ಶಿವಮೊಗ್ಗ district ಬರುತ್ತೆ.
CNL ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ jurisdiction police ಕೊಟ್ಟಿದ್ದೀರಾ?
Cyber crime branch.
Complaint copy ಇದೆಯಾ?
I shall furnish my lord right now.
Being of the considered opinion that so and so, who is the investigating authority in the complaint filed by the petitioner, would be required to be brought on record as respondent, since the views of the investigating officer would have to be, since the status of the investigation would have to be ascertained. So and so is brought on record as respondent number 3, learned AG accepts notice for respondent number 3. Registry is direct print his name as such. Released on Monday at 2:30.
It is cyber crime branch, CID Bangalore.
Birth code, CN.
Crime number 1 of 19.
27, Sachin BS, connected matter.
This is covered by my lord's judgment, Device case. For Sagubane land, I sought for permission to cut the tree.
Sagubane is not covered under that. It is always out of the purview. Adu regularization of unauthorized. 53 ಅಲ್ಲಿ. Sagubane ಅಲ್ಲಿ ಹಿಂಗೆ. Sagubane is owned by them. This is not a granted land.
Everything.
Not regularization of unauthorized occupancy.
My lords also dealt with it in detail, my lords, in my lord's judgment. What is privileged, unprivileged, everything has been dealt with.
You are Sagu Bane anyway.
Sagu Bane. I made an application to Forest Department. Forest Department sought opinion from DC. DC said the ownership right vests with the petitioner, but trees does not vest with the petitioner. Or it's annexure A is the finding recorded by the DC at last paragraph. And relying upon annexure A, annexure B, Forest Department rejects it. Last paragraph would be.
They themselves say it is Sagu Bane.
Yes.
Third. Petitioners are before this court seeking for the following reliefs. In both the matters, in WP number 4674 of 2025, the petitioner is the owner of the land in survey number 22/1, 16/1, so and so, Virajpet Taluk and district. The said lands have been classified as Sagu Bane land in the revenue record. The petitioner growing coffee, a plantation crop, as also certain trees like jackfruit, nandi, matti, onne, kardi, tari, bage and rosewood, had made an application for cutting the said trees, some of the trees. Respondent number two, who on 2/11/2023 submitted a report as regards the ownership of the land, but claimed that insofar as trees which are required to be cut, the petitioner would not have any title thereto, and the said trees would belong to the state. And it is in that background that the request made by the petitioner for cutting the said trees came to be rejected, and it is in that background that the petitioner is before this court, seeking for the aforesaid relief. This court has dealt with the similar matter while it's order dated 25/7/2024 in WP number 55534 of 2013 and other connected matters, and has come to a conclusion that insofar as Sagu Bane land is concerned, the same would be a private property and the government would not have any authority or right over the same. And further, that in view of the amendment which has been carried out to the Karnataka Land Revenue Act, even as regard Jamma Bane land, occupancy rights could be granted on an application being made by the concerned owners of the property, concerned holders of the property. In that view of the matter, the tenure of the land, the classification of land being Bane land, now whether it is Sagu or Jamma, the right of the holder of the land has been confirmed by way of the said judgment. In the present case, the land being Sagu Bane land, the title would continue to vest with the title of the property vests with the landowner. So also would the title to any trees which are grown on the said land, and as such the respondent could not have claimed that the petitioner, who is the owner of the Sagu land, does not have title over the trees which have been grown on the said land. The rejection being on that ground is therefore required to be set aside. However, insofar as the trees which are proposed to be cut by the petitioner, each of the trees would have to be examined by the respondents to ascertain if they could be so cut, and if so, by following what procedure, and if not, the reasons why they cannot be so cut. Rosewood they cannot do it. In that view of the matter, I pass the following order. Writ petition is partly allowed. The impugned report dated 2/11/2023 at annexure A issued by respondent number 2 insofar as the claim made therein that the petitioner cannot have right over the trees grown on Sagumane land is set aside. The respondent, consequently, the order dated 22/4/24 at Annexure A and the endorsement dated 3/7/2025 at Annexure A2 are set aside. The matter is remitted to respondent number 2 for fresh consideration in terms of the above observation. It is made clear that respondent number 2 would have to consider the right of cutting of the trees in terms of the applicable law, which shall be so done within a period of 30 days from date of receipt of a copy of this order.
Second petition, same observation, but annexures gets changed, my lords.
Annexure
A is the order passed by the deputy for.
all the trees are the same trees or different trees?
No changes. Annexure A is the order passed by the deputy range forester, and B is annexure A is order passed by the deputy commissioner, and annexure B is the pursuant to the order passed by the DC.
A and B are quashed. Limited to consider D and D1.
Great.
28.
This matter I appear for the petitioner. The petitioner is practicing Unani and not Ayurvedic medicine since from not the 35 years.
Who is for the respondent?
The third respondent not.
Who is for the respondent?
Respondent not is. But the third respondent passed the impugned order annexure M or page number 114. But thereby I'm not.
R2 is a separate council.
No, my lords. Last date
Register
of
Karnataka Ayurvedic and Unani
last date of hearing not we took notice of not. Last date of
Murthy
hearing.
VN antidiyallappa ಇಲ್ಲಿ.
ನಮ್ಗೆಲ್ಲ
Murthy VN for respondent number 2 ಅಂತಿದೆ cause list ಅಲ್ಲಿ. Is there a separate council?
ಹೌದು ಸರ್.
Where is Mr. Murthy?
For dental council, for medical.
Only I request not since from 35 years not I am practicing. Only I am requesting not to disturb the practice not till not the board decides the matter. It is not the pending before the board. But the annexure M is the impugned order.
Appears for respondent number 2. If none were to appear for respondent number 2 on the next date of hearing, the matter would be taken up for consideration on the basis of the submission of the council for the petitioner and an AGA. Relist on
Rest matter list not.
11th in preliminary hearing.
Public.
29. Government advocate.
We appear for the
You are appearing, Mr.
respondent.
Yes, madam.
State
has challenged.
We had filed caveat.
Yes.
I'm not complaining, but without even informing, they keep on mentioning. Your lordship had adjourned it to January. They keep on mentioning again and again. At least to namge information adru kodbekalva. That's all right. I am ready, my lord.
Been adjourned to January.
ಮೊನ್ನೆ 151 ಇತ್ತು ಐಟಮ್ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ January 11th ಏನೋ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ, ತಿರ್ಗಾ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ನಮ್ಗೊಂದು ಮಾತು ಹೇಳಿದ್ರೆ ಸಾಕು. But anyway, my lord, let's forget that. I am ready. Let my learned friend go on with the matter.
Then leave.
This is all too trivial a matter to bring it to your lordship.
Yes, madam.
To maintain
Lordships,
certain
we have
decorum, I only
challenged.
mention.
Yes.
Annexure
It is
A
required
is
that it be.
Annexure A is the notice, my lord, issued by the commission, which is in challenge, my lord. Lord, the brief facts of the case are that, my lord.
Yes.
Respondent number 3, my lord, he applied for querying lease, my lord.
Respondent number 3.
He applied for querying lease, my lord. And my lord, under the section rule 31ZC, my lord, of Karnataka minor and minerals rules. My lord, under rule 8(5), my lord, it's mandate that he has to obtain no objection from the forest department as well as revenue department, my lord. As such, my lord, there were several communications between the department and the respondent number 3, my lord. That was apparently, my lord, challenged before the green bench, my lord. Before the green bench, my lord, there was an order passed, my lord. My lord, despite, my lord, there being a direction from the this honorable court, my lord. The respond number 3 has filed a complaint before the National Commission, my lord, on the same lines. My lords may kindly permit me.
Copy. Pendings and notebook.
What is
If my lords may kindly see this judgment.
25164
Beg your pardon.
WP 25164, what are the relief sought?
My lord, this, my lord, there were several communications. My lord, NOC, he ought to have, it was mandatory, my lord, to produce no objection from the forest department and the revenue department, my lord. And there were several communications between the department and respond number 3, which was challenged, my lord, before the green bench, my lord. Your lordships may kindly see the order, my lord, para 13 of the division bench order, my lord. May I read, my lord?
Yes, please.
Another aspect that can be found from the communication is that same is in connection with the petitioner's application for grant of query lease. The application is filed on 29/2023. No doubt the application has seen further development of its consideration by joint inspection by competent authorities, and the application is under consideration as evident from the correspondence between the authorities as available before the court. Still, application deserves consideration at the earliest. In these circumstances, the prayer to quash the communication dated so-and-so at annexure so-and-so is misconceived. The petitioner contends that in pursuance of the consideration of the application, respond number 5 has requested no objection certificate from R4 and 5, which is awaited without any just reasons. The submissions of the learned advocate for petitioner pursues limited interference of the court to the extent of directing R4 and 6 to consider the petitioner's request for issuance of no objection. Accordingly, following order is passed. My lord, despite there being directions of this honorable court, my lord, the petitioner, my lord, approached the commission, my lord. If my lords may see the complaint filed by the petitioner, my lord, it is at annexure B, my lord.
Yes.
Lord, the page 33, my lord. Last paragraph, my lord. My lord, he approaches the commission on the ground that, my lord, there is discrimination, my lord. Therefore, in view of the above facts and submission, I humbly submit this honorable commission to take up the matter and Prevention of Atrocities Act 1989 and Protection of Civil Rights Act 1955 and issue notice to R6 Deputy Commissioner Tumkur so-and-so and Deputy Conservative of Forest a copy of notice for information and further necessary action in this regard to R3 Principal Chief Conservative of Forest 4th so-and-so and Principal Chief Conservative of Forest and help justice may against this discrimination. Now, my submission is that, my lord, when this court has clearly and insofar as the Lord, I have produced the proceedings of the commission also, my lord, which will have a better now, my lord, they are issuing notices repeatedly, my lord.
To it, saying that this is
We have replied, my lord. Now, my lord, again, my lordships may kindly see my memo which I have given. They have again issued one more notice, my lord, to Principal Chief Conservative of Forest and Regional Commissioner. They are not at all party before the National Commission, my lord. And if my lords may kindly see the proceedings before the National Commission, I have produced it, my lord. Now, SIT is constituted, my lord, to determine whether the land is forest land or revenue land. Your lordships may kindly see the proceedings before the National Commission. May I read the relevant portion, my lord?
Yes.
In the page 10, my lord, paragraph 5.
Yes.
In this matter, a hearing was conducted again on 29/8/2025. The action taken report on the Commission's recommendation was presented by the officials present at the hearing, and the Commission was informed that legal process of joint survey of concerned land by the Forest Department is in process. Additionally, for a detailed investigation of the matter, a special investigating team has been constituted by Revenue Department, Karnataka government, and under the chairmanship of Additional Revenue Commissioner. The team has completed the preliminary investigation and compilation of all documents related to the matter. However, the team is still examining the matter. The resolution of the matter will be based on SIT's report. After hearing both the parties, the Commission recommends that the SIT team conduct an impartial and independent investigation and submit its reports to the government at the earliest. The SIT team should hear the petitioner in person. Kindly see this, my lord, in person and take cognizance of the documents presented by them. The District Deputy Commissioner Tumkur should resolve the matter positively and submit a report to the Commission within 1 month. The SIT team expedite the investigation in an unbiased and independent manner in a time-bound period and also hear the petitioner in person with cognizance of their documents. The DC Tumkur is directed to submit an action taken report within 1 month. Now, my lord, may I bother my lord to kindly peruse page 44 of my petition, my lord.
Yes.
My lord, this is the order passed by this honorable court, my lord, in a similar situated circumstance, my lord. Petitioner is before this court calling up in question an order passed by National Commission for Scheduled Caste. A license under a stone crusher whose license had been declined to be renewed does not approach any judicial fora, but
What is the relief that has been sought for before the National Commission?
Beg your pardon, my lord.
What is the relief before the National Commission?
My lord, that his contention is that, my lord, there is a discrimination and no objection certificate should be given, my lord, for querying license. That is at page number, my lord. Page 24 is his complaint, my lord.
33 is the prayer.
33 is the prayer sort.
So now this is part of the deemed forest.
Yes, my lord. Yes, my lord. That is why, my lord,
And
SIT
the
is constituted.
affidavit has been filed before the Supreme
Yes, my lord. SIT is constituted to ascertain whether it is, if my lords, for a moment, kindly see page 57, my lord. Page 56, my lord.
Yes.
Page 56, my lord.
You should
Yeah, my
bring all
lord.
this to the notice of the Supreme Court that this is how it is happening.
Lord, my submission, page 44, my lord. This court has dealt with the matter and
From
held
what
that
you are
it is
showing
not in the
us,
domain
there
of
is not
National
a stray
Commission.
case. So
Hello?
where this mining people are filing this kind of
Lord,
application.
they've been repeatedly issuing notices to all
We'll
the.
deal with it today, but
Please, ma'am.
the next date when the matter is there
Please,
before the
ma'am.
apex court, you should bring it to the notice of the
Please,
apex
ma'am.
court.
Please, ma'am.
That this is what is happening
Yes,
and how then the apex court can direct all the authorities to stay their hand, like how we are not taking any action until the decision comes
Please, ma'am.
on the deemed forest.
Please, ma'am.
Once the
For a
Supreme Court
moment,
is
if
seized,
my lords may kindly see.
everybody should hold their hands. Nobody should do anything.
For a
That's Mr.
moment,
Rao.
My lord, in this, what has happened, in the same land, in the same survey number, 5 other quarry leases have been granted.
When?
My lord, kindly see page 31.
That was in 2018 and in 2015.
Paragraph
That was
13.
long ago.
Para
Now
13.
with the direction which have been issued by the apex court in Godavarman matter,
Yes.
deemed forest, they have to identify and they have to submit a report.
My lord, all that I am saying
But
is,
what gives your client the right to go before the National Commission on this basis?
Because
when you have
there is
gone
a-
on a writ appeal and the order has been passed? Is this kind of pressurizing the officers?
my lord, in para 13, kindly see my complaint.
Yes, we have seen your complaint, we have read it.
Yes, and what is
These
the
are all 1915 and 2015 and 2018.
true, my lord, when
You
they
went
give,
now, when the directions have been
No, no,
issued by the
kind-
Supreme Court.
kindly see, my lord, the prayer and what is it that is been asked from them. Please see that for a moment.
Yes, then why are they interfering in the no objection being given? If there's a
They are not-
discrimination, let them inquire on that and take action. But they cannot direct you, the authorities to issue the no
No,
objection.
no. I'm not asking them to give me lease.
That is what you are asking here. That is
No.
what the entire procedure has been. The
No,
minutes of the
please.
meeting which have been produced indicate that.
All that I have said, please give me 5 minutes.
Yes.
All that I have said is this. In the same survey number, you have given it to 5 others. To me, because of my particular status in society, you have deprived me. I have given a complaint to see to it that under 338 section of the Constitution article, please take action. That is what is the complaint.
Yes. That is, what does that mean?
That means.
To give you the no objection and issue the lease.
No. Take
Then
action.
we'll record
against-
that you don't want that.
Milord, all that I am asking is protect my right. Milord, as far as lease is concerned, may
Mr.
I
Rao,
just say
when
this?
there is a SIT constituted at the behest of the Honorable Supreme Court, the SIT's report will be submitted to the Supreme Court and Supreme Court will take a decision on what is to be done in all these matters. That is the forest matters which are coming up before us on a regular basis.
Milord, I have
And
appeared
we are
in
not
forest
taking
bench
any,
matters.
we are not taking any decision on that because we are
No,
waiting for the Supreme Court decision. And
Please
here this
see.
commission takes this.
Milord, please see the notice that is given to them. Annexure A. ಏನ್ ಕೇಳಿದ್ದಾರೆ ಪೇಪರ್ಸ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರುತ್ತಾ ಅನೆಕ್ಸರ್ ಎ ನೋಡಿ ತಾವು ದಯವಿಟ್ಟು ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಂತಾರೆ ಅನೆಕ್ಸರ್
ಇದಕ್ಕೆ
ಎ
ಬನ್ನಿ.
ಅಲ್ಲಿ
ಇವಾಗ ಮಿನಿಟ್ಸ್ ಆಫ್ ದ ಮೀಟಿಂಗ್ ಇವಾಗ ಓದಿದ್ದು ಬನ್ನಿ. The 29/8/2025 along with the memo which has been filed.
that has not been supplied to me at all. It's being given just now.
But this is in my, this is in your, you are a party to these proceedings.
Milord, please
Sir, aware
allow
of
me to
this.
say this, Milord. Otherwise, Milord, I will be helpless. Kindly see annexure A, which is question. Paragraph 2. You are hereby requested to submit facts and information on the action taken on the allegations, etc., to the undersigned within 15 days.
Yes.
ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಿ ಅಲಿಗೇಷನ್ ಮೇಲೆ ನನಗೆ 15 days ಅಲ್ಲಿ ಹೇಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Much
ಇದ್ರ ಮೇಲೆ
water has
ರಿಟ್
flown.
ಬರೋದಾ?
If you are not been informed by your client, we don't know. But much water has been flown after that. Please see 29/8/25.
This is 26/12/24.
See 29/8/25, which has been given now. You see the kind of direction which have been passed.
ನಮ್ ಕೇಸ್ ನಮ್ ಕೇಸ್ They are asking them to give the particulars.
Please read it, Mr. Rao. We don't want to see.
ಅಲ್ಲ ಇವಾಗ ಕೊಟ್ಬಿಟ್ಟು ನನಗೆ ಅದು ಹೇಳಿದ್ರೆ ಒಂದ್ ದಿವಸ ಮುಂಚೆ ಕೊಡ್ಲಿಕ್ಕೆ
We'll stay these proceedings. You can have a look at it because these kind of directions we cannot have it when the Supreme Court is seized of the matter.
Lord, this is trying to overreach me. These people give me at the last moment and then tell me, my lord, I have filed a caveat which is pending since several days and no copies are given. At the last moment, copies are given to me. Proceedings are here.
These are proceedings of which you are a party.
Who, my
Not
lord,
a party, then you
ultimately,
would have
what is it
said
that
so.
commission is doing? What is it that they are asking?
Please see what they have said. That's why we asked you to read it. What they are doing.
Have it tomorrow morning, my lord, I will read and come.
Yes, tomorrow morning, top of the list.
Very well.
At the request of learned counsel for respond number 3, release tomorrow, top of the list.
May I make one submission?
Yes.
For 30, my lord, they have asked the principal conservative of forest to
That's
be
what we are
present,
not
my
able to.
lord.
Why does the PCCF have to be called for?
He's not, they are appearing, my lord.
They
He is not
notice-
called. He has been asked to give the details.
See that, Mr. Rao, that's what we have been trying to tell you. Although you might have been given now, please see it at least.
In
If
I'll
the
leave it to
complaint
you,
is
Lord.
against one range forest officer and ACF, the PCCF is being asked to appear. And there's a direction being given, you do this in 30 days, positively, consider it positively. Even when we issue a mandamus, we say consider it in accordance with law.
Yes, that earlier order,
And we don't say positively like that.
I know, my lord, it can't be said also.
It has been said. That is what, that's why we are shocked by this.
I will leave it to your lordship. Because I am helpless to,
We'll take it up tomorrow. Till tomorrow, it will be stayed. Tomorrow, you make your submission. If your submission is valid, then we'll consider it. But to be directing all the forest officials, top forest officials to be present, for this is not proper. Even when we ask them to appear, we say appear through VC.
he can appear.
And here they say personally present, in person.
Lord, either this
Should
or
be
that.
doing this in one, for one lease of 2 acres, you ask the PCCF to be present personally.
And
When
he
the
is the
person authority is
person who
different.
gives NOC for 5 of them and deliberately
In
will not discriminates
2015,
me.
we'll deal with that tomorrow. The further proceedings before the first respondent
Joint survey.
in file number ESDW/IP/KA/2024/27505 of 2020 or 275/055 as stated till the next date of hearing, considering that notices are being issued now to the principal chief, notice has been issued to the principal chief conservator of forest to appear in person before respond number 1. More so when the matter is seized by the Honorable Apex Court and a special investigation team has been formed to identify, demarcate and submit a report to the Honorable Apex Court as regards forest land. And until orders are passed by the Honorable Apex Court, no action could be taken as regards those lands. Relist tomorrow at top of the list.
Lord, to physically present, nothing is given to me.
District Magistrate, Deputy Conservator of Forest, Regional Commissioner, Principal Chief Conservator of Forest. Why are all these
This is in
people
August,
required?
my lord. This is in August.
Why are all these 2011, 25, Mr.
Date of hearing
Rao?
29th August 25. They have appeared, they have participated, they have also
Mr. Rao,
given
please
documents.
see page 11. Please see page 11.
My lord, ಅದಕ್ಕೂ ಮುಂಚೆ 3 ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದು ನೋಡಿ ಇಲ್ಲಿ.
ಇದು latest ಇದು.
27/11/430 in person. To whom? The District Magistrate Tumkur, Principal Chief Conservator of Forest, Head of Forest Force, Deputy Conservator of Forest, Regional Commissioner Bangalore Division. Why should they be required for in person? Cannot a council represent them?
They can.
Then why they say person?
From August they are appearing, my lord.
Or through council illa illi, in person and it is bold.
ಯಾಕೆ ಅಂದ್ರೆ ಫಸ್ಟ್ ನೋಟಿಸ್ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
We'll deal with that later.
Documents
That's just may I seek for hand delivery.
Hand delivery
Please
order.
oblige.
4 o'clock.
Four o'clock matter, list number 2, serial number 11. Sagar B. Shastri.
My lord, the connected matter, my lord, along with this, 19980, my lord, if that file can be called for. Because it was supposed to be linked together.
This previous matter, this forest matter.
Yes.
Because the Supreme Court is seized, we are staying our hand.
Sorry, my lord.
The Supreme Court is seized of the matter.
Yes.
We are staying our hands in all these matters.
Yes.
Please look into it seriously.
Yes.
And bring it to notice of the Apex Court that this is what is happening.
Yes.
Ms.
Yes,
Kulkarni will brief
yes.
you on that.
Yes.
Cannot be happening like that.
Yes.
Yes, what is the other matter?
So the connected writ petition was 19980 of 23, my lord.
19980.
Yes, my lord. These two petitions, I think that's not listed today.
It was delinked at your request.
No, no,
to file
that's not
objection.
delinked, my lord.
It was.
No, no.
Amendment was
Pertaining
allowed.
to
and-
the same
Was it
petitioners.
dealing?
Not on 24/11/2025. Saying that they need to file objections. 24/11/2025.
11. There is nothing which has been delinked on 24/11.
No, my lord. WP 29.
Anyway, my lord,
656
by the time
and
the
24 and 16251 of 23 are dealing from the above matters.
24/11.
Yes, ma'am. Can I just pass on not the order? I think it is passed in that matter.
That matter.
I'm sorry, I only have one copy.
It's fine. So this was passed in which matter? 19980.
Yes.
my lord,
Because my lord, their pleadings
submission,
were not
may I just
complete.
make- No, no, that's completed, my lord. In fact, if my lords recollect, 15 and 15.1 was what was being argued on the last date of hearing.
No, no, only this was argued, not
No, correct. But
15.1
both the
was.
petitions have been filed by the same petitioners, my lord. If my lord recollects, I have said that the petitioner.
So what do you want? You want that
My lord,
matter?
by-
linked to this?
No, my lord, if the file is called for, my lord, same counsel appears for the petitioners. The 64A pertains, it's a one common order which has been passed. By the time they complete their submissions on 16251.
Can't call for it like that now.
Lord, it's a pertaining to the same,
Which are the other matters? You give us the list, we'll connect. it
only
and have
one.
it Another day.
That's all, only one.
Only one.
No, the other connected matters, my lord, there are two matters. One, Mr. Vijay also appeared.
No, that's separately, my lord.
That my lord also was dealing along with that, the other
no.
matter. But I have no difficulty if everything is taken up together.
Lord,
I have no problem.
Manmohan appears for both the petitioners. By the time,
Mr. Rohan, you just tell us which matters are to be taken up together. We'll take it up together.
my lord, this is the only matter, my lord, which needs to be called along with this 16251. my lord. That's the only matter, my lord. If these two
We'll
both,
have to have it on another day.
Then I'll.
In now the.
or he can
I'll
complete
finish
in
this,
this,
Lord. I'll
my lord. He
complete
can
this
complete in
instead of-
this.
But more or less, it will not be in the same footing.
Yes, completely.
Only difficulty there not is, it was an application for regularization. That I'll only take 5 minutes, not in that matter. But can I request the court not to please turn to, not the report not which I had placed on record along with the memo on the last date. I'll just show not few portions, not I will not trouble with everything.
Yes.
Not the report not extracts all these proceedings that were initiated, including regional commissioners not orders. So he's stating that the forest department should withdraw the allegations made or the prosecution initiated against not several people. All those things not were mentioned in this report. It contains not all documents, archives not which was not otherwise available. It is collected from the archives and shows not how the entire proceedings were dropped. Because the proceedings for acquisition was initiated in 1920, after which not they were dropped and not nothing happened thereafter. Even assuming not, as I pointed out last occasion, assuming not because the government says the proceedings were not dropped, whereas not the documents reflect that proceedings were dropped. Even assuming it is not dropped, after 100 years not they cannot initiate or continue the proceedings.
The whole thing.
Yes, Lord. Now, Lord, can I request the court to please turn to the Karnataka Forest Act note for a moment?
Karnataka Forest Act.
Yes, 1963.
What section? Section?
Please note, can I request the court to please turn to section note 2, subclause 6. Note 2, I'll not read this note, I'll just point out and then take notes to the section 3 straight away then. Note section 2(3) defines who is a deputy conservator of forest. Then Lord 4 says forest division not means any area declared as such by a notification by the state government or any such authority as may be prescribed. 6 not defines who is a forest officer. Then please then turn to note section 2 subclause 14 which defines a reserved forest. reserved forest means any land settled and notified. Let's kindly note these two words. 2 clause 14. No? Reserve forest means any land settled and notified as such in accordance with provisions of chapter 2 of this act. So the two things, settlement, because settlement officer has to be appointed under section 5, and notification, that is under section 17. Now please then turn to section 3. Powers to constitute reserve forest. The state government may constitute any land which is the forest property of the government or over which the government has proprietary rights, or to the whole or any part of the forest produce to which the government is entitled, a reserve forest in the manner hereinafter provided. Note
So
section
reserved
4.
forest is in terms of chapter 2.
Yes, Lord.
So that starts from section 3.
Yes, Lord. Starts from 3. So the state government may constitute any land which is a property of the government. But two things, Lord. Property of the government or over which the government has proprietary rights, or to the whole or any part of forest produce of which the government is entitled as a reserve forest in the manner provided hereinafter provided.
So private property cannot be declared.
Please. Then Lords, 4. Notification by government.
Yes.
Whenever it has been decided to constitute any land a reserve forest, the state government shall issue a notification declaring that it has been decided to constitute such land a reserve forest. B. Specifying as nearly as possible the situation and limits of such land. And C. But this is important, not appointing an officer hereinafter called the forest settlement officer to inquire into and determine the existence, nature and extent of any rights claimed by or alleged to exist in favor of any person in or over any land comprised within such limits or in or over any forest produce, and to deal with the same as provided in this chapter. Not then not explanation, not I one not may skip, not may see, not subclause 2. The officer appointed under subclause C of subsection 1 shall be a person not holding any forest office except that of a forest settlement officer. But a forest officer may be appointed by the state government to represent it in the inquiry under this chapter by the forest settlement officer. Now, there is nothing to show how this forest officer was notified or appointed, because not a settlement officer should be someone who is
Unless you
notified.
show violation.
No, Lord. A person who
Not say that if it is not shown as to how he was appointed, there is a violation. You'll have to show some violation, that he is a forest officer or something.
not for a purpose of not a person acting as a forest settlement officer, but he has to be so appointed.
Yes.
And he shall not be any forest officer, not as defined not under the act.
Correct. Is your contention that is a forest officer?
But we have not no details with regard to that.
Then,
therefore, not our contention is not the fact whether he is a forest officer or not will have to be substantiated by the government, whether he is appointed or notified in that
no
fashion.
reverse burden of proof. First
Very
you
well.
have to say that.
I will leave it at.
Once you establish that,
Very well.
then we can ask them.
Very well. I will not also not skip it for the moment. Then please see note section 5. Proclamation by the forest settlement officer. When a notification has been issued under section 4, the forest settlement officer shall publish in Kannada and in any other language of the area at headquarters of each taluk in which any portion of the land comprised in such notification is situate, and in every town and village in the neighborhood of such land a proclamation specifying as nearly as possible, etc., etc. Then please turn to subclause D.
Yes.
Fixing a period of not less than 3 months from the date of publishing such proclamation and requiring every person claiming any right or making any claim referred to or mentioned in section 4 either to present to such officer within such period a written notice specifying or to appear before him within such period and state the nature of such right or claim, if any, and in either case to produce all documents support thereof. Then the forest settlement officer shall also serve a notice to the same effect to every person or reputed owner or occupier of any land included in or adjoining land proposed to be constituted as a reserve forest or is recognized agent or manager. Such notice shall be RPAD to the person residing beyond the limits so and so. Then note section 6 note deals with bar of accrual of forest rights. But after issuance of section 4 notification, no right shall be acquired in or over the land comprising such notification except by way of succession or under a grant or contract in writing made or entered into by or on behalf of the government or the same person in such right so and so. Note, I'll skip that portion. Then section 7 note, deals with inquiry by the forest settlement officer. But he has to conduct an inquiry as to the rights etc. of the persons there. Then note section 9. Extinction of rights. Rights in respect of which no claim has been preferred under section 5 and of the existence of which no knowledge has been acquired by inquiry under section 7 shall be extinguished unless before the final notification under section 17 is published, the person claiming them satisfies the forest settlement officer that he has sufficient cause for not preferring any such claim within the period under section 5 in which the forest settlement officer shall proceed to dispose of the claims as hereinafter provided. Then let's please then turn to section 11. Power to acquire land over which right is claimed. In case of a claim to a right in or over any land, other than the right of way or right of pasture or a right of forest produce or a water course or in respect of any building standing on such land, the forest settlement officer shall pass an order admitting or rejecting the same in whole or in part. If such claim is admitted in whole or in part, the forest settlement officer shall either exclude such land or building from the limits of such reserved forest, or come to an agreement with the landowner for surrender of his rights, or proceed to acquire such land in the manner provided under the Land Acquisition Act 1894. But then note 3 says, for the purpose of so acquiring such land, he shall be deemed to be a deputy commissioner. But I'll skip that portion. Then notes please then come to section 15. It says, in case of forest settlement officer. Yes. In case the forest settlement officer finds it impossible having due regard to the maintenance of the reserved forest to make such a settlement under section 14, he shall ensure continued exercise of said rights to the extent so admitted. He shall direct payment by the state government of compensation determined on the basis of the value of such right on the date of notification under section 4 in accordance with the provisions of Land Acquisition Act insofar as such provisions are applicable. Then let's please then turn to section 17.
Yes, this is the final notification.
This is the final notification. When following events have occurred.
The contention is only section 4 has happened. None of the procedure
None of the
from
proceedings
4
has
to
happened.
17 have happened.
Yes, nothing has happened. And therefore, my Lord, now to say that I will invoke the power under section 4, appoint a settlement officer and initiate proceedings after more than 100 odd years, my Lord, it will be completely, my Lord, unacceptable because reasonable period principle. 2, my Lord, even my Lord, under the act, within what period, my Lord, entire proceedings have to be concluded with regard to, my Lord, publication, etc. is also provided. In fact, my Lord, I'll place on record the judgment of division bench of the Honorable Court, wherein the court says 3 years is the period within which final notification has to be issued.
17 has to.
17. If not, the entire proceedings will lapse. Now, my Lord, here, Lord, at the cost of repetition, Lord, it is more than 100 years. But also, my Lord, can I request the court to please turn to section 64A, because my Lord, this order which is impugned before my Lords is passed under section 64A. But any person unauthorizedly occupying any land in reserve forest, district forest, village forest, protected forest, or any other land under the control of the forest department may, without prejudice to any other action that may be taken against him under any other provision of this act or any other law for the time being in force be summarily evicted by a forest officer not below the rank of assistant conservator of forest. Notes may kindly note this note. And any crop including trees raised in the land and any building or other construction erected thereon shall, if not removed by him within such time as a forest officer may fix, be liable for forfeiture. Then Lord's subsection 3 refers to an appeal. Then Lord, can I request the court to please turn to section 117, repeal and savings. Lord, the Indian Forest Act 1927, Lord, I'll skip all that. Lord, please see the Mysore Forest Act 1900 is what is referred to. The repeal and saving 1900 Mysore Forest Act, Mysore Act 10 of 1900. Yes. Lord, it does not save, Lord, any other proceedings. Here the notification is not under the Mysore Forest Act. It is under the Mysore Forest Regulations, which is Lord Act 11 of 1900. Unfortunately, Lord, a clear copy, Lord, of that notification is not there.
So regulations are under which act?
Lord, that is the difficulty, Lord. The regulation does not refer to the act.
Where are the regulations?
I have a copy, Lord, but I'm sorry, it is not very legible.
If the regulation is made under a particular act, that will get covered.
Yes, not sorry. Lord, therefore,
Regulation
Lord, I
cannot
was
be without any parent act.
true.
Somebody
This
has
is
to
in
be there.
1900. Lord, what system was being followed then, Lord, I'm not, but the date is the same. Can I just, I'm not sure if copy idea. Copy clear illa.
Mysore Forest Regulation.
Mysore Forest Regulations. This is Act, these are regulations. Copy for them. Kiran, you have a copy? Mysore Forest Regulations. If you have a better copy, please. My copy not been. But I'm sorry, this is not very legible. But then, not it is notified not on the same day. The date of notification of the
16
Mysore
November 1900.
Yes, Lord. Mysore Forest
Pass on
Act
this
also.
legible copy.
Date as eligible.
ನಮಗೂ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ.
ಅಲ್ಲ
ನಿಮಗೆ ಕೊಡಲ್ಲ, ನಮಗೆ ಮಾತ್ರ.
Mysore Forest Regulation, Court Office.
All these things need to be uploaded on your website so people.
We'll
can
ensure
get it.
that. We'll ensure.
All the act, regulation, rules, everything.
Yes.
Of what? Huh? This is what? No, this is the act. Kiran, if you can send me a soft copy, it's fine.
I'll give you. I'll send.
Where's the regulation, Mr. Ron? This is as regards probably a commentary. The regulation what Mr. Manmohan has given us is different. Regulation number 11 of 1900.
I had that one copy. I thought it's.
No, act is different, not regulation is different.
So
both
where
are
does it
notified on the
trace
same day.
As you said, unfortunately, it's not legible.
This is regulation.
But where does it trace its power from?
But it does not refer to that, Lord. I tried reading whatever, Lord, they could read.
We'll just pass this on. This is little more.
No, it's a regulation. What is
I know.
Have a look.
Yes, this appears to be.
No, this is 1920.
Given the
As amended in 1901 and 1920.
But this, I think this is not Karnataka Forest Manual.
given the.
That, not that. There's another, this you have given him.
No, my lord, I had only one copy. He,
Don't
in
have a
fact,
copy for
month. I'll send the soft copy to him.
Shall be published in Canaries in the official gazette. This is a legible one. We'll have to go through this and find out.
Very well.
This is in 40 pages. Somewhere there must be something as to where, and what provision this has been made.
But usually it will be there in the first portion itself.
It should be, but can never know how those drafts.
True, not I will have a look at it. But my lord, interestingly, both are not passed on the very same day.
That is why. What is the interrelationship between both?
But
Act and the regulations.
we tried to compare my lord, the two. Substantially, my lord, it is similar. The provisions in the Act and in the regulations are substantially similar.
That's similar.
We tried to make a comparison because here also there is section 4 under the regulations, but even under the Act there is section 4. The definition, not all that, everything, not. I think only portion that changes not is the extent to which it applies. Because regulations say it is whole of Mysore, not Act says it extends to whole of state of Mysore except Bellary district. I think again that is not subsequently amended. But I don't want to waste the court's time. Not I will have a better copy.
Now that you have a legible copy.
Yes, not I'll have a.
Must be some literature on this.
I'll also try and do.
What
Yes.
is the relationship between
Yes,
the Act and this
I'll also-
regulation?
I'll gather that information.
The submission of Mr. Manmohan is that they're by and large the same or verbatim the same. And why two? Why the Act and regulation?
Yes. I'll take
There must be
instructions on that
some,
front.
in the archives, there must be something.
I'll try and.
What happened at
Yes.
that time? So you want us to connect this to the other matter? What is
Yes,
that?
Not I would also request not the other petition, the fresh petition that we had filed. Let it also become not along
You
with
filed
this.
one more petition.
No, it was there not on that day.
Uh,
That also not maybe
So
listed.
that I had to file pleadings, I had sought for time. Those were fresh writ petitions which were filed. These
Fine,
writ
but then
petitions,
we'll take everything together. Everything has to be decided. Piecemeal, why do you want to
all right.
connect with WP number 19980 of
19980 of 2023.
And WP 33767 of 2025. Not done that. In that matter, one request, not. I sought for an interim relief, not, but that day, not, I did not bring.
It's
It
not
was a fresh
listed.
matter. It's not listed today. It was delinked on that day.
So we'll have it on another day and then consider.
Very well.
My lord, these are what, these two matters, my lord, that is what my lord is hearing now, and 19980 of 2023 is pertaining to 64A proceedings. The other matters are, now the petitioner has produced the annexure S, my lord, and a prayer is sought by virtue of which the forest settlement officer has been appointed. He has issued proclamation, including the petitioners have appeared and have filed their claims, and those claims are adjudicated and orders have been passed in accordance with section 14 of the Karnataka Forest Act.
The
I'll place,
foundational aspect is would a notice, a preliminary notification or
I'll point out, there's a,
1920 be acted upon in 2024?
Now, there are two decisions. One which Manmohan said, with regard to reasonable time, the division bench of this honorable court said that reasonable time would be 3 years. There was an appeal which was filed, and initially the Honorable Supreme Court had granted stay. There the notification was of the year 1991. And during pendency, the final notification was issued after 25 years. Then the Honorable Supreme Court says, now the question becomes academic. And we'll not go into that area. That's one. No,
2 decades and 1 century, there's difference.
That's one area. That's one area. The second is division bench of this honorable court, pursuant to the question that was framed and remanded matter back by the Honorable Supreme Court, whether mere issuance of Section 4 itself, whether land can be treated as reserved forest land. The finding is, yes, it can be
on
reserved.
record. You complete the pleadings, we'll take it up.
No, I'm just saying, so I'll pass on.
There's some other matters also. Other
Yes,
people are
yes,
waiting.
I'm sorry. I'm sorry.
You can place all the submissions on
And
record.
I'll also place the FSO findings.
Anything and everything that you want to place. You want to place anything, please place that.
Because
not aware of
maintainability of the
Section
writ
14
may be
order.
an issue. I'll place it and I'll argue on the next day.
By when will you file your objections? In all of them?
Not 1 week from today.
Relist on 9th December. So 9th December, you complete all the pleadings?
Yes,
and we'll take it at 4 o'clock.
Because some of them have constructed structures over the natural stream itself. That is the urgency.
The problem with this forest issues.
No.
8th, we have 189 matters already. You want to make it double century, please.
No, Milord, we'll have it on the day that, no.
9th, we have 128.
Can it be at 2:30?
4 o'clock. ಯಾಕಪ್ಪ ಡೆಲ್ಲಿ ಮಂಡೇ ಹೋಗ್ಬೇಕು ಇಲ್ಲ ಫ್ರೈಡೇ ಹೋಗ್ಬೇಕು ಟ್ಯೂಸ್ಡೇ ಏನಕ್ಕೆ ಹೋಗ್ತೀವಿ 10th you have a matter. And should we have it on 4th? By 4th will you file your objections?
4th, Milord. Yes.
4th, or then the last week 15, 16, then it will become
Milord,
difficult
I would
to
prefer-
take up the matters.
Subject to the court's
Subject to you completing the matter on that day, otherwise last week it will be very difficult before vacation.
4th, we'll work and file objections.
4th at 4 p.m.
Yes.
If the copy can be furnished to us.
I'll furnish.
In advance.
I'll do all.
Great. The order will be extended.
Interim order earlier granted is extended till next week.
I'll furnish the other case number as well. Furnish to club.
Please.
Great.
Serial number 12. Manu Kulkarni. Connected matters.
Yes.
Matter was adjourned for final arguments today, my lord. Central government. said they
Continuance
had-
of the final argument.
My lord?
You can continue. It's only one small amendment that they did.
Yeah, yes,
You have to finish your argument.
yes, ma'am. Central government said, Mr. Kamath had said it was only 5-10 minutes their argument and state, oh, Thursday. So I thought it-
He's having a special badge and all.
I'm fond of lapel pins, so.
Yes.
I'm not sure how your lordships are here. I mean,
You have to argue on your amended portion only. You have finished everything. Only that point, if you argue, that probably is 5 minutes. Mr. Kamath is 5 minutes.
yes.
The state synopsis we have kept it.
It's already done.
Yeah. I'm
Ours
just
is also
placing the
ready.
synopsis.
Ours is ready.
It will take some time. I would kindly grant me that indulgence.
Last
They have
woman
filed-
standing.
They have filed 6 volumes of affidavits.
Okay.
Whatever they have filed, the issue is,
My lord, my lord had passed, a very prescient order, which they have answered each point of my lord's questions. The entire matter, the meat of the matter lies there. I'll
That's
just
all.
take my lord through the affidavits and.
The state synopsis, can I place it on record, my lords? Or
Enough file madilva?
let this place?
You served it on everybody?
I'm giving it assignment. I'm giving it to the petitioners, my lords, because we are sailing on the same.
I filed my objection.
Yes, Mr. Kulkarni.
Lord, in respect of those guidelines, I have fourfold submissions, my lords. First, in terms of form, and some of this has already been said, therefore I will just go briefly, my lords. In terms of form, the guidelines nowhere denote that they are law in any sense of the term.
Yes.
Second, my lords, if your lordship will kindly see the guidelines, they are filed by the state. Lords, the form, I will just read the title of the guidelines.
Initially, extract was produced by center.
Please, my lords.
The entire guidelines were produced by the state.
State.
The argument on that was made by the center.
Center.
Then you filed the amendment application.
Please. There, the document, my lords, itself does not in any way say that it is a law that applies to anybody other than lactation, public health centers or lactation centers.
Where is that and which
Lords,
volume is that?
Statement of objections, your lordship may kindly see of the state at annexure R13. Lord, statement of objections filed on behalf of R1 and R2. State, annexure R13. You have one.
Only thing is probably when we file that first instance, the guidelines.
You made it into a truckload of papers. 19352.
You have extra documents. It's filed on 16/7.
Registry 18.
It's okay.
Yes, yes. I'll give you.
Can I pass my copy,
Just pass your copy.
madam?
No deal.
I'll just use it for my sufficient.
Yes, page number?
Lords, page 81 annexure R13.
Yes.
Lords, it says national guidelines on lactation management centers in public health facilities. Therefore, prima facie on the face of the document, it is restricted to lactation management centers in public health facilities. That's why, my lords, it's called a guideline. It's an internal document of the ministry for public health facilities. It's an internal document. And every other page of the document, my lords, does not have any vestiges of law. For instance, it is not notified, it's not in the form of a government order, it is not expressed to be made in the name of the president. Then if your lordship will kindly come to page 98, it says guiding principles.
Yes.
Therefore, my lords, my respectful submission is that first submission therefore is it is not law.
Yes.
The second submission, my lords, is because this was not law, throughout the show cause notice proceedings in the order, there is no reference to it. Therefore, even the state did not think when the cancellation order was passed that this is law.
Yes.
Thirdly, my lords, this is not, or this does not, it is not even claimed that this is made under the Drugs and Cosmetics Act. Therefore, that leaves only Article 77 and 73 as to whether this is executive legislation. An affidavit has been filed saying this is executive legislation. But even there, my respectful submission, my lords, is for it to become executive legislation, a certain form is required, including gazetting it, including signing it in the name of the president. None of that has been done.
Constitution.
Please. Seventy-three one.
Yes. Yes, yes. When they question, where is it, along with the memo, I think. Yes, yes.
Yes.
Please, my lords. Then the last submission, my lords, is that from Ram Javaya Kapoor, etc., executive policy making under 73 cannot take away or impinge upon any right, much less a fundamental right. It can only fill in the gaps where, for instance, my lords, in Ram Javaya Kapoor's case, it was a case of printing of textbooks by NCERT, which does not affect anybody's right. Just on the last point, my lords, may I? On the last point, my lords, I will just show one judgment that, therefore, even assuming it were executive legislation, Ram Javaya Kapoor.
But one set is there.
Yeah. Lords, in the written submissions, I have extracted Ram Leela Maidan para 30, where they say if any fundamental right is to be invaded into, then it has to be done by way of statute made law and not by way of executive made law. That would be my respectful submission by my lords.
As regards the guidelines.
As regards the guidelines. Yes. Then, my lords, there is one judgment, if your lordship permits me, my lord, that I will cite. Here is my marked copy. This is on, lords, some in respect to coastal regulation zone and environment, policy was made, guidelines were made, and object perhaps, my lords, was the object was not frowned upon. Nevertheless, my lords, the Honorable Supreme Court says, your lordship may kindly see, my lords, para 2, as to the brief facts. The constructions raised by the appellants are not per se illegal in the conventional sense. They are not without permission and sanction of the competent authority. What has been alleged by the state and has been approved by the High Court is that such constructions are in derogation of the environmental guidelines in force, warranting demolition of the same as a step to safeguard the environment of the beaches in Goa. Specifically, it is the case of state that the constructions in question are between so and so from high tide line, etc. Therefore, my lords, what was squarely in question was the validity of the guidelines. Then, my lords, in para 11,
yes.
In para 11, my lords, Sri so and so learned counsel appearing for the respondent NGO Goa Foundation has submitted that the letter dated so and so, the guidelines as well as the guidelines of 1986 have to be construed to be law within the meaning of Article 73 of the Constitution. Therefore, this specific submission was indeed made. Then, my lords, it is answered in para 14 onwards. In fact, there is reference to Ram Javaya Kapoor also, my lords, that there is certainly power to make or lay down policy in para 12.
Yes.
Please, my lords. Then your lordship may kindly turn to para 14 onwards, where there is a discussion. The cases of the respective parties having been noticed, the necessary discourse may now commence. In Bennett Coleman, a newsprint policy notified by the central government for imposing conditions on import of newsprint came to be challenged on the ground of violation of fundamental rights. Begg in a concurring judgment observed, what is termed policy can become justiciable when it exhibits itself in the shape of even purported law. According to 13(3) of the Constitution, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. So long as the policy remains in the realm of even rules framed for the guidance of executive and administrative authorities, it may bind those authorities as declarations of what they are expected to do under it, but it cannot bind citizens unless the impugned policy is shown to have acquired the force of law. The question then is, what is law has perplexed many a jurisprudent, yet the search for the elusive definition continues. It may be unwise to posit an answer to the question. Rather, one may proceed by examining the points of consensus in jurisprudential theories. Thereafter, what appears to be common to all these theories is the notion that law must possess a certain form, contain a clear mandate stroke explicit command, which may be prescriptive, permissive, or penal, and the law must also seek to achieve a clearly identifiable purpose. While the form itself or absence thereof will not be determinative and its impact has to be considered as a lending or supporting force, the disclosure of a clear mandate and purpose is indispensable. It may therefore be understood that a government policy may acquire the force of law if it conforms to a certain form possessed by other laws in force and encapsulates a mandate and discloses a specific purpose. It is from the aforesaid prescription that the guidelines relied upon by the union in this case will have to be examined to determine. Then my lord may kindly see para 19. Article 77, 19 notes. Article 77 of the Constitution provides the form in which executive must make and authenticate its orders and decisions. Clause 1 of Article 77 provides that all executive action of the government must be expressed to be taken in the name of the President. The celebrated author H.M. Sirvai in Constitutional Law describes the consequences of government orders or instructions not being in accordance with clauses 1 or 2 of 77 by opining that the same would deprive the orders of the immunity conferred by the aforesaid clauses, and they may be open to challenge on the ground that they have not been made by or under the authority of the President, in which case the burden would be on the government to show that they were in fact so made. In the present case, the said burden has not been discharged in any manner whatsoever. The decision in Air India taking a somewhat different view can perhaps be explained by the fact that in the said case, the impugned directions contained in the government letter, not expressed in the name of the President, was in exercise of statutory power under 34 of the Air Corporations Act 1953. In the present case, the impugned guidelines have not been issued under any existing statute. Clause 2 of 77 also provides for authentication of orders and instruments in a manner as may be prescribed by the rules. In this regard, YD SO dated so and so published in the Gazette of India, the President has issued the authentication order rules. The said rules have been superseded and subsequently in 2002. Admittedly, the provisions of the said 1958 rules have not been followed in the present case insofar as promulgation of guidelines is concerned. Therefore, in para 21, the conclusion is, in the absence of due authentication and promulgation of the guidelines, the contents thereof cannot be treated as an order of the government and would really represent an expression of opinion. Then, my lords, para 24, the Honorable Supreme Court also appears to indicate that such guidelines may have to be published in the Gazette. Although it is not prescriptive, that seems to be the indication. It will not be necessary to notice the long line of decisions reiterating the aforesaid view. So far as the mode of publication is concerned, it has been consistently held by this court that such mode must be prescribed by the statute. In the event the statute does not contain any prescription, and even under subordinate legislation there is silence in the matter, the legislation will take effect only when it is published through the customarily recognized official channel, namely the official gazette. Admittedly, the guidelines were not gazetted. If the guidelines relied upon by the union in the present case fail to satisfy the essential and vital parameters, requirements of law as the trend of the above discussion would go to show, the same cannot be enforced to the prejudice of the appellant as has been done in the present case. Give me the affidavit.
Yes.
Not in the affidavit filed by the center. They don't say it is made by the president. Therefore, my lords, it comes within the prohibition of the decision of the Honorable Supreme Court. Then, my lords, that one paragraph from Ram Leela Maidan at para 13.30. Para 30, my lords, they summarize the law, Ram Leela Maidan. No person can be divested of his fundamental rights. They are incapable of being taken away or abridged. All that the state can do by exercise of its legislative power is to regulate these rights by imposition of reasonable restrictions upon them. Upon an analysis of the law, the following tests emerge. A, the restriction can be imposed only by or under the authority of law. It cannot be imposed by exercise of executive power without any law to back it up. What's the last on this is in the decision of the Honorable Supreme Court, there was reference to the authentication rules of 1958, which are remade in the year 2002. These are rules, my lords, made under 77(2). If I may just read the first paragraph. In exercise of the powers conferred by clause 2 of article 77 of the Constitution and in supersession of the authentication orders and other instruments rules, except as respect things done before the supersession, the President is pleased to make the following rules, namely the rule set. Then rule 2 may kindly be seen. They shall come into force on the date of publication in the official gazette. Then, my lords, all orders and other instruments made and executed in the name of the President shall be authenticated, one, by the signature of a secretary so and so or under secretary to Government of India. And then, my lords, they prescribe how this authentication has to be done. And, my lords, if your lordship will kindly turn to internal page 20.
Because I think the question that he's raising should be signed by the secretary.
There, my lords, Health and Family Welfare, Department of Health. Internal page 20 on the left hand side, last but one entry.
This is my friend.
Directorate General of Health Services, Director Administration and Vigilance, Deputy Director Administration.
It's been produced.
Present guidelines, my lords. Guidelines. Are signed, my lords, by. There is a message, but there is no authentication. There is a message. There is message, there is preface, there is foreword, but it is not. There are acknowledgements from high-ranking officers who may fall, my lords, within this definition. But this does not contain their authentication in any manner. And, my lords, the critical component of rule 2 is also not met. It is the same page as court number. Page number of court. The last page is, my lords, at 218. There is no signature there. They are annexures. 216.
Last is 216.
216.
216 is the reference.
Please. Which is why, my lords, and these rules, the last page of the document itself.
Annexures. Annexure. Appendix.
No, appendices. Lords, section 3 is where the appendix begins. The section 2 ends at internal page 52. Even there is no legend saying this is authenticated or signed.
145 doesn't have it. Yes.
But the last point on these authentication rules is rule 2. That would be, my lords, page 147. In these rules, they say, my lords, they shall come in rule 2. It is not printed in a correct way. Rule 2 first line says they shall come into force on the date of publication in the official gazette. That refers to these very rules. Then, my lords, the second portion where it begins, all orders and other instruments made and executed in the name of the president shall be authenticated.
By the.
Therefore, my lords, the first requirement is it must be made and executed in the name of the president on behalf of the president. An authorized officer, in accordance with these authentication rules, can authenticate it. These are not made and executed in the name of the president.
Yes.
That would be my submission with regard to these guidelines.
Yes, Mr. Kam.
Lord, in the Constitution, would your Lordship have a look at first the directive principles, Article 39.
Article
39, Part 4.
Yes.
Item clause E. State shall in particular direct its policy towards securing the health and strength of workers, men and women. So I am emphasizing on health of women and tender age of children are not abused, and that citizens are not forced by economic necessity to enter into avocations unsuited to their age or strength. So inducing a woman, a mother, to part with her donor milk can constitute forcing her by economic necessity. So therefore there is one of the principles that I need to follow as a state is covered there. Also Article 47.
Yes.
The Article 47, the Constitution, Lord, mandates the state to raise the level of nutrition and standard of living and to improve public health. It says the state shall regard the raising of level of nutrition and standard of living of its people and improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of consumption except for medical purposes, intoxicating drinks or drugs which are injurious to health. So raising the level of nutrition, the standard of living, Lord, this also covered here. Next, would your Lordship kindly have a look at Article 73, which deals with the extent to which the executive power of the union can be exercised. It's titled as extent of the executive power of the union.
Which one are you referring?
73, my lord. 73.
Yes.
73. Subject to the provisions of this constitution, the executive power of the union shall extend to the matters with which the parliament has got the power to make laws.
Your power is not under dispute. It is only the form. From what we understand from Mr. Kulkarni, that the power, if you have excised, has to be excised in a particular form. And that form is not there in the.
In fact, I have even filed.
Guidelines are not.
Along with the, no, those kinds are followed. It is approved by the secretary. There is no.
So that if you place it, that argument goes.
I think while your lordships were sitting in Dharwad, I filed a memo. I'll pull it out in a minute. We have produced some documents to show that there is approval of the government.
Yes,
yes,
we show that.
Yes.
The only thing that he is speaking of is authentication in terms of the authentication rules. It is to be made in the name of the president if it is a rule under 73.
True.
With a policy under 39 or 47, that's a different thing. If you place the bar as high as 73, It would have to be made by the president or in the name of the president. If you lower the bar to 39 and 47, there is a policy which has to be done by that particular department.
True. No, I would say, I would like to use both. As a policy in pursuance of the directive principles, as also exercise of executive power under 73 to come out with the executive legislation.
73 would be a little high. If it is to be made in the name of the president, you'll have to place that on record. Secretary will not do.
Lord, I have during March 2025, Lord, I have filed along with my affidavit, I have produced a confirmation by the Deputy Commissioner of that ministry. Finding out.
Yeah, I have it ready.
Data mining.
Just give us a convenience set. If you have filed so much of documents, give us a convenience set.
All right, sir.
I will do that.
Like a needle in the haystack, or even worse. You have filed the affidavit of the assistant director in charge. Is that what you want to refer to?
I'm sorry, Lord?
The affidavit of the assistant director in charge, Central Ayurveda Research.
Yes. In that, my Lord, annexure R3A, Lord, this communication issued by the Deputy Commissioner of the Ministry of Health. And he says, dear sir, this is in reference to DO letter from the Secretary, Ministry of Ayush, to Secretary, Ministry of Health and Family Welfare regarding WP number so-and-so, which your lordships are hearing now. In this regard, I have been directed to inform you that the national guidelines on lactation management centers were framed for ensuring availability of mother's own milk or donor human milk for newborn babies admitted in public health facilities, especially the low birth weight pattern and sick newborn. These guidelines were framed after deliberate discussion and discussion by the technical resource group comprised of renowned subject experts, specialists in the field and professional organization. List of experts is attached as Annexure 1. The guidelines were released in June 2017 after following due process and approval of the competent authority, the Secretary, Ministry of Health and Family Welfare. So therefore, my lord, the due process and approval of the competent authority has been obtained. So therefore, that the guidelines that my learned friend just referred to, issued by the MHA, has been followed. Essential features of the guidelines, along with the details of the non-commercialization of human milk, as given in the national guidelines of lactation management centers in public health, are attached. So therefore, my lord, in form as well as spirit, the prescribed and stipulated rules have been followed. Therefore, my respectful submission is that the national guidelines would constitute law for the purpose of obtaining donor human milk. Minus this, my lord, it can be chaotic. In the sense, there is no other guideline which deals with how lactation centers are to be managed, and companies like the petitioner will take advantage of that. Now, my respectful submission is that on the merits, my lord, the claim of the petitioner that the mother's milk is a medicine is incorrect. I would say that mother's milk is food. It is food for the baby. It may have certain medicinal and therapeutic value, but it is food. And even for obtaining the trademark, for the name of Neolacta, the writ petitioner has classified it as food.
That you have taken us.
And I have produced a copy of that, my lord, which your lordship.
That you have taken.
I think we should file a convenience volume.
Convenience volume 1, Marty. You can file your written submission with convenience volume.
With this,
it will not be filed. Half the documents are not required.
This looks like a Burj Khalifa now.
I'll do that, my lords. I'll coordinate with them and we'll file a convenience volume and common page number.
Or do you file your written submission with your document? They'll file your coordination.
Because all the documents that I'm referring to are somewhere here, there. So
all these arguments are done. Only now this guidelines was there. Anything else you want to cover in your written submission, you can cover.
More importantly, my lord, my respectful submission here would be that the manner in which the writ petitioner is obtaining the milk. Now, in the first place, the writ petitioner did not disclose the manner in which he was collecting. Only after your lordship's direction, information started trickling in. Initially, a submission was made, or rather it was projected through the writ petition that there is no incentivization. But later we see from the disclosures made, there are vegetables given, fruits given, Flipkart vouchers are given.
Coupons are given.
Yeah, so therefore, my lord, there is definite incentivization, and the amount of money that we have all covered it on return submissions. Large scale money is received by the two NGOs, and there is no explanation to it. Lakhs of rupees in the name of conduct of some campaigns, and both are commercial entities. The petitioner is a commercial entity for profit, and the NGOs also are profit, and there is no proper explanation for the money received. So therefore, that would be a significant aspect that your lordships would have to consider on the on the right of the writ petitioner to seek discretionary relief from your lordship. So that entitlement. So therefore, my respectful submission would be that petitioner is disentitled in seeking any relief, and that the license was given wrongly in violation of the Drugs and Cosmetics Act, and the center has very rightly intervened by exercising its powers under section 33P. And therefore, in compliance with that, the state, having given an opportunity of being heard, has rightly withdrawn. So therefore, there is no scope for interference.
At the same time, my lord, all the appeals filed in the statutory remedy, those are still pending, where no action has been taken. While those are pending, these writ petitions are put in place.
My lords, as far as state is concerned, beyond the scope of the guidelines of central government, if my lords just examines it from the Drugs and Cosmetics Act, even it doesn't come within the purview of section 3H under which they are claiming a license is given. That is the proprietary medicine, and whether what are the, it actually speaks of the ingredients in a particular medicine. Are they saying they're selling it as a drug? And what is the ingredient and to which book do they refer to? It is argued before my lords that Ayurvedic text, please, 3H and 3A, they're not followed. That is the reason they have, till now they have not established before my lords. It is mother's milk is used as an ingredient. They're making it itself as a product, which cannot be done under the Drugs and Cost. Even under the Act, they do not have a right to manufacture something like this and sell. So that is the case.
Has to be
please
the ingredient, not the whole of
please, that is the sin. That is the whole thing. For them to stand before my lords and argue that there is a license for a particular product, under which provision and what is it that you're manufacturing? They have to first satisfy that to my lords and then go beyond the whether mothers.
How much time will you take?
20 minutes. I will try. I will do my best because my submission is on the petition.
20 minutes, not today, Monday.
My lord would have said it today and tomorrow. My lord would hear it at 4:30. My lord would permit me to commence. My lord would permit me to commence.
A meeting had been fixed, so 5:15 that meeting is there. So we have to write 5 o'clock. It is there. We are already late for that.
My lord, tomorrow. My lord has anyway scheduled it for tomorrow at 4:30. My lord has said 27th and 28th continuity arguments. Only my arguments are left. My lord.
Release tomorrow. Heard Shri Manu Kulkarni, learned counsel for the petitioner, Shri Arvind Kamath, learned DSGI, Ms. Pratibha Vannapura, learned Additional Advocate General, Shri Doreraj H, learned counsel for FSSI, released tomorrow for arguments of the impleading applicant.
My lords, sir, synopsis may be taken on record. My lords, the synopsis I have already filed. It may be taken on record.
My lord, interim order may be extended.
Synopsis filed by learned Additional Advocate General is taken on record.
Great.
Interim order earlier granted is extended.
Lord, I have also filed written submissions.
What did you file?
Written submissions.
Written submission you filed today?
Just normal.
But you'll have to file it along with
then, my lords, I'll refile it with convenience.
and give it, please.
I have one submission to make, my lord.
Serial number 95, my lord. One submission with respect to serial number 100. My lords,
Urgency is there. It is listed in the orders group to comply with some office objective.
Please comply.
Registry may be directed to list it on Monday for admission.
How can we do that without 100 and what is the number?
Some objections.
What is the serial number?
Say 130.
130 registries direct post the matter before the
my lords,
concerned registrar.
Serial number 100. My lords, serial number 100.
Memo for withdrawal, please, Manoj.
Not tomorrow, Monday, Tuesday, Wednesday.
My lords, memo for withdrawal, please. Serial number 100.
My lord, serial number 66, my lord.
What do you want?
I would like to have it on Tuesday, is it possible?
56 Tuesday.
Lord, serial number
Date
100.
was-
My lord, serial number 66, my lord.
Only thing, don't ask for it to reach. Whichever reaches, we'll take it.
My lord, serial number 100. Senior counsel just.
My lord,
mentioned
serial
in
number
230.
66, my lord.
ಯಾವ date ಬೇಕು ಆ date.
My lord, one
My
submission,
lord.
serial number 36, delivery of possession, my lord, yesterday it was there, it was posted to
ಯಾವ date?
36.
My lord, serial number 66.
ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹಾಕಿ ಅಂತ ನಾಳೆ ಬರಲ್ಲ ಲಿಸ್ಟ್ ಆಗೋಗಿರುತ್ತೆ ಮಂಡೇ ಬರ್ಬೋದು
Court sir, item number 61 is on date ಕೊಡಿಯಮ್ಮ.
ಫೈಲ್ ನಾಳೆ ಕಳಿಸ್ತೀವಿ ಆಮೇಲೆ ಲಿಸ್ಟ್
Madam, serial number 44.
Item number 61 is on date ಕೊಡಿ ದಯವಿಟ್ಟು.
ಒಂದ್ ಲೈನ್ ಆಗಿ ಬರ್ತೀನಿ ಸೀರಿಯಲ್ ವೈಸ್ ಬರ್ತೀನಿ
ಹಾ.
ಪೇಜ್ ವೈಸ್ ಬರ್ತೀನಿ ಸೀರಿಯಲ್ ವೈಸ್ ಬರ್ತೀನಿ ಒಂದ್ ನಿಮಿಷ ಸರ್ ಪೇಜ್ ವೈಸ್ ಕರಿತೀನಿ ನಿಮ್ ಸೀರಿಯಲ್ ಬಂದಾಗ ಹೇಳಿ
ಹೇಳ್ತೀನಮ್ಮ ಹೇಳ್ತೀನಿ.
ಪೇಜ್ ನಂಬರ್ 5 ಸೀರಿಯಲ್ ನಂಬರ್ 34 to 36 ಯಾವತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಅದೇ ನೀವ್ ಯಾವತ್ ಕಾಯ್ತೀರಾ ಆ ಡೇಟ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. ಯಾವತ್ ಕಾಯ್ತೀರಾ? ಬುಧವಾರ ಕಾಯ್ತೀರಾ? ಬುಧವಾರ ಮೀನ್ಸ್ 3 ಆಯ್ತು. 34 35 ನಾನ್ ಜನವರಿ ಕೊಡೋದು ಜನವರಿ ಸ್ವಲ್ಪ ಏನಿಲ್ಲ ಕಾಯೋದಷ್ಟೇ. ಯಾವತ್ ಕಾಯ್ತೀರಾ ಹೇಳಿ ಡೇಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಒಂದ್ ಡೇಟ್ ಹೇಳಿ. ಬೇಗ ಮುಗಿಸಿ ಮುಂದಕ್ಕೆ ಹೋಗ್ತೀನಿ. 36 ನಾಳೆನೂ ಹಂಗೆ ಕಾಯ್ಬೇಕು. ನಾಳೆ 492 ಮ್ಯಾಟರ್ಸ್ ಇದೆ. 38 ಪಿಟಿಷನರ ನೀವು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ ಏನಕ್ಕೆ ಶಾರ್ಟ್ ಡೇಟು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ ಇನ್ನ. ಯಾವತ್ ಕಾಯ್ತೀರಾ? 4th ಯಾವ್ದು ಇಲ್ಲ. ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಮಾತ್ರ ನಾಳೆ ಇಲ್ಲ. ಮಂಡೆಗೆ ಹಾಕೋಣ ಅಲ್ವಾ? ಮಂಡೆಗೆ ಹಾಕೋಣ. ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಮಂಡೆ. 39 ಯಾವತ್ತು? ಅದೇ ರೀಚ್ ಆಗಲ್ಲ. ಕರೆಕ್ಟ್ ಆಗಿ ಡೇಟ್ ಹೇಳ್ಬೇಕು. ಕಾಯ್ಬೇಕಲ್ಲ ನೀವು ಹೇಳಿ. ವೆಕೇಶನ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ 40 41 42 10th ಡಿಸೆಂಬರ್ 43 ಯಾವುದು ಅವತ್ತೇ ಬರ್ಲಾ? 11th ಡಿಸೆಂಬರ್ ಇದೆ ಸರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. 43 ಹೇಳದ್ದಲ್ಲ ಈಗ 11 ಡಿಸೆಂಬರ್. 44 412 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲಪ್ಪ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ.
ಇಲ್ಲ 95 years old madam.
45 46 ಯಾವುದು? 46 10th 47
ಮೇಡಮ್ 47 ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಒಂದು
ಯಾವತ್ತು ಬೇಕು?
ಎನಿ ಡೇಟ್ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಜಾನ್ವರಿ 21
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಅದಕ್ಕೆ
ಡೇಟ್
ಡೇಟ್
ಕೊಡಿ
ಹೇಳಿ
ಮೇಡಮ್.
ಅಂದಿದ್ದು.
10th ಕೊಡಿ ಮೇಡಮ್.
ಲಾಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಬೇಡ ಸುಮ್ಮನೆ. 48 49 50 51 ಯಾವತ್ತು? 20th ಜಾನ್ವರಿ 21st ನೆನ್ನೆ 20th ಕೊಟ್ಟಿದ್ದೀನಿ. 52 ಯಾವುದು? 49 ಯಾವತ್ತು? ಜನವರಿ 21st.
52
ಯಾವ ಫೈಲ್ ಬೇಕಂತೆ? ಎತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿದ್ದೀನಲ್ಲ ನಾನು ಹೆಂಗ್ ಎತ್ಕೊಂಡು ಕೂತ್ಕೊಂಡೆ ಫೋನ್ನ. ಯಾವ ಫೈಲ್ ಬೇಕಂತ ಕೇಳಪ್ಪ ನೀವ್.
ಮೇಡಮ್ 52 ಟ್ಯೂಸ್ಡೇ 2:30 ಲಿಸ್ಟ್ ಕೊಡಿ ದಯವಿಟ್ಟು. ಅದು ಎಂಟ್ರಿ
2nd
ಮಾಡಿಲ್ಲ.
ಡಿಸೆಂಬರ್ ಅಷ್ಟೇ ಸರ್. 2:30 ಎಲ್ಲ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು.
ಸೆಕೆಂಡ್
ಅಷ್ಟೇ list
ಟ್ರಯಲ್
ಅಲ್ಲಿ
ಕೋರ್ಟ್
ಇರುತ್ತೆ.
ಒಳಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ
ಅದೇ
ಸೆಕೆಂಡ್.
ಸೆಕೆಂಡ್ ಬರುತ್ತೆ ಗೊತ್ತಿಲ್ಲ ನಂಗೆ ರೀಚ್ ಆಗೋದು. 2:30 ಎಲ್ಲ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು. 53
ಯಾವತ್ತು ಹೋಯ್ತು? 52
2nd ಡಿಸೆಂಬರ್ ಹಾಕಿದೀನಿ ಸರ್. 51 ಎಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಡೇಟ್ 21st ಜಾನ್ವರಿ. 54 ನಾಳೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿದೆ ಏನಕ್ಕೆ ನಾಳೆ? ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಬೇಡ ಅಂತ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಲ್ಲ. ಒಂದಿನಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿರಲ್ಲ ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಕೊಡಲ್ಲ ನಾಳೆಗೆ. ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ ಟೈಮ್, ಮುಂದಕ್ಕೆ ಹೋಗ್ತೀನಿ ನಾನು ಆಮೇಲೆ ಮಾತಾಡೋಣ. 56 2nd December, 57, 58, 59, 61,
61 ಮೇಡಮ್.
ಯಾವತ್ ಸರ್?
ಯಾವತ್ ರೀಚ್ ಆಗುತ್ತೆ ಅವತ್ ಕೊಡಿ ತಾಯಿ.
ಜನವರಿ ಫಸ್ಟ್ ವೀಕ್.
ಡಿಸೆಂಬರ್ ನಲ್ಲಿ ಒಂದ್ ಡೇಟ್ ಕೊಡಿ, ರೀಚ್ ಮಾಡಿಸಿ ಅವತ್ತು.
ಹೇಳಿ ಡೇಟ್ ಹೇಳಿ, ಗೊತ್ತಿಲ್ಲ ರೀಚ್ ಆಗೋದು, ಡೇಟ್ ಮಾತ್ರ ಹೇಳಿ.
ಫಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ತಮಗೆ ಕನ್ವೀನಿಯಂಟ್ ಇದ್ದದ್ದು.
4th December.
ಒಬ್ಲೈಜ್ ಮೇಡಮ್.
ಅವತ್ತು ಕಾಯ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ, ಡೇಟ್ ಕೊಟ್ಟಿದೆ.
ಕಾಯ್ತೀನಿ ಕಾಯೋದು ನಮ್ ಧರ್ಮ ಅಮ್ಮ.
ಆಯ್ತು ಸರ್. 63 8th ಏನ್ ವಾರ? ಆಗ್ಬೋದು. 64, 65, 66 ನಾಳೆ ರೀಚ್ ಆಗಲ್ಲ, ಇರ್ಲಿ ಎಮರ್ಜೆನ್ಸಿ ಕಾಯ್ರಿ ಅಷ್ಟೇ. 68 ನಾಳೆನೆ ಆದ್ರೆ ಕಾಯ್ಬೇಕು. ಅದು ಸಿಸ್ಟಮ್ ಜನರೇಟ್ ಆಗುತ್ತೆ ಸರ್. ನಿಮ್ದು ಎಷ್ಟು 28,000 ಅಲ್ವಾ? 28,000 ಅಂದ್ರೆ ಎಲ್ಲಿಗೆ ಬರ್ಬೋದು ಹೇಳಿ? ಅದೆಲ್ಲ ಈಗ ಬೇಡ ಬಿಡಿ, ನಾಳೆ ಬರುತ್ತಷ್ಟೇ. ಯಾರು ಬಂದ್ರು ನಾಳೆ ಬರುತ್ತಷ್ಟೇ. ಇಲ್ಲ ಈಗ ನಾಳೆ ಬರುತ್ತೆ ಅಷ್ಟೇ, ಅದಕ್ಕಿಂತ ನಾನು ಇನ್ನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ 68, 69, 70. ಯಾವ್ದು 70ನಾ? 70 Tuesday 2nd December. 71 12 December. 72 after vacation 21st January. ಹಾ ಸರ್ ಇದೆ, ಎಂಟ್ರಿ ಮಾಡಿದೆ. ಏನಂತೆ ಫೈಲ್ ಯಾವ್ದಂತೆ? ಅದೇ ರಿಸರ್ವ್ ಆಯ್ತಲ್ಲ, ಅದೇನೇಪ ಕ್ರಿಕೆಟ್ ಅಸೋಸಿಯೇಷನ್ ರಿಸರ್ವ್ ಆಯ್ತಲ್ವಾ? 73 ಬರ್ತಾ ಇದೀನಿ ಸೀರಿಯಲ್ ಆಗಿ. 73, 74
74
2nd December. 75 ಯಾವತ್ತು? 21st January. ರೀಚ್ ಆಗಲ್ಲ. 77, 78, 79
ಮೇಡಮ್.
ಹೇಳಿ ನೀವೇ ಕಾಯೋದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ 4th December.
ಮೇಡಮ್ 79 ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು.
ಯಾವಾಗ ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ?
ನಾಳೆನೆ ಮಾಡ್ತೀವಿ.
ನಾಳೆ ಮಂಡೇ.
ಆಯ್ತು.
ಮಂಡೇ ನಾನಿಲ್ಲ, ದಯವಿಟ್ಟು ನಾಳೆ ಹಾಕ್ತೀರಾ?
ವಿಡ್ರಾ ಅಂತೆ ಸರ್, ನೀವೇ ಬಿಡಿ ಸರ್, ವಿಡ್ರಾ ಮಾಡ್ತಾರಂತೆ. 80, 15 December. 81, 82, 21st January ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ. 83, 84 ಯಾವತ್ತು? ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದ್ಮೇಲೆ ಏನಕ್ಕೆ ಬೇಕು? ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ. ಜನವರಿ ರೀಚ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಯಾವತ್ತಿಗೆ? ಏನಪ್ಪ ಫ್ರೈಡೆ ಬೇಡ, ಫ್ರೈಡೆ CMP ತಗೋತಾರೆ. ಫ್ರೈಡೆ CMP ಮಾತ್ರ 10th December. 85, 10th December. 5th ಇಲ್ಲ, ಬರೀ CMP ತಗೊಳೋದು. ಫ್ರೈಡೆ CMP ಮಾತ್ರ ತಗೊಳೋದು. 85, 86, 87.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್
87,
86 ಮೇಡಮ್.
86 ಯಾವತ್ ಬೇಕು ಸರ್?
10th ಹಾಕೊಡಿ ಮೇಡಮ್. 10th ಕೊಡಿ ಮೇಡಮ್.
10th December. ಆಯ್ತು ಸರ್,
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಲಿ ಮೇಡಮ್.
ಹಾ ಸರ್, ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಏನ್ ಆಗಲ್ಲ, ಅದು ಅಬ್ಸಲ್ಯೂಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲ್ಲ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
87 ಯಾವುದು? 87 ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಇಲ್ಲ ನಾಳೆ ಇಲ್ಲ, ಬೇರೆ ಡೇಟ್ ಹೇಳಿ. 4th. 88 ಎಂಟ್ರಿ ಮಾಡಿರಿದಿಲ್ಲ, ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ. ಆಯ್ತು, ರೀಚ್ ಆಗಲ್ಲ. ಇಬ್ರು ಸೇರಿ ಒಂದೇ ಡೇಟ್ ಹೇಳಿ, ಯಾವ್ದು ಅಂತ ನನಗೂ ಗೊತ್ತಿಲ್ಲ. 4th. 89, 9th ಕಾಯ್ಬೇಕು. 90 ಯಾವ್ದ್ರಲ್ಲಿ? 89 ಎಂಟ್ರಿ. 90 ಯಾವತ್ತು? 3rd December. ರೀಚ್ ಆಗಲ್ಲ ಅವತ್ತು. 91 10th. ಹಾ ಸರ್, ಡಿಸೆಂಬರ್. 92, 93, 94, 95.
95 ಫಸ್ಟ್ ಗೆ ಕೊಡಿ ಮೇಡಮ್. 95
8th ಅದೆಲ್ಲ ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ ಸರ್. ಇದೇ ತರ ಸೇಮ್ ಮ್ಯಾಟ್ರಸ್ 2nd December ಗೆ.
ಸೆಕೆಂಡ್. ಓಕೆ ಫೈನ್.
ಅವತ್ತು ಬರುತ್ತೆ ಎಲ್ಲ ಸೇಮ್ ಮ್ಯಾಟ್ರಸ್. 97, 98, 99, 100. ಯಾವುದು 100 ನಾಳೆನಾ? ನಾಳೆ ಅದೇ CMP ಕೆಲವರು. 101, 102 ಯಾವ್ದು 102ನಾ? ಎಲ್ಲಿ ವೆಕೇಟಿಂಗ್ ರೀಕಾಲಿಂಗ್ ಅದು ಯಾವತ್ತು? ಅಲ್ಲ ಯಾವತ್ ಕಾಯ್ತೀರಾ? ಇನ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ. ನಾಳೆ ಇವತ್ತು ಕಾಯ್ದಿದ್ದೀರಾ, ನಾಳೆ ಯಾಕೆ ಕಾಯ್ತೀರಾ? ಹಾ ಸರಿ ಸರಿ. ನಾಳೆನಾ ಕಾಯ್ತೀರಾ? ಐಎನಲ್ಲಿ ಬರುತ್ತೆ, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಕಾಯ್ತೀರಾ? ಐಎ ಎಲ್ಲ ಬರೋದೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ, ಕಾಯ್ತೀರಾ? ಅವರು ಸೆಕೆಂಡ್ ಹೇಳಿದ್ರು, ಇಬ್ರು ಸೇರಿ ಒಂದೇ ಡೇಟ್ ಹೇಳಿ. ಇದು ಆ ಹುಡುಗಿಗೆ ಫೈಲ್ ಕೊಟ್ಬಿಡಿ, ಅದು ಅರೇಂಜ್ ಮಾಡ್ಕೊಂಡು. ಇಲ್ಲಿದೆ ಹಿಂದೆ ತಗೊಂಡಿದ್ದಾರೆ. ಅದು ಇದಿಷ್ಟು ಕಣಮ್ಮ, ಡೇಟ್ ವೈಸೇ ಇಡಿ. ಕನೆಕ್ಟೆಡ್ 3 ಫೈಲ್ ಇದೆ, 3 ಫೈಲ್ನು ಡೇಟ್ ವೈಸೇ ಇಡಿ. ನೀವು ಡೇಟ್ ಹೇಳ್ಬಿಡಿ, ಅವರು ಡೇಟ್ ವೈಸ್ ಇಡ್ತಾರೆ ಅಷ್ಟೇ. ಆ ಯಾವ ಡೇಟ್ದು ಅಂತ ಒಂದ್ ರ್ಯಾಪರ್ ಅಲ್ಲಿ ಅಕ್ಕಿ ಸುತ್ತಿಟ್ರು ಆಯ್ತು, ತಕ್ಷಣ ತೆಗಿಬೋದು. ಯಾಕೆ ಹಿಂದಕ್ಕೆ ಹೋಗ್ಬೇಕು ಮತ್ತೆ? 49 ಯಾವತ್ತು? ಮುಂದೆ ಹೋಗೋಣ, ಎಲ್ಲ ಕಾಯ್ತಾ ಇದ್ದಾರೆ. 21 ಜಾನ್ವರಿ. 101 ಯಾರು ಇಲ್ಲ. 103, 104, 105, 106, 106. ಟಾಪ್ ಎಲ್ಲ ಇಲ್ಲ. ನಾಳೆಗ್ ಬರ್ಬೇಕಾ? ನಾಳೆ ಇಲ್ಲ, ಮಂಡೇ. ನೀವಿಲ್ವೇ ಇಲ್ಲ ಅಲ್ಲಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ತಾನೆ, ಬಿಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ತಾನೆ. ಯಾವತ್ ಕಾಯೋದು ಹೇಳಿ? ಹೋಗಿ ಎರಡೇ ಹಾಕ್ತೀನಿ. ಟಾಪ್ ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನನಗೆ, ಬರುತ್ತೆ ಅಷ್ಟೇ. 107, 109. ಹೌದು. ಇವಾಗ 212. 109, 110 ಯಾವತ್ತು? 111, 12 ಯಾವತ್ತು? 24th ಅಲ್ಲ, ಸ್ಯಾಟರ್ಡೆ ಅದು. 114, 114 ಇದ್ರೆ ಆಗುತ್ತೆ, 114, 115, 116, 117, 118, 119, 120, 121, 22, 21 ಯಾವತ್ತು ಸರ್? 4 ಹಾಕ್ತೀವಿ, 2 ಜಾಸ್ತಿ. 119 ಯಾವತ್ತು ಬೇಕು? ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ? ಹಾಕ್ಬೇಕಾ? ಹಾಕ್ಬೇಕು. ಅಷ್ಟ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀರಾ? ಈಗ ಯಾವ ಡೇಟ್ ಬೇಕು? ಅದೇ ಯಾವತ್ತು ಹಾಕ್ಲಿ ಹೇಳಿ. ಯಾವತ್ತು ರೀಚ್ ಆಗಲ್ಲ. ಅಲ್ಲ, ಈಗ ನೀವೇನ್ ಡೇಟ್ ಇವಾಗ ಡಿಸೆಂಬರ್ ಅಂತ ತಗೊಂಡ್ರೆ ಯಾವತ್ತು ರೀಚ್ ಆಗಲ್ಲ. ನೀವು ಕಾಯೋ ಡೇಟ್ ಹೇಳಿ, ಅವತ್ತು ತಗೊಳ್ಳಿ. 21 ಜನವರಿ. 120 ಇಲ್ಲ, 120 ಕೊಡ್ಲಿಲ್ಲ. 121 ಕೊಟ್ಟಿದ್ದು. 122 3, 123, 125, 126, 128, 129, 127 ಇಲ್ಲ, ಡೇಟ್ ಹೇಳಿ.
128.
R5 ಯಾರೋ ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅಂತಲ್ಲ, ಅದಕ್ಕೆ. ಏನ್ ಹೆಸರು? ನಿಮ್ಮ ಹೆಸರೇನು? ಅಲ್ಲ, ಅಡ್ವೊಕೇಟಾ ನೀವು? ವಕಾಲತ್ ಹಾಕಿರೋದು ಅವ್ರೇನಾ? R5ಗೆ ನೀವೇ ವಕಾಲತ್ ಹಾಕಿರೋದು. ಶರವಣನ್ ಜಿ ಅನ್ನೋರು ವಕಾಲತ್ R5ಗೆ ಹಾಕ್ತೀರಾ. ಯಾವತ್ ಬೇಕು ಡೇಟು? ಜನವರಿ, 21 ಜಾನ್ವರಿ. ಅಲ್ಲ, ಇವ್ರು ಕೇಳ್ತಿದಾರೆ ನೋಡಿ, R5. ಯಾವ್ದಾದ್ರು 9th ಡಿಸೆಂಬರ್ ಆಯ್ತು. 128,
128 ಮಂಡೇ. 128
ಯಾವತ್ ಬೇಕು ಸರ್? 128
ಫಸ್ಟಿಗೆ ಮೇಡಮ್.
ಫಸ್ಟಾ?
ಹೌದು.
ಆಯ್ತು ಆಯ್ತು, ಫಸ್ಟ್ ಆಯ್ತು. 8 ಒಂದ್ ಕಡೆಯಿಂದ ಬರ್ತೀನಿ. 85 ಯಾವತ್ ಬೇಕು ಸರ್? 21 ಜಾನ್ವರಿ. 58 ಯಾವತ್ ಬೇಕು? ಅಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಕಾಯ್ಬೇಕಲ್ಲ. ಅದಕ್ಕೆ ನೀವು ಕಾಯೋರು ನೀವೇ ಡೇಟ್. 21 ಜಾನ್ವರಿ. 40 ಯಾವತ್ ಬೇಕು ಸರ್? 3rd December. 57 ಯಾವತ್ ಬೇಕು? ಪಾಸ್ಟ್ ಓವರ್ ಯಾವತ್? ನಾಳೆ ಬೇಡ, ಮಂಡೇ ಹಾಕಲ್ವಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ ಬೇಡಪ್ಪ. ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ ಈಗೇನ್ ನಾಳೆನಾ? ಎಂಟ್ರಿ ಮಾಡಿ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಲ್ಲ, ಅದು ಪ್ರಾಬ್ಲಮ್, ಇನ್ನೇನಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿರುತ್ತಲ್ಲ ಒಂದಿನ ಕಟ್ ಆಗೋಗುತ್ತೆ, ಎಂಟ್ರಿ ಮಾಡಿರಲ್ಲ ಮಧ್ಯ ನಿಮ್ಗೆ. ಸರಿ, ನೆಕ್ಸ್ಟ್ ಸರ್ ಯಾವತ್ತು ಸರ್? ಯಾವತ್ತೂ ಆಗಲ್ಲ ಸರ್, ಡಿಸೆಂಬರ್ ಆಗಲ್ಲ. ನಿಮ್ದು 2ವರೆಗೆ ಅಂತ ಇರೋದಕ್ಕೆ ಆಗುತ್ತೆ, ರೀಚ್ ಆಗುತ್ತೆ. ಪಾಸ್ ಓವರ್ ತಗೋಬಾರ್ದು ಅಷ್ಟೇ, ರೀಚ್ ಆದಾಗ ಪಾಸ್ ಓವರ್ ಆಗುತ್ತೆ. 2:30ಗೆ ತಾನೇ ನಿಮ್ದೆಲ್ಲ ಬರೋದು, ಹಂಗಾಗಿ ರೀಚ್ ಆಗುತ್ತೆ. ಅದ್ರ ಟೈಮ್ ತಗೋಬಾರ್ದು, ಅವಾಗ ಪಾಸ್ ಓವರ್ ತಗೋಬಾರ್ದು. 17th ಲಾಸ್ಟ್ ದಿನಗಳು ಬೇಡ ಅನ್ಸುತ್ತೆ ಸರ್. ಬರೀ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರುಗಳು ಅದ್ರ ಮೇಲೆ ಇರುತ್ತೆ ಗಮನ. ಹೇಳಿ ಸರ್, ಬೇರೆ ಡೇಟ್ ಹೇಳಿ. 7 ಅದೇ ಇಬ್ರು ಸೇರಿ ಹೇಳಿ, ಗೌರ್ಮೆಂಟ್ ಅವರು. ಸರ್ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ, ಹಾಕಿರ್ತೀನಿ. 8 ಇನ್ನೊಂದು ಉಳ್ಕೊಂತು. 8 ಶ್ರೀಹರಿಗೆ ಹೇಳ್ತೀನಿ. 70 to 21st January. 75 21st January. ಅಲ್ಲ, ಜನವರಿ ಯಾವಾಗಾದ್ರೂ ತಗೊಳ್ಳಿ. 19 90 ಯಾವ ಡೇಟ್ ಹೇಳಿ, ನೀವೇ ಒಂದು ಹೇಳಿ ಡೇಟ್. ಅಲ್ಲ, ಅವ್ರು ಯಾರು 3rd ಕೇಳಿದ್ರಲ್ಲ, 3rd December ಕೇಳಿದ್ರಲ್ಲ. 3rd December ನೀವೇ ಕೇಳಿದ್ದ? ಅಲ್ಲ, 3rd December ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 65. ನಾನು ಅವಾಗ್ಲೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ದೆ, ಹೇಳ್ತಾ ಇದ್ದೆ ಕೇಳಿಸ್ಲಿಲ್ಲ. ಯಾವತ್ತು ಹೋಗಿದೆ?
ಅಲ್ಲ, ಯಾವತ್ತಿಗೂ ಹೋಗಿಲ್ಲ. ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ.
ಟೆಂಡರ್ ಮುಗ್ದೋಗುತ್ತೆ ಮೇಡಮ್, ಲೇಟೆಸ್ಟ್ ಮಂಡೇ ಕೊಡಕ್ ಆಗತ್ತಾ?
ಕೊಡ್ತೀನಿ, ಕಾಯ್ಬೇಕಷ್ಟೇ, ರೀಚ್ ಆಗಲ್ಲ.
ಓಕೆ, ಬಟ್ ಮಂಡೇ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲಿದೆ? ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಈಗೇನು ಕಳಿಸ್ತಾರಂತ? ಕಳ್ಸಿದ್ರಿ, ಇವಾಗ ಹೋಗುತ್ತೆ ಬಿಡಿ, ಈಗಲೇ ಕಳಿಸ್ತೀವಿ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಇದೆ ಹೆಂಗಿದ್ರು ನಮ್ದು. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಜೊತೆ ಅದು ಹೋಗುತ್ತೆ. ಅಲ್ಲ, ಬೋರ್ಡ್ಗೆ ಹೋಗಲ್ಲ, ಪೆಂಡಿಂಗ್ ಹೋಗುತ್ತೆ. ಅವರು ಹೌದು. ಹಾ, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಹೊಟ್ಟೋಯ್ತಾ? ಒಂದು ಡಿಸ್ಪೋಸಲ್ ಆಯ್ತು. ಡಿಸ್ಪೋಸಲ್ ಹೋಯ್ತಾ? ಡಿಸ್ಪೋಸಲ್ದು ಹೋಯ್ತಾ ಫೈಲು? ಏನ್ ನಂಬರ್? ನನ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು ನೀವು. 2 ಬರ್ಲಿ, ಬುಕ್ ಬಂದ್ಮೇಲೆ ನಂಗೆ ಒಂಚೂರು ಹೇಳಿ. ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಯಾರು ತಗೋತೀರ? ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಲಿಸ್ಟ್ ಏನೋ ಮಾಡಿಸ್ತೀವಿ. ಹೆಂಗಿದೆ ಹಂಗೆ ಬರುತ್ತೆ, ಸಪ್ರೇಟ್ ಲಿಸ್ಟೇ ಮಾಡುತ್ತೆ. ಇಟ್ಟೆಲ್ಲ ಮಾಡುತ್ತೆ, ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ. ನನ್ನ ಪ್ರಕಾರ ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ 492 CMP ಮ್ಯಾಟರ್ಸ್ ಸಿಗುತ್ತೆ ನಾಳೆ, ಹಂಗಾಗಿ ಆಗಲ್ಲ. 70 77 ಲಿಸ್ಟು ನಲ್ಲಿ ಬರೀ 7. ಅದೇ 12th December. ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇದೆ. ಅಲ್ಲ, ಈಗ ಫೈಲ್ ನಮ್ ಕೈಗೆ ಬಂದ್ರೆ ಬ್ರಾಂಚಿಗೆ ಕಳಿಸ್ತೀವಪ್ಪ. ಇರ್ತಾರೆ ರಾತ್ರಿ 10 ಗಂಟೆ ಆದ್ರೂ ಇರ್ತಾರೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ, ಯೋಚನೆ ಮಾಡ್ಬೇಡಿ. ಯಾವ್ದು? ಅಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ, ಇವಾಗ ಕಳಿಸ್ತೀವಿ, ಬ್ರಾಂಚಿಗೆ ಕಳಿಸ್ಬೇಕು ಅಷ್ಟೇ. ನನ್ ಕೆಲ್ಸ ಅದು, ನಾವ್ ಮಾಡ್ತೀವಿ. ಬೆಳಗ್ಗೆ ಇವಾಗ ಹೋಗಲ್ಲ, ಈಗ ಯಾರು ಹೋಗ್ತಾರೆ? ಈಗ ಯಾರು ತಗೊಂಡು ಹೋಗಲ್ಲ ಬ್ರಾಂಚ್. ಬೆಳಗ್ಗೆ 10:00ವರೆಗೆ ಕೊಡಿ. ನಿಮ್ಗೆ ಯಾವತ್ತಿಗೆ ಬೇಕು ಅವತ್ತಿಗೆ ಕೊಡ್ತೀನಿ, ಬೆಳಗ್ಗೆ ಕೊಡಿ. ಯಾಕಂದ್ರೆ ಮೆಮೊ ಎಲ್ಲ ಒಂದೇ ಸತಿ ಬೆಳಗ್ಗೆ ತಗೊಂಡು ಹೋಗ್ತಾರೆ. ಇನ್ನೇನದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಸಬ್ಮಿಷನ್ ಯಾವ್ದು? ಸೀರಿಯಲ್ ನಂಬರು ಹೋಯ್ತು, ಬ್ರಾಂಚಿಗೆ ಹೋಗಿದೆ. ಈಗ ತಾನೇ ಸರ್ ಎದ್ದೋಗಿದಾರಲ್ವಾ, ಸ್ವಲ್ಪ ಹೊತ್ತು ವೇಟ್ ಮಾಡಿ. ಮೆಮೊ ಏನ್ ಬೇಡ, ಆರ್ಡ್ರಲ್ಲೇ ಬರ್ದು ನಿಮ್ಗೆ ಹೋಗುತ್ತೆ. ಮಿಕ್ಕಿದೆಲ್ಲ 21. ಫಾಸ್ಟ್ ಓವರ್ ಎಲ್ಲ ನಾಳೆಗೆ ಹಾಕಿರಿ. ಮಂಡೆ ಸರ್ ಹೇಳುತ್ತೆ. ಇಲ್ಲಿ ಕೊಡಲ್ಲ, ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ. ಫೈಲ್ ಸೈನ್ ಆಗ್ಬೇಕು ಅವಾಗಷ್ಟೇ. ಸರ್ ಇವಾಗಷ್ಟೇ ಹೋಗಿದಾರಲ್ಲ, ಮೀಟಿಂಗ್ ಹೋಗಿರ್ತಾರೆ, ಮೀಟಿಂಗ್ ಮುಗಿಸ್ಕೊಂಡ್ಬಂದೆ ಸೈನ್ ಮಾಡೋದು. ಅಲ್ಲ ಪೋಸ್ಟಿಂಗ್ಸ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ, ನಿಮ್ಗೆ ಫೈಲ್ ಕಳಿಸ್ಬೇಕಲ್ವಾ, ನಾನು ಕಳಿಸ್ತೀನಿ ಅಷ್ಟೇ. ನಮ್ ಕೆಲ್ಸ ಏನೋ ಅದನ್ನಷ್ಟೇ ಹೇಳಿ, ಬೇರೆದೆಲ್ಲ ನಂಗೆ ಹೇಳ್ಬೇಡಿ. ನೋಡಿ ಈಗ ಲಿಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕು, ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. ಸ್ಯಾಟರ್ಡೇ ಇಲ್ಲ. ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು. ಇದು ನಾಳೆ ಅಲ್ವಾ? 21. ಅವಾಗ ಒಂದೊಂದು ರೌಂಡ್ ಬನ್ನಿ, ನಾನು ಇರ್ತೀನಿ ಇಲ್ಲೇ. ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ. ನಾನು ಇನ್ನೂ 1 hour ಮೇಲೆ ಕೆಲಸ ಇದೆ ನನಗೆ, ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ. ಅವಾಗ ಬನ್ನಿ, ಹೋಯ್ತೋ ಇಲ್ವೋ ಅಂತ ಹೇಳ್ತೀನಿ, ಆಯ್ತಾ? ಯಾವುದು? ಇಲ್ಲ 21 ವೆಡ್ನಸ್ಡೇ ಅಲ್ಲ, ಅದೆಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ತಗೋಬೇಕಷ್ಟೇ. ನಮ್ದು ಏನಿಲ್ಲಪ್ಪ, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋದು ಕರಿತೀವಿ ಬಿಟ್ರೆ ನಮ್ದು ಇನ್ನೇನು ಇಲ್ಲ. ಲಿಸ್ಟ್ ಮಾಡೋದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಲಿಸ್ಟ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಹಂಗ್ ರೀಚ್ ಆಗ್ತಾರೆ. ಅದ್ ನನಗ್ ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಸಂಬಂಧಪಡದೇ ಇರೋ ವಿಷಯ.